Hey, what's up, guys? Welcome to Lost-Planing the Interwebs. I'm your host, Nick Ricada of Ricada Law, small law firm in central Minnesota. And with me today already are Kurt, Mr. Uncivil Law. How's it going, buddy?
Doing reasonably well. How about you, sir?
I'm exhausted and tired, but I'm good. I'm good. And also, Mr. Andrew Bronca, the Law of Self-Defense.
Thanks for having me on again, Nick.
Of course. I think we may see the defense rest today.
Yeah, the defense is short and actually has things to say. The prosecution takes forever and says nothing.
Yes, and the prosecution should be ashamed of itself, and it should go flagellate.
If prosecutors were capable of feeling shame, the justice system would probably be better.
Yeah, but it doesn't do that.
No, apparently not.
It's not a thing.
No.
Oh my goodness. So
I got to rewatch that first witness yesterday because I had to do something else and watch him. And yeah, that's the first witness yesterday, the use of force expert who basically invented it. It's like, what are your citations? Me. Hey, I created it. I was like, okay. I was asked to be the leader of the SWAT team. I created that SWAT team. They're my guys. Joined this national association. I wrote the damn TASER manual. I was at the first TASER training ever. I think I've taught in all the countries. And then the prosecution over here, I think at one point they objected to lack of expertise, or basically that the guy didn't have sufficient
CV.
Yeah, well, the hearsay on the CV was also equally hilarious. That was just petty as shit. But the one I cracked up on was they at one point is like basically objected to the fact that he wasn't an expert in the area, and I'm like, he's an expert in all the areas.
Yeah, this guy's an expert in all police work. When he was born, policing was merely a concept, and he molded and crafted it out of the clay of his mind into the reality. He hired each police officer to ever work on a police force individually. He interviewed them. He determined they were not good enough and then trained them to be what they are. It's like, who is this guy? It was
44 years. If I'm doing this for free, I do all of them for free. This is the only one where I'm testifying for the police officer. The other three against, so it's like I'm not biased in that way.
Drove here in my truck.
Drove here
after open heart surgery.
Open heart surgery last week. Holy shit.
I almost expected him to say, well, I'm from Missouri, so I actually drove down to Texas and walked to Minnesota to make it more fair. It's like this guy was, he's overqualified in every way possible. He came across way better. I actually have, my editor put together a nice clip of the Weasley state's expert. Definitely not saying that they would be able to just apprehend Dante Wright at a later date.
If you do a juxtaposition of those two people just testifying side by side, like with one stopped and one playing, man, it's just brutal. Soy Boy versus Chad of Chads.
Oh, actually, since you mentioned that, and we're about to get started, let me find. Someone did this for me. I gotta see if I can find it quickly. Oh, where was it? Someone sent me a Virgin versus Chad meme.
Have you ever received any words of you? Were you in the Police Hall of Fame? Yeah.
Oh, but okay. I don't want to be, for the reason that I'm in there. That was one of my favorites. It's like
that I had to slay an enemy.
Even though he deserved it, I wish I hadn't. Okay, why is my email not opening? Oh, here it is. Where was it? Oh, come on. Bruh, this email. I'm telling you, I am barely even alive. A lot of people are asking me if I'm going to review the other interview that Thomas Binger has done. And I think I'm not going to.
Yeah, why do that to yourself?
Well, it's actually less about that because I'm happy to torture and ruin my own time. But the interview, as I went and looked at it and reviewed it and a little bit, and it's him with his friend. It's him with his best friend, and they've been best friends forever. They're not explicitly talking about the thing, and I think it would just make me way too tempted to like make fun of his friend who hasn't done anything to deserve that.
Well, he is friends with the guy.
That's true, but yeah, it's the other guy seems like just a decent chap, just trying to do his thing, and so I'm not going to do that because I don't want to sit and dump on this other guy, right? And I think it would come across that way, so I'm not super interested in doing that. If it was a media interview, yeah.
You're showing restraint. I don't understand.
Yeah. I tend to not. Yeah, like I said, that he's just a guy, right? And it's not. They barely touch on the case from what I could tell. Anyway, I don't know if I'm going to find this thing in a reasonable amount of time. I swear, it's really funny. But oh well, I'll figure out where it is and put it up later. Someone sent me a Virgin versus Chad meme, but it doesn't go the way you think. In regards to those two witnesses, it was very crafty and clever. But okay, what is this? All right, got the Fox News feed up. Do you guys expect any interesting fireworks today? I mean, Kim Potter's going to testify. Slip and Capture is going to testify. I think that's it. And then we'll see if they do closing arguments.
I mean, I just hope they have Larson on cross. That would be good.
Oh, they're probably going to fight over jury instructions.
Oh yeah, that'll be the first thing.
Yeah,
because the judge is throwing in the non-deadly force justification.
Right, and that's going to make them really salty because it basically, well, in a sane world, it nullifies their case, right?
Right. So if she was justified in using non-deadly force, then her going for the taser was justified, and her presenting the gun was a simple mistake.
Right.
Which is negligence, but not recklessness. By the way, I got some emails about this from people. They're looking at the charging document, and the second count calls for an element of culpable negligence. That's not really negligence, folks. That's just another way of saying recklessness. It's a heightened state of negligence.
Right. I read the Supreme Court's interpretation of culpable negligence early on in the trial so that people would be aware. How dare you all not have watched every second of coverage of this? And not only like every day, but every second of every day.
More than once.
The culpable negligence is defined by the Supreme Court as gross negligence with recklessness. So that's why we've been talking about recklessness this whole time, is because that's the interpretation of culpable negligence. It is above this mere I don't know, mere accident, this mere disregard of or not disregard, but failure to follow your duty or fulfill a duty that leads to damages, a breach of a duty. That's negligence. Recklessness is a conscious disregard of the risk. So,
hey, the court camera's on. Much
not
is happening.
Yeah, it's not on Fox yet. Oh, here we go.
There's a judge.
I'm bringing the screen up right now. Judge just left. She heard we were watching. She said, no, thank you. And she has left the building. Jay, I sound this way because I just woke up. My voice will wake up, and my voice will get woke in just a little bit.
Okay, thank you, Deputy.
Deputy, that usually means the jury is being brought in. They're not going to argue the jury instruction?
Not till after the witnesses, I would wager.
That's okay. I mean, I would want them. I would want to know if I'm getting that non-deadly force instruction that would influence how I question these witnesses.
Yeah. I agree. I mean, she indicated that she would be doing them.
She doesn't normally change her rulings. So
yeah,
she's basically ruled it's in. Frank is going to argue for 30 minutes about it, and then she'll say it's still in.
Yeah. Well, you see, Judge, what I think you're failing to understand here, Judge.
Larson can throw his pen across the courtroom.
Bring on the jury.
Yeah, the more Larson we get, the better for the defense.
It's weird to see some of these lawyers.
Okay, please be seated.
Like Larson and Krause that are so
Good morning,
they emote
members
so
of the
heavily.
jury. Okay, is the defense prepared to call its next witness?
Yeah, we call Dr. Lawrence Miller.
Doctor?
He invented the doctorate. So this
I
is
gotta run for now, but I'll be back later.
See you in a few.
See ya.
All right, Seth Kaiser, thanks for the rainbow. Baffled Balloon says, I'm here to
Please
grift.
come forward, Dr. Miller.
I'm here to grift and chew gum, and I'm all out of gum.
Would you please
Check out my
stand
channel for
behind the
mostly
witness chair?
even-tempered pop culture reviews and news. Thanks, Nick. Hey, check out Baffled Balloon, guys.
Raise your right hand, please. Do you swear under penalty of perjury that you will truthfully answer questions pertaining to this case?
I do.
Please have a seat.
Well, this looks like a doctor right here.
Good morning, Judge.
And you can remove your mask.
He already
You should
did.
Please state your full name and spell it.
Lawrence Miller, Laurence, Miller, Miller.
Okay. Dr. Miller, a couple things to keep in mind when you're testifying. The court reporter is taking down everything that's being said. So only one person can talk at a time. Please wait till the question is finished before you answer. And the lawyers have been instructed that they should not ask another question until you finish your answer. You have to answer with a yes or no.
Yes, Your Honor, I've done this before. 10,000 times.
If an objection is made, please
Clip and
stop
capture is
talking
apparently
immediately
very
and do not answer
controversial
the question
as
unless
a
it's
theory. So
and
we
then
should
finally, if you
expect
need
the
clarification
prosecution
of
to
the
really
question,
attack
please don't
it
hesitate.
heavily as a concept in general.
Sure.
Understand.
It's also normally used to explain away police mistakes.
Dr. Miller, how old a man are you?
Excuse me?
How old are you?
70 years old.
No, how old are you?
How am I? A little cold, but fine.
No, how old are you?
70.
It's two old
Oh,
men yelling
boy.
at each other.
Where did you fly in from to be here?
I flew in from Fort Lauderdale, Florida.
You
How
have
old
an
are you?
accent. Where
Old.
did you grow up initially?
I grew up in New York, in the New York area.
No kidding.
38 years of my life and was educated in New York.
Let's start with your education. Do you have a college degree?
Yes, I do.
What?
Tell us about that.
Well, I have a bachelor's degree from Queens College of the City University of New York.
What was the major?
Psychology.
Cooney, we call that.
Go on to an advanced degree beyond a BA.
Beyond the BA, I obtained a master's degree from that same college in neuroscience and experimental neurophysiology.
What year was that, if you recall?
That was 1978.
Did you go further beyond your master's degree to get a PhD?
Yes, I obtained my PhD from City College of the City University of New York in 1988.
What was your emphasis for your PhD?
Clinical neuropsychology.
What was the title of your thesis?
I did my dissertation on neuropsychological functioning, brain functioning in psychopaths.
Are you a psychologist?
Yes.
What does a psychologist do?
Psychologist is a doctoral level professional who specializes in the evaluation and treatment of mental disorders, and in some cases, mental disorders caused by problems in brain functioning and neuropsychological impairment.
And how long have you been in the practice of being a psychologist?
Well, I've been licensed as a psychologist in independent practice since 1990 as a trainee, probably 6 to 8 years prior to that.
Do you have specialties in your practice as a psychologist?
That's correct.
What do you have specialties?
Yes.
Tell us what they are.
Well, one specialty is clinical psychology, which is what most people think of psychologists doing, which is evaluating and treating patients for various problems, family matters, adults, children.
Are you also a forensic psychologist?
That's correct. The forensic psychology aspect deals with matters of psychology as applied to law, civil cases involving personal injury, workers' compensation cases, criminal law in terms of evaluation for
Jordan Peterson,
insanity defenses, prediction of dangerousness, and so on.
Tell me about lobsters.
Do you also practice neuropsychology?
Neuropsychology is the direct application of brain science to behavioral disorders, and it ranges everything from dealing with children with learning disorders all the way up through older folks with various types of dementia.
Do you also practice in the area of police psychology?
Well, police psychology is kind of a hybrid specialty between organizational psychology, clinical psychology, and forensic psychology. And there you apply behavioral science to various aspects of law enforcement. It's kind of broad. It can deal with anything from hostage negotiation, de-escalation training, stress management, but also dealing with officer-involved shootings and the psychological factors that can both influence a shooting incident and the effects of that shooting on everyone concerned.
How long have you practiced police psychology?
Approximately 20 to 25 years.
In the course of your career, have you published?
Yes.
How many books have you written?
I think it's about 12 at this point.
Showing you the practical police psychology. Is this one of your books, Professor?
Yes, it is.
Doctor? What's this book about?
That basically instructs officers on managing their stress related to the profession of policing, but also in crisis management, dealing with various types of crisis situations, and specifically ways of de-escalating in order to avoid use of force. Also dealing with such topics as police officer suicide, critical incident stress, hostage negotiation, and other special unit policing.
This was recently published.
Excuse me?
This was recently published.
That book goes back to 2006.
Okay. How about this one? Psychology of Police Deadly Force Encounter. Did you
they
write
brought
this?
all the books.
Yes.
They brought Amazon.
That was, I believe, published in 2020, and that deals more in a more focused way with the psychology of police shootings themselves.
How many books, in addition to this, have you written? I may have asked, but I want to ask again.
I think 10 other books on various topics.
Question.
Have you also
Objection asked
published
and answered.
articles in professional and peer-reviewed journals?
Just want to make sure I got it right.
What's a peer-reviewed journal, by the way?
A peer-reviewed article is an article that has been evaluated by one's professional peers. In other words, it's evaluated for its adherence to scientific principles, its coverage of the literature, and its credibility as it relates to other aspects of the field.
Have you also published articles in non-peer review magazines and journals?
Well, I like to write for both a professional audience, but I think psychology needs to be known outside the field. So I do try to write for a popular audience. I've written online articles, magazine articles, and so on.
Have you taught as well?
Yes.
Where are you teaching now?
Well, currently I'm teaching at Florida Atlantic University.
What courses are you
Bought a
teaching?
bunch of my books.
I teach a course in clinical psychology, a course in neuropsychology, a course in psychology and law, and a course in police psychology.
Are you a full-time professor there or an adjunct?
I'm an adjunct.
Okay. And in your working life, what else do you do besides teach them? Practice, engage in your practice as a psychologist?
I have my clinical practice. I have my forensic work where I work with the various civil and criminal courts in various types of cases, brain injury cases, criminal cases, personal injury cases. I also on occasion conduct seminars for various groups, and these can be criminal justice people or mental health people on various topics relating to psychology and the law. And then I have my special cases that I do, which is what brings me here today.
Okay. We could go for another hour on all the articles you've written, but they are included in your CV.
Been practicing psychology longer than Stoughton's been alive.
Yes.
Author 1000.
1,000.
Yes, Your Honor, hearsay.
Okay.
The objection is overruled and the exhibit will be received into evidence.
What is their theory on the hearsay objection for
Now,
the things that
you were
these
approached by
witnesses
the
have written?
defense to
I guess they're out of court
assist us in
statements.
certain
There are things he didn't testify to that are in his CV, right? They didn't read the whole
retain
CV.
you,
Yeah.
to assist us.
Yes.
How much did you charge us?
My flat fee for my total involvement in this case was $30,000.
Okay, and that
Whoa.
includes interviews with
Hiker.
the defense, review of the interviews with others, the review of the file,
Well-
writing a report, coming here today.
It includes everything that I've done for this case, from the beginning consultation with the attorneys through reviewing records, clinical interviews of relevant personnel, producing a written report, consultations with the attorneys, preparing for testimony, and of course, getting on the plane and coming here today.
That's going to
And is it
include
your
probably
practice
his
to
travel
charge
and
flat
expenses
fees?
then.
Is that what you've established in terms of your fee schedule?
Different experts do it in different ways. Some like to charge by the hour and submit a very detailed invoice for time spent and materials used. I've been, doing forensic psychology in one form or another for about a quarter of a century, and I found it simply more efficient to sort of prorate what a typical case will involve, the number of hours it typically takes, and then just
That's what I do.
base a flat fee on that instead of submitting a 20-page itemized invoice.
Yeah, billing
I wanna
is
ask
the
you
worst.
about some
In all
topics, and then we'll get
fields.
to action errors and slip and capture in a moment. But let's start with how skills and knowledge is learned, how memories are formed. Can you help us with that? What are the stages of learning and memory?
We like to believe that we're always in control of our actions, but most of what we do on a daily basis really occurs on an automatic level. And in fact, we couldn't function if that weren't the case. Think about everything you simply did today just to prepare to come here, all the little actions you took in preparations in the morning. If you had to think and deliberate about each thing you did, you trip over your own mental feet.
We all know people
Much
like
of what
that.
we do, both in personal life and in terms of the skills we perform, whatever those skills are in a profession we may have, is something that achieves a certain automaticity. We sort of go on automatic. Think about driving a car. The first time you learn to drive a car, it seemed like an impossible task.
I use
Now,
this example
literally
every class.
on just an unconscious basis, and think about other things, talk to people in the car, and so on. And so in order for that to happen, that information has to get into your brain.
Is there a term in your field called input?
Well, one of the stages of memory is input. In other words, you have to be able to pay attention to something sufficiently for it to get into the brain in the first place. If you're not attending to it, if you don't see it or hear it or perceive it, then you're not going to be able to recall it later, not because you can't recall it, but because it didn't get there in the first place.
Is there another term in your field called consolidation?
The interesting thing about the way the brain processes memory is it's an ongoing process. What we're speaking about now is still in the process of being formatted. And if something were to happen to interrupt that process, you may not recall what I said a few seconds ago. But as time proceeds, structures in the brain format that memory and they begin to place it in different relevant storage areas in the brain. And this is something that goes on and on and on, literally throughout your life. Every time you encounter something that's similar to a previous memory, it interlinks with that, it forms synapses. And so what you get is this kind of holistic gestalt of knowledge that you call upon when you need it.
And what
Obviously, his first time on the witness stand.
You've talked about input, consolidation, storing the memories. How are they retrieved?
All the storage in the world is not going to do much good if you can't get the memory when you want it. And it's quite amazing, if I were to ask you some specific questions, how you could come up with the answer almost instantaneously, considering the billions of bits of information that you have. So there are structures in the brain that then go back, search the memory, and pick out those specific instances that you want to recall, whether it's knowledge memory in terms of a topic that you want to expound about, or if it's a skill that has to be done quickly, efficiently, instantaneously, without thinking. And again, that's why most of what people do on a skilled basis, they do on an automatic level and use the other parts of their brain when an unusual circumstance presents itself.
Is there a term that you've come to know in your field called multiple representation?
What the hell is? What the hell
Nick,
was that?
What did you do? You pressed the pink button?
And we say storage in the brain. It's not like there's a certain file cabinet for each individual memory.
That's the feed.
The Care 11 feed is working for me.
All right. Let's see. Care 11, Care 11, Care 11, Care 11. Damn it. Sorry, guys.
Information is being updated, annotated. Information that comes in has to integrate itself with information that's been in your brain for the longest amount of time.
All right, let me ask you this then. Consistent with the way memories are formed, do certain skills and behaviors that we have become more practiced and thus more automatic?
Right. The more you do something, especially if it's the same kind of thing over and over and over again, the less you have to consciously think about it. And again, nature builds that into our brains because that enables us to have efficiency of operation. Imagine having to think about everything you did. Most of what you do, especially if it's the same routine on a regular basis, are things that you do automatically because that's how the brain wants you to work.
Just a great commonsensical way of describing all these otherwise complicated concepts.
System 1 and System 2.
This was a concept that was developed by a cognitive psychologist named Kahneman to basically describe what's part of a larger process. Again, it's what I was saying before. System 1 is a kind of code that's used to refer to the kind of automatic, instantaneous, not thinking about it, shooting from the hip, all the phrases we use to describe things that we do that don't take any real degree of conscious deliberation.
Let's not talk about shoot from the hip.
That is by utilizing System 1. Remember, we're rarely born learning, knowing most things. We have to learn them. The way we learn them is by practice. The more practice you do, the better you get at it. The better you get at it, the more automatic it becomes. And so I don't want to think of System 1 and System 2 as like two totally separate things. It's kind of an interaction. And the more different ways you now apply this new skill, and the more different circumstances and experience you get with those circumstances, the more integrated that knowledge becomes, and the more likely it is to be called upon in a situation where you have to think fast and act fast.
Well, you've described System 1. How about System 2?
And that's the thinking, more deliberative, more slow processing part of the brain. Typically, we reserve those aspects of thinking for things that are unusual, atypical, less well learned, less well practiced, and less automatic. So just to use driving as an example, if you're driving down the road and it's a route you've taken before and you're not thinking about it, and suddenly the road is closed or a car cuts you off, now you've got to focus on something different. You've got to engage your conscious deliberative process and figure out what to do in that novel situation. And that takes a little more time. And in most cases, it's done successfully. But there may be circumstances where if the focus is so intense and the stress factor is so intense that that System 2 type of thinking may become hijacked and superseded by the System 1 thinking that has been in operation for the longer period of time.
Well, did they usually work in coordination, the two systems, 1 and 2?
I'm sorry, could you
Did
repeat
they
the
usually
question?
work in coordination with each other, the Systems 1 and 2?
Yeah, I mean, we're doing this right now. I mean, you're paying attention, you're writing things down, you're listening. The court reporter is typing. These are things that you've all been trained to do and done thousands and millions of times before. What's novel is what we're talking about. These may be new topics. It may be a new environment. So that, the brain says, use your frontal lobe cortical thinking part of your brain for the things that you need to think about. And the things that you don't need to think about, like how to write something down on a pad or, how to use a particular device. Those are the things that are done on that automatic system one level.
My brain better not tell me what to do.
And
That
as
asshole.
the skill becomes for a person becomes more integrated and automatic, is there a gradual transfer from system one to system two?
Well, that's the whole point. It's a gradual transfer. So, at any given time, there are certain things that are completely automatic. There are some things that are sort of in between, and there are some things that are relatively novel. And that, pretty much describes the situations that we encounter in life.
In the brain imaging studies that you've worked with and studied, have you found in the literature that the brain actually uses less energy with respect to more skilled in practice and automatic,
MRI, folks.
as opposed to system one and system two, I should say?
It's counterintuitive because you think as the brain becomes more skilled, it would be, use more energy, but it's just the opposite. As you become more skilled at a task, fewer parts of the brain have to chip in and contribute to that task. It's very similar to, again, the car example. The first time you learned to drive a car, it was all systems on deck. You had to think about it. You had to use your vision, your audition, your every sense to try to figure out how to work that machine. And what happened was over time, it became so automatic that the driving program under ordinary circumstances is now overlearned and routine. And the brain no longer has to work as hard to perform these skilled activities as it did when you first learned it. And again, that's what the brain wants to do. It doesn't want to waste any energy. Just keep the simple things simple.
If this guy drove from Florida to Minnesota after a colonoscopy, I'm going to lose it.
Unusual and more challenging.
Would that apply, for example, in playing a musical instrument?
I'm sorry, what?
Would it apply, for example, in playing a musical instrument?
Stop yelling at me.
I mean,
It's like talking to your old
musicians in the room
grandpa.
today, they understand that the first couple of times you tried to play something, you wondered, how could anybody do this? Now, maybe a couple of years later in your practice, and it seems like what we call second nature. Well, it's not nature. You practiced, you became good at it. It became more automatic. And just think about anything you do in life that's in that category. We do so many things automatically because that's how our brains have trained us to do it.
Would a surgeon completing surgery be another example of that?
Yeah, I mean, this is very important and very complex skills. Where this often comes up in skills such as aviation, surgery, medical skills. It's very important that if a surgeon is performing, hundreds and hundreds of operations of the same type, that some aspects of that operation are going to be routine. But what the surgeon is focusing on are those unusual aspects of a particular procedure that may cause him to zero in more with that system two thinking and try to figure out what to do in a more deliberative, conscious, reasoning kind of way. But the only reason he's able to, or she is able to do that, is because other aspects of the procedure have been overlearned, have been well practiced, and don't require that intensive type of concentration.
Can the same thing occur with firearms training, for example?
Firearms training is a specialized skill in law enforcement. One of the reasons that we want all professionals, whether it's police officers, paramedics, firefighters, EMTs, to practice is because we want most of the things to be automatic. And in fact, if you speak to officers who have been involved in officer-involved shooting, many times what they'll say is,
The objection is sustained.
Okay. Well, stay with what other officers have told you. I just wondered if it happens in firearms training as well. Fair
yes,
enough?
it does.
Okay. What's
Was that a
muscle
hearsay
memory?
objection?
Well, it's an interesting term because your
That's so.
muscles really don't remember anything. The only way your
Maybe it's
muscles
beyond the
know
scope of
anything
his
is
report.
what the brain tells it.
Maybe.
Your muscles are hooked up to nerve fibers, which in turn are hooked up to neurons in the spinal cord, which get their direction from cells in the brain. So the brain tells the spinal cord to tell the muscles what to do. The learning part of that process is what happens in the brain. And then when the brain becomes more efficient at a task, it tells your spinal cord to tell those particular combinations of hundreds, if not thousands of muscles, how to behave in a given circumstance, whether it's driving a car or practicing on a firing range.
What happens in the brain when a person learns a new skill, and how that new skill interacts with the old skill already learned?
Well, one of the cognitive psychologists will tell you that one of the principles of memory is last hired, first fired. In other words, the brain does not forget anything. If you learn something new, especially if it's different from, in some respects, similar to, but in other respects, different from the old knowledge, what happens is the old memory, the old skills, they become overwritten. And so in most circumstances, after a while, you become more proficient in using the new program, the new skill. But there are circumstances under which the old skill, remember, it's there in the background, that may become what we call prepotent. Prepotent simply means most likely to occur under certain circumstances, and it may overwhelm the training that occurred more recently with the new skill.
Well, this brings us to a term in psychology called the action error. You're familiar with that term?
Yes.
Would you explain to the jury what an action error is?
An action error is a sequence of responses in which an intended action has an unintended effect, especially where this does not have to do with outside interference, willful neglect, or conscious manipulation. Plain language, you intend to do one thing, think you're doing that thing, but do something else, and only realize later that the action that you intended was not the one you took.
Well, are these action errors unusual in our lives?
They occur all the time.
Could you give us some examples?
Well, I mean, action errors occur all the time. Simple examples are the first couple of weeks of the new year. Many of us will write the previous year on a check or on the top of a paper.
This guy's
we know
still
it's a
writing
different year. We
checks.
know it's 21 and not 2020. But if we're distracted or we're thinking about something else, that old memory comes back. Other examples include if you're in a traffic circumstance and a car cuts you off. How many times has this happened where you impulsively and instinctively slam on the brake, even though stopping may not be the proper thing to do if you have time to think about it, but that's an overlearned response. You've braked and braked and braked so many times. That's what comes to the fore. And I'm sure, we can all think of a plethora of examples in our own lives where this has happened. And again, typically they're trivial and we laugh to ourselves and we say, how could I do that? How could I be so silly? That was a silly mistake. Well, it wasn't silly. It was that old action program coming back for that moment because your attention was distracted while you were intending to do something else.
Well, another example would be password confusion. You change your password and you use your old password, for example.
Well, we've all gone through that. Somebody hacks your account and you have to change your password. And most of the time you remember the new password. But if you're thinking about something that's extraneous and instinctively you plug in the old password and the only thing that lets you know it was wrong is the little error message comes up. And then you go, oh, that's right. I changed the password.
There are examples, though, of action errors that occur that are far more serious than what you've just described.
Well, if we're only limited to passwords and checks, we probably wouldn't be having this conversation, and it wouldn't have been such an intensive area of study for almost the past 40 or 50 years.
Well, give us some examples of action errors that have been harmful.
Action errors can occur in medicine, where if a medical personnel are being trained on a new procedure, and they are trained just to the point of criteria. In other words, they know how to pass the test and get certified in using that procedure, but they've been using a different procedure for several years prior. And then a circumstance occurs where it's a high critical circumstance. It's one of these emergency room situations. The brain may default to the old program. And these have actually happened. And the medical community takes a very active interest in studying this because obviously the goal is to prevent this from happening.
But yet it does.
It does occasionally, yes.
And how about in the fields of military, nuclear energy, aviation? Does it happen in those areas as well? And if so, how?
Probably the industry with the largest record of studying action errors is the aviation industry. Because here, if a mistake is made, we can only imagine the tragic consequences. And there have been circumstances where in a cockpit, personnel who have been trained in a procedure or in a particular type of aircraft, and they've flown this aircraft maybe dozens of times, but have flown previous aircraft hundreds of times, or maybe even thousands of hours of flight in a very high stress circumstance, which involves the safety of everybody aboard that plane. They will reflexively default to the previous action pattern. And it's an error because that causes the plane to lose an engine and in some cases to crash.
During an action error, I think you touched on this, as the individual involved realize that the error is taking place at the time it's taking place.
I'm sorry, could you repeat that, please?
When an action error occurs, does the individual who commits the action error understand that the action error is taking place when it does?
Well, that's what makes it an error. During the action itself, the person thinks that they are performing one action when they're performing something else. They typically, what happens is when the intended result does not occur, they realize the action was an incorrect one. But while they're doing it, they think they're doing thing one while they're doing thing two.
What are the critical factors in the literature that contribute to action errors?
You know, again, as they've been studied in aviation, in medicine, the nuclear power industry is another active area where this is studied. There are three main factors, and that is hyperarousal. The person is under.
What's that mean?
That means the person is under an extreme degree of stress. But what's interesting, it's not the arousal itself necessarily that causes the action error. It's the other two factors that are associated with it. Like hyper distractibility, hyper focus. When you are in an extremely emotional state, you zero in on the thing that seems to be most dangerous, most critical. And because you're zeroing in on one particular aspect of that situation, the thing that is causing in your mind the greatest peril and danger, you're tuning out everything else. So you've got hyper focus caused by this hyper arousal. And of course, what that means is you get the third factor, which is a distraction of attention. Because you're zeroed in, you're tuning out everything else. And if you look at almost all of the action errors that occur, especially the ones that have been studied, and they've been studied because they've had a tragic outcome, it's these three main factors in various combinations that are responsible for the unfortunate event that occurs.
Hyperarousal is what happens when the chat sees the
When you
judge.
talk about the factors, is there a relationship between system 1 and system 2 thinking that is involved in those reactions too?
I'm sorry, could you?
Is there a relationship between system 1 and system 2 thinking, as you've described it, with what you've just described as the critical factors?
So again, when you're performing any skill, you're operating mostly on your system 1 thinking. Most things are automatic, most things are routine, and you're keeping system 2 in reserve just in case something unusual happens and you have to sort of tune in and concentrate a little bit harder. And that's how it works. You know, when you're driving a car, flying a plane, performing surgery, there are going to be some aspects of it that are very routine and common. And there are a couple of things that you need to use your brain on. You have to change a route or stop because a car stops in front of you. But if it's a high stress circumstance, extremely high arousal, what happens is that system 2 then gets knocked offline. It's not there to overcorrect for the previous system 1 action error, the previous overlearned response, which used to be the right response, might have saved your life in the old situation, but now in fact is superseding the more newly learned response. And that's what's taking something that ordinarily would have saved your life. Now it's putting your life in danger.
There's a phrase that I read in your books. It's not the object, it's the action.
Well, a lot of times, you know, people say, how could you not know the difference between this particular object or that particular object? And in the example that you raised before, in firearms, how could you not know the difference between, let's say, what a flashlight or a baton or a taser looks like and a firearm? And these are all objects that have been confused with a firearm in various cases. So the point is, it's not the object, meaning there's nothing wrong with that person's perception. If you put the two objects in front of them, they can easily tell the difference. But the perception isn't working. It's offline. The program is not running because the previously learned response says this is what you do in an emergency situation. This is what you've been trained far more times than the new learning. And that's what becomes what we call the prepotent response.
Is there another phrase from your literature that it, quote, it's not the action, it's the outcome?
Yeah, you know, when something, you know, I'm explaining a very common psychological process that we've all gone through, we can all relate to. But almost in every case, fortunately, they don't lead to a tragic outcome. But what makes an action error, the critical ones, the ones we pay attention to, the aviation accidents, the surgical mishaps, or the law enforcement cases, is that there occurs a tipping point where the action that is taken, the prepotent action, happens to be one that can have a lethal outcome, whether it's pressing the wrong lever or moving the switch in the wrong direction on an airplane, whether it's using the wrong instrument or the wrong medication dose in a hospital, or drawing the wrong weapon in an officer-involved shooting circumstance.
Let's go then to what can contribute to action errors in police work. And one of the topics in your literature and your writing that is discussed is what's called an optimum arousal level. Are you familiar with that term?
Yes.
Tell us about that.
All right. So that's not a term that I invented. This goes back.
But you've referenced it in your books. Okay, go ahead.
In order to do anything well, you have to be in a certain zone of arousal. In other words, you can't be too laid back and chill and uninterested, because you're not going to have the motivation to do that skill well, whatever that skill happens to be. So you have to be a little bit pumped up, a little bit enthusiastic, a little bit motivated to do it. What happens is, as that arousal increases to the point where it starts becoming fear or agitation or panic, then you have the opposite effect. Then it begins to degrade your performance. Again, we've all experienced situations where we've been motivated to do something, but maybe the pressure is on, and we talk about sometimes choking under pressure, or doing the wrong thing because we just got too hyped up. And so as long as we're in that range, and that range could be fairly wide, we do well. So typically what happens is, when you have something like an action error occurring, it's occurring because that person has gone beyond, they have exceeded the optimum level of arousal for that particular task, so that higher levels of arousal no longer help, but now begin to hurt efficiency in performing that task.
Okay.
Joke
And
about
that
choking
includes
under
such factors
pressure and
as
Scott
hyperfocus,
Peterson.
tunnel vision.
Well, hyperfocus, hyperarousal is what we mean by being outside that zone. And hyperfocus and distraction of attention are the main factors that being out of that zone tend to produce.
In your 25 years of experience with working with police psychology, have you studied critical incidences, shootings, that sort of thing?
Yes.
And you've worked with officers who've been involved in such incidents, have you not?
That's right.
And many of them involve deadly force.
Some of them, yes.
Okay.
Choking during hyperarousal. Wasn't that David Carradine? The real question, guys, is how he's going to hold up on cross.
Yeah.
You know, a witness like this is
So
going
what
to
are
be
the-
great on direct. It's always cross on these things.
Factors that would contribute to an action error in a law enforcement setting.
Well, in any situation that involves an extreme degree of stress, which usually means a threat to life, we mean by a critical incident. We mean an incident where there is some credible threat to the safety or life of a police officer, of a citizen, of bystanders, and that requires an immediate response. Critical incidents don't only occur in law enforcement; they occur in medical, emergency room settings. They occur in firefighting and first responders. But here we're applying critical incidents to law enforcement, and in those cases, the factors usually involve an extremely compressed time frame. The person has to act very quickly, sometimes instantaneously. There is that high threat to life and safety. Often there are confusing and changing circumstances. The circumstances may be ambiguous. You're in a scene and you're not quite sure what's going on, and what's going on may change from second to second. And put all these things together, and this creates a high state of arousal and agitation. And that is exactly the kind of perfect storm for the production of an action error.
We've heard about the term weapon confusion. Are you familiar with that term?
Yes.
Okay. Is weapon confusion a form of an action error?
Well, weapon confusion is a subset of action error that applies to a specific law enforcement circumstance where...
Is there a particular term for it that you know?
Well, the term that's been used for it is something called a slip and capture error.
Explain what slip is and what capture is then.
That term was coined by a police psychologist and refers to the fact that under these states that are conducive to action errors, these states of high arousal, hyperfocus, and impaired attention, the ability of system one to pick out the correct response slips away, and the actual performance, the actual behavior is captured by the older, more well-entrenched, more baked-in knowledge program that
Meant system
person
two
was
there.
hanging around long before the newer, and in this case, what would have been the more appropriate program has a chance to engage.
Has that process happened in the literature in the arena of weapon confusion?
That's right.
Confusing, say, a taser for a gun.
That's the most typical example of what's meant by weapon confusion shooting.
Oh, does he have data on it? It would be great. I don't know if he does, but it'd
Now,
be
when
great
you're
if he
talking
had
about
some
action
data on
errors,
it.
before we got to slip and capture, you were talking about critical states and circumstances that would likely cause an action error in terms of police conduct. Is that correct?
Yes.
Okay. Or are there other factors that might well contribute to an action error when a police officer confronts an individual?
Well, we already know that action errors are more likely to occur under states of hyperarousal, hyperfocus, and distraction of attention. And we know that in critical incidents, you do have many of these factors occurring. Officers will typically report hyperfocus in the form of what's called tunnel vision. They're zeroed in on one aspect, usually the most dangerous aspect of a circumstance, and will tune out other goings on and other things in the surrounding. They're under extreme time pressure. They're under circumstances that are confused and changing. And so so what might be the types of circumstances that would produce that kind of high-wired psychological state in a police officer? And these are, police officers deal with citizens on a daily basis. In any given day, there are hundreds of thousands of police-citizen contacts, most of which are uneventful. The ones that do qualify as critical incidents usually involve situations where police officers have reason to believe there's a high danger level. And those are the ones that we're talking about.
How about whether or not the subject is intoxicated?
Well, things like a subject may be intoxicated, a subject may be mentally impaired, subject does not respond in the usual way that you'd expect a citizen to respond to a police officer, such as obeying a lawful command. If an attempt is made to arrest the suspect or the subject, the citizen may resist. Of course, if the citizen becomes violent or tries to flee the encounter or does anything that could potentially put the officers or other citizens in danger, and especially if you have a combination of these factors, that's more likely to produce these states of hyperfocus, tunnel vision, hyperarousal, distraction of attention, which in turn, if an action error is going to occur, that's the proper recipe for something like that to happen.
In traffic stops, or in the police work that you've studied and experienced in your 25 years, are there certain risk factors that may also contribute to an action error?
And these are just a special example of the risk factors that we mentioned above. One of the most dangerous things about a traffic stop is you don't know who's in the car. It's the factor of the unknown. And so, people often wonder why, if there's a traffic stop, do you need so many police officers responding? Well, we all know.
The objection is sustained for lack of foundation. You may lay additional foundation.
Sure. Have you studied in your 25 years the risk factors, for example, that may contribute to an action error in a traffic stop?
Yes.
I mean, you've done hundreds of interviews of police officers, which we can't talk about, obviously, but you have interviewed a lot of police officers who've been in these kind of things, I mean, in traffic stops. Is that correct?
Well, I mean, not all of the officers I've worked with have been in traffic stops specifically, but yes, a fair number of them have.
Yeah, you've seen hundreds of videotapes over the course of your career, and you've reviewed the literature of the stressors involved, have you not?
Yes.
Okay. So what are some of the risk stops, the factors that
Got to do the work, got to lay the foundation.
Traffic stop?
Well, very similar to what we described above. I mean, the subject may not respond to lawful commands. You don't know the occupants of the vehicle. If in fact you discover that there may be outstanding warrants or the vehicle may have been stolen, or other factors that lead one to believe that this person may show resistance, in some case violence resistance. These are all factors that sort of build up cumulatively in the first responder's mind. And the reason is because first responders know that there have been circumstances where this has led to the death or injury of police officers and other citizens. And so the radar is likely to be on high alert in these circumstances. And then what often happens is if you analyze many of these cases, you look at the videos, you interview the officers, what you see is a tipping point.
What do you mean by tipping point?
At some point, a subject resists a command, resists arrest, does something which, if only that thing hadn't been done, the situation may have ended with an arrest or even with a, have a nice day. But for whatever reason, somebody went somewhere, a word was exchanged here, an elbow went there, and a tragic result occurred. And, it's disconcerting when that happens, because when you go back and you look at this and you run the scenarios in retrospect, you realize how many different ways these things could have turned out.
Okay. So it's a combination of all the factors that you've talked about.
Well, that's exactly it. We're talking about cumulative factors. There's no one thing that causes an action error. You have a set of circumstances that creates a certain emotional climate and a sense of danger. Then you have actions that are done by the citizen, actions that are done by the police. And if those sort of align in a particular way, then you have what we call the unfortunately rare occurrence of an action error that causes a tragic outcome.
I wish you would have said
One of the-
unfortunately rare.
One of the factors that you've studied in the aftermath of such an error has to do with the police officer's memory of it. Would that be fair?
Yes.
And what have you studied in that regard?
Many police officers are themselves surprised that they don't recall certain aspects of what went on in the scene itself. Sometimes when they're questioned by authorities, do you recall what happened? The officer will say, I don't recall, or I have a spotty memory. And that relates to what we talked about earlier about the different stages of memory: input, consolidation, storage, and retrieval. Most of the time, and again, it's not just police officers. If anybody here has ever been involved in a very frightening experience and lived to tell about it, there may be some aspects of it, and you look back and you say, I don't know how I got out of that car, or I don't know how I evaded that truck that was about to hit me, but somehow, next thing I knew, I was on the side of the road and I was okay. And that's because it's not a matter of not retrieving the information. Remember, the information didn't get in the first place. You were focused on something else. The officer was focused on surviving that encounter, and not only surviving that encounter, but
By the way, I've put hundreds of people
the
through
survival
self-defense
of
simulators,
on the
and
scene.
they have the same
So the reason
experience,
you
even
can't
though there's
recall it,
zero actual
that
threat.
officer can't recall it.
Yep.
Is he or she, it didn't get into his or her brain in the first place. And if it did, it didn't have time to be consolidated by this memory formatting process in order to be stored in a way that could later be recalled.
Well, it's like that
What's a
the
flashbulb memory?
basketball
Is that in connection
passing
with what
video.
you just described?
Again, the paradox is where some memories may be missing or distorted, other memories may be acutely, the officer may be acutely aware of them. And again, these are typically memories for those specific aspects that presented the danger. Sometimes this is called weapon focus effect. It doesn't happen to just to police officers. Crime victims, well, when asked to identify an assailant, will say, I don't even know what the guy's face looked like. I wasn't looking at his face. I was looking at the knife or the gun or the weapon that they were pointed at me. So again, the point is, what we're describing in the case of police officers is simply a special application of cognitive processes that occur in all emergency situations, except in all emergency situations, you're not dealing with first responders who are charged with a very special task of protecting life and safety.
So in sum, it would be fair to say that action errors do exist, have been studied in the literature, and a subsection of an action error is a slip and capture error. Fair enough?
That would be a fair statement, yes.
Okay. And that's what you just described to us.
Yes, it is.
No further questions.
Here we go.
Counsel, you may cross.
Pretty quick, about 40 minutes. Welcome to the show, Legal Mindset. How's it going, buddy?
Good to see you guys. Good to see you guys. I was told, Bronca, I was told to, at one point when I was asking my audience what to review, they said I should review your interview with Megyn Kelly.
Oh, from yesterday?
Yeah, that
I actually don't remember the interview. I mean, I
Before
remember
you-
doing it, but I was so eager to get back to this show that I don't even remember
Thank
what I
you.
talked about.
High stress situation,
Weather is
apparently.
treating you okay thus far?
When I can move, yes.
So I want to talk a little bit about some of the questions you were asked on direct, a little bit about your experience. I know
Her shirt makes me
a number of
dizzy.
articles.
Oh, yeah.
Gone through a lot of school.
It's like one of those pictures where
but
if you
talked
stare
about
at it,
one of
you'll
the
actually see the
areas
image.
of
It's a Rorschach.
expertise you've developed is as a police psychologist. Is that right?
Yes.
And police psychology as a specialty, that wasn't recognized by the American Psychological Association until 2013, right?
8 years ago.
As it happens, it is. There is actually a special section of the American Psychological Association called Police and Public Safety Psychology. It's called the section. The APA, American Psychological Association, has I don't know how many different sections, but that is now one of them.
And that's a recent change as of 2013.
I don't recall the date, but I'll accept that.
But in any case, the work that you do in terms of the way that you make your income, it's primarily on behalf of police and police entities, right?
I'm just going to ask you to speak up just a little bit, please.
You work primarily with police officers and police departments,
Well, that's one aspect of my practice. That's not my entire clinical practice.
but a lot of your consulting and the work that you do that generates income is for police departments and police officers, right?
Some of it, yes.
And are you still working closely with law enforcement in your local area?
Yes.
And that includes West Palm Beach Police Department, the Palm Beach County Sheriff's Office. Is that right?
Those are the two main agencies that I work with on a regular basis.
But you've also worked with national police organizations, other types of police forum venues, if you will.
Well, I do consulting, expert witnessing, and a lot of training with many of these other agencies around the country.
And you're also affiliated with Police One, correct?
Police One, the website, yes, I have a webpage on that.
And that website, that's a site for the law enforcement community, right?
For the law enforcement community and also other professionals who work with law enforcement.
So they have a lot of articles and resources for police officers on that site, right?
That's right.
And some law enforcement only content as well. Fair?
I'm sorry, some what content?
If you're a member, you can log in and get some law enforcement only content, correct?
I think that's right, yes.
Premium.
You're identified on their website as a police columnist, as well as all of the other things you do, right?
Yes,
You've written a number of articles for Police One over the years, correct?
that's right.
And many of them are listed in your pretty voluminous CV, right?
That's right.
And you spent
Now it's a problem. The CV is too long.
5 years or
Yep.
so of your career working with law enforcement.
That's right.
And you also mentioned that you testify as part of your consulting work on behalf of police officers, right?
That's one of the things I do, yes.
And that's primarily who you testify for police officers, police departments.
What do you mean by for?
In terms of what you mentioned, civil and maybe criminal litigation, typically when you're offering testimony or you're consulting, that's on behalf of the police officer or in a criminal case, the defendant, right?
In most of those cases, yes.
Now this is a problem
And
too.
I know you said
Completely,
it's not the only thing
you
that
know,
you do, but
their
that's a
witness
big income
It's
generator.
entirely
right?
against
It's
police.
one of them, yes.
And for this case, you were paid, you said $30,000 for your work. Is that right?
That's right.
And that you described involving today's testimony, but also an interview with the defendant, Ms. Potter, correct?
Yes.
And you said that there was also a review of records, right?
Yes.
That was part of your review. But you didn't review the whole file in this case, correct?
The entire file, no.
You, in your report, identified the materials you reviewed, correct?
Well, I reviewed somewhat more than those materials. Those in my report are the ones I felt were most relevant to be formulating my opinion.
Okay. And in your report, you identified, I think, 3 documents and 1 composite video clip. Is that right?
Yes.
You didn't review any training materials in this case, correct?
I did review some training materials, but I did not put those in my report.
Well, you didn't review any department policies.
I don't have the entire file with me, which is, a big stack, but I do recall reviewing training records, training materials, SOPs, other documents, transcripts of other witness statements, and a wide variety of things that didn't all work their way into my report. Otherwise, it would have been a 100-page report.
Well, in your report, you included just a few of those materials, right? Including the transcript of a statement by Officer Lucky, the summary of video recordings.
It's almost
the
like you
complaint, and I
review
believe
things
the
and then
composite
you
video,
only
correct?
include the
Yes.
relevant things which you
and then
reviewed.
a lot of your report is dedicated to your commentary on your interview with the defendant, Ms. Potter. Is that right?
Yes.
Fair to say that the majority of the information that you got came directly from the defendant, Ms. Potter.
Well,
right?
yes, she was the focus of this case.
I'm going to talk a little bit about that interview with the defendant a little bit later, but let's get back to some of the work that you do more broadly. You talked about System 1 and System 2 processes as part of sort of those psychological components when it comes to how our brains work, right?
Well, that's the way I'm conceptualizing this case for the jury, yes.
And you talked about how things that are learned early on become sort of regular, sort of automatic type of behaviors, correct?
Yes.
And that would include things that we would learn, at childhood, for instance. Fair?
Well, I mean, some of these things go back to childhood, but we also do quite a bit amount of learning as adults.
Sure. We continue to learn as we grow older. Is that fair?
Yes.
But things like learning left from right, that's something that's done at an early age, right?
Yeah. Yes. Hopefully.
Not
yes.
for you.
Getting back to some of the training that you do, I think you talked a little bit about training. You provide some training to law enforcement officers as well, right?
Yes.
And that includes how to manage stress, ways to avoid using force, things like that.
That's essentially right. Yeah.
And you've written, I think there was a book shown, you've written a number of papers and books even about the management of stress for law enforcement officers, right?
Yes.
You'd agree that managing stress is an important part of a law enforcement officer's job.
A law enforcement officer and anyone who finds themselves in a high stress circumstance during their job. Yeah.
And you'd agree that it's a high stress job being a police officer.
Yes, it is.
They encounter stressful situations often.
Even if it's not often, even if it's occasionally, the ones that they do encounter can be quite stressful and quite dangerous.
And so managing that stress is an important part of doing that job, correct?
That would be right.
Including things like determining when to use force, how much force to use, things like that.
Well, that's actually more of tactical training. In terms of the procedures used, that's more of a tactical issue than a stress-related issue.
Fair enough. So other people train on what force to use and when, but for your purposes as a psychologist, in terms of imparting that knowledge, it's important for you in your profession to impart on officers how to manage their stress, how to make decisions under stress, things like that.
That would be right.
And you mentioned a variety of articles, and I know that you said that you wrote for Police One as well. One of the articles that you wrote for Police One in 2010 was called Understanding an Officer's Reaction to That One Big Mistake. Do you recall that?
I do recall that title, yes.
And you call those OBMs for short. Is that right?
I'm sorry, what was that?
The abbreviation for that was OBM, One Big Mistake.
One big mistake, right.
You also refer to that as OBFU, correct?
That's right.
And that stands for what?
OBM stands for one big mistake.
And OBFU, which you said it was also known as, stands for one big fuck up, right?
Well, I'd rather you say it than me, but yes.
Okay. But in that article, you use those abbreviations to refer to those terminologies, correct?
Well, I use the abbreviations, but the terms were used by the police officers themselves.
Okay. And so in that article, you acknowledge that OBMs, however you characterize them, are preventable, right?
Some of them are, yeah.
And in that article, you wrote, quote, "Yes, class, you've heard me say this 1,000 times before, but the fact is many OBM incidents occur in response to the deer in headlights freeze response that occurs when officers aren't sure what to do and have to wing it on the spot. And many of these mental choke points are preventable through the use of proper training and practice. This includes proficiency with firearms, non-lethals, vehicles, and communication equipment. It also means basic expertise in proper approach, citizen confrontation, vehicle stop, dwelling search, use of backup, suspect search, physical restraint, and arrest technique. Equally important is training in verbal communication and nonviolent conflict resolution skills so that potentially dangerous situations can be diffused before they require cuffs, bolts, or bullets. Those were your words, right?
No police psychologist and no police officer is going to contest the fact that the more training, the better. But the whole concept that we're discussing today is despite training, and in fact relies on training, that certain types of training may become more prominent than others.
You answered the question. Those were your words, correct?
Well, I'll give that long paragraph a yes.
But you're acknowledging that at least as early as this article 2010 and likely before, that this is an important part of the knowledge that you're imparting on these officers who are reading your articles, right?
Could you just repeat and rephrase that, please?
Prevention is half the battle, essentially, right? Is sort of the takeaway.
Prevention is always preferable than follow-up, yes.
And you mentioned that training can play a big role in that. So things like scenario-based training, trainings on managing stress and making decisions under stress can help prevent these types of things from happening, right?
Well, the whole concept of training is good is something that nobody's going to contest.
And you've been training officers on how to do these types of things, manage stress for decades, right?
Right, not the operational aspect, but the stress management.
The stress management.
Her crossing this guy
Essentially,
makes
to
it
help them
more likely that
have these
Larson will
situations turn out
cross
the best
Kim
way
Potter.
possible. Fair?
Yeah, that's fair, yes.
And that's because you're aware that stress can affect how people behave, right?
Yes.
Can impatience also influence someone's behavior?
I'm sorry, what was that?
Impatience, can that affect how someone will behave?
I'm not quite sure what you mean by impatience.
Well, if someone acts impatiently, that can influence
Like you?
will turn out.
Is she just testifying now?
Impatiently, do you mean impulsively? Because impatiently seems to imply sort of a lack of wanting to wait for something. And I'm not sure how that would apply to this type of circumstance.
Well, if a person acts impulsively or impatiently or acts too quickly, that can affect how a situation will turn out. Fair?
I can't say that's fair only because quickly is not synonymous with impatiently. People can act quickly and act adaptively. And in fact, most of the circumstances that we're talking about, that's exactly what happens.
All right.
This was a terrible question
That's an answer
to
my
ask.
Thanks.
Yeah.
Can't answer
She's
that.
rude to him too.
Really what you've talked about is stress management, right? Stress management,
She doesn't
Something
understand the
important
question
for
she was
officers,
asking. That
right?
was
Yes.
bad form.
and
Like a question someone gave to her.
trained to manage stress is to suppress certain behaviors when it's necessary under stress, right?
Well, preparation for a particular task is one way of handling stress. The more competence
It's a
one
yes or
ha-
no question, sir.
then-
Yeah.
can we go back to the question?
Excuse me.
Uh-oh.
Everybody has to follow the rules. Please don't interrupt him when he's in the middle of a sentence. Let him finish his answer before you ask the next question. Did you need the question repeated?
Yes, could you please repeat?
Mommy versus Karen.
No question, sir. Are officers trained to control their stress?
They often are and should be, yes.
And when it comes to the brain and how
Manage and control are two different things.
you discussed about how our brains can be flexible, how we can change behaviors, right?
Yes.
I think you said something about, I don't know if it was the frontal lobe, but some portion of our brain allows us to
One of your lobes.
plan an action, but also to shift gears when appropriate, right?
Yes.
And I think you said that we save brain power for things that are more challenging, where we have to focus on unusual aspects. Fair?
Well, we save the thinking and reflecting part of our brain power for those purposes, yes.
And again, training and experience has a lot to do with how someone will respond to a stressful situation. Fair?
That's fair.
And someone who has been trained repeatedly is better able to control and manage stress and better able to adapt. Fair?
All things being equal, that is correct.
And you were also asked about high stress jobs, things not only like law enforcement, but also other fields. There are lots of high stress jobs, correct?
I'm sorry, repeat that last one, please.
You mentioned aviation, things like medicine. There are other types of high stress jobs, correct?
Law.
But with fields like those and law enforcement where people have to deal with high stress, through your psychological experience and the training that you impart, particularly on officers, is the training
She's going to say training for an hour.
that officers can.
We get the point.
They are expected to be better prepared to respond appropriately in those situations.
Yes, I think I said that
At
earlier.
some point, this is asked and answered.
You talked about
The whole point is that doesn't matter
the
how much
job
training
of a
occurs.
police officer, right? And that sometimes there are other factors that might come into play with respect to an individual suspect's behavior. Fair?
All
Not
this
sure what you mean by
ambiguous language,
Well, you
this
mentioned
sometimes stuff, that's not helpful to proof beyond a reasonable doubt.
Right?
Well, those are factors that would heighten an officer's arousal level to danger, yes.
Sure. Sometimes people flee. Sometimes people can be violent. You mentioned those examples.
Yes, I did.
And those are all things that officers are trained to respond to, right?
That's right.
You also talked about the term slip and capture as a particular way that action error has been sort of adapted for law enforcement, right?
Yes.
But slip and capture isn't a term that's generally accepted in the field of psychology at large, is it?
Well, it's not a diagnosis, but it's simply a way of describing a cognitive phenomenon.
But that's a term, the slip and capture term, that you and others in the field of policing have coined, correct?
That we do what?
That's a term used in the field of police psychology, right?
Yes, it's used.
And used by individuals like Dr. Bill Lewinsky.
Yes.
And
I
you
read
relied
this
on his
same
prior work
NPR
in
article she
formulating
read
your
yesterday.
opinions in
Yeah.
this case.
Is there an article on
I
this?
don't rely on anything
Yes.
that Lewinsky said in formulating my opinion on this case, other than simply the use of the term slip and capture.
Okay. And you're aware that his research has been characterized as junk science in other forums.
What is this?
I don't know what you mean by characterized.
Well, the term slip and capture has no foundation in the general field of psychology at large, right?
The term may not, but the concept certainly does, and that's what we mean by an action error.
Okay. So we can talk about action errors.
Can you?
Are you
As
a
it
psychologist?
The term action error in this case, you're relying on your knowledge of research into the area of stress and perception, and sort of the general psychological term of action error. Fair?
Well, no, it's not a general psychological term. If you looked at the bibliography that I appended to my report, you'll see there are numerous references in peer-reviewed journals of descriptions of action errors occurring in the different fields that you mentioned earlier.
Sure. So action error is a term that has been studied in psychology, but slip and capture, not so much. True?
The actual term, again, is something that was applied, so it would be a handy phrase that people in law enforcement could use who are not familiar with the literature on action errors, but the term is almost irrelevant because it's describing the same phenomenon.
But when it comes to law enforcement,
But
there's
please
really
tell
not
me it's
much
not real.
peer-reviewed research connecting the research on stress with a police officer's action in firing a weapon, right?
No, that's not correct. There's a whole literature on cognitive distortions and other types of errors that occur in officer-involved shootings, much of which I built my book around to sort of have a handy compendium for researchers and law enforcement personnel to describe. So everything we know about officer-involved shooting and the cognitive processes that occur in those emergency critical incidents does have a long
Well,
recent
he's earning his 30 grand.
history.
The phenomena that you described include, you said, cognitive distortions.
Don't write your cross
That
based
right?
off of
Yes.
an
And you
NPR
used a
criticism
term
ever.
You are not going to out expert the expert.
or
Yeah, smart.
hyper focus, right?
Yes.
And that's what you described as where, under these stressful conditions, someone will zero in on the threat or the suspect and sort of tune everything else out, right?
That's essentially the concept. Yes.
And you talked about weapon focus being part of that as well, where people will focus on the weapon and not the surrounding circumstances.
Weapon focus is an example of tunnel vision.
That happens like in armed robberies.
Basically,
The victims
tunnel
always look at the
vision
gun.
being a condition where they would focus on that threat and not register what's going on or what people are doing or saying around them.
That's essentially correct.
Okay, so getting back to this concept of action error and these other fields.
Oh, you want
that
to go back to this
mentioned,
one? Are you sure?
Medicine, aviation.
Taking
things
the
like
L.
that. You describe that action errors are a known phenomenon in life, right?
Well, they are very common. Yes.
And because action errors can happen, there are a lot of policies and procedures and systems in place to prevent fatal consequences of an action error, right?
Well, the action errors that we strive to prevent are precisely those that can cause a danger, not just to ourselves, but to other people.
And in striving to prevent those types of action errors, you mentioned medicine, things, there are policies in place where, for example, there are checks on systems and how medicine
But they happen
is administered in
anyway.
hospitals, things like that, right?
And we don't send them to jail when those accidents happen.
There are
Exactly.
different knobs and different buttons that are different colors and in different places, multiple buttons to press so that there's sort of checks on the system. Fair?
Yes.
And your report talks about this phenomenon of action error, but it doesn't talk about error avoidance or error detection or error mitigation, right?
Yes, and there is a reason for that.
But those things are all also studied and known in the field of psychology and also human factors, right? In the way that these issues are addressed in the real world.
I'm not sure I understand the last question.
There are systems in place to address action errors in many professions, including medicine, aviation, and policing, right?
In those two professions, the first step is to identify them, to characterize them, and only then can we begin to develop ways of trying to mitigate them or to prevent them. And since the study of action errors in law enforcement is much more recent, we're still in the process of validating, cataloging, describing the types of action errors that occur. And of course, the hope is that just like these other professions, we'll get to a point where we can design mitigatory strategies for preventing these in the future, or at least minimizing them.
So there are things in place, systems in place to minimize or prevent fatal consequences from action errors, right?
Not as well developed in law enforcement yet as occurs in these other fields you mentioned.
Okay. Well, there are things in place in law enforcement that you'd agree are similar to the things in place in other fields. For example, things like design. There are systems of design that can be implemented to address action error. Fair?
Could you be more specific, please?
So things can be designed to look different from one another. For instance, a taser can be bright yellow while a gun can be black, right?
That's correct.
And that design difference is one way to make noticeable the differences in those two devices. Fair?
That's the intention, yes.
And there are things like policies and procedures in place in terms of how officers are required to carry their weapons, for instance, to address this type of risk, right?
Yes.
For instance, like carrying your taser on the opposite side of your duty firearm, right? Using the opposite side of your duty belt.
Yes.
Things like having different holsters, different mechanisms for draw, right?
Again, I'm not testifying here as a tactical expert, but in a general sense, I would agree with that statement.
And you'd agree that practice handling those weapons can help to reduce those errors as well. Fair?
And the more practice, the better the effect.
And things like handling a weapon on a daily basis can help with that as well, right?
Right. Practice with any technique, the more it's practiced, the more it gets baked into the brain, the more likely it is to occur when you need it.
So I'm going to get to your interview with the defendant in this.
Those 4
case.
times she didn't
You did conduct an interview.
test her taser, spark test her taser. That's the key, I guess.
That's it. This guy is good. This guy is very good.
Yeah, yeah. This guy's
He's
good.
holding up very well.
He's breaking up the flow by doing non-yes, no answer responses. Like he's doing very well.
So they're gonna try and exclude, I guess. Maybe
What
some of the
she
statements
said,
from
but-
the interview.
But what she said is part of your point in the mission, though. So
Right.
she gave statements. It should be able to come in.
I was thinking this might be one of the reasons that they're going to have Potter testify is because if this guy's interview is going to be the subject of this cross-examination, they'd want her to be able to maybe rehabilitate the characterization of what she says or what she said to this guy in the interview. So I wonder if they have a transcript of the interview or just a summary.
I got distracted, but she wanted to ask about what Potter told him.
Yes.
Yes.
Okay.
But I don't think they would have any trouble doing that. Unless there's very specific things in the interview that they want to go into that they might object to those specific things. Sorry, what were you going to say, Nate?
No, I was going to say the only objection I can really understand is hearsay, but the party opponent admission gets you over that. So I don't know where they're going with this objection.
By the way, Nate, I'm going to need you to sue Nate the Hoof Guy. Because every time I go in to type your name, Nate the Lawyer, into the description, it pulls up Nate the Hoof Guy. And I'm like,
Is that a furry? Like a
I gotta look who that guy is.
I think he's probably a guy who like manages horse hooves, like, clips them, maintains them, rubs
niche
oil
job.
on them or something.
Nate the
I don't
Hoof
know.
Guy.
Probably lives in Ocala.
Leave the hoof guy alone. Send hoof pics. No. Oh no. Here, let me read some of these chats. Oh my goodness. Abe Eckstein says, "Can we get Uncivil Law to sing us in even if it's not your birthday?" No. If he does that, I'll sue him forever.
Wow, this Nate the Hoof Guy's got like almost 400,000 subs.
What?
Yeah.
Hold on, I'm on it.
I'm telling you, horse hoof maintenance is very important.
Yeah, he's all over it.
Damn.
Is that
We're
what
in
he
the
does?
We're on the
Is
wrong
it-
niche, guys. We're on the wrong
Is
niche.
it hoof maintenance? Is that
Yeah,
what his
it's
videos
hoof
are about?
maintenance. I'm looking like a whole bunch of hoofs that look horrible, but he's
cows
keeping them
too.
up.
He doesn't simp for horses. He's in cows.
All hooved animals. He doesn't mess around with cloven-footed animals or whatever. Earlier, guys, I read a chat and I said it was from Baffled Baboon because I was still asleep on stream. Baffled Buffoon. If you want some politically neutral, I think he said, what did he say? He said some even-tempered, not politically neutral, even-tempered pop culture news and reviews. Baffled Buffoon, not baboon. That was good Lord. Taylor Otwall says, "Rip that tie off, Bronca. Today's a big day. I'm ready to get hard."
Speaking of which, lawselfdefense.com/get-hard.
Boom.
Autographed.
The judge is about to say it. She's going to say it. This is MAGA country.
I would pay
Oh,
so much money to have the judge say that.
Oh, that would be
my
so
God.
awesome.
This is MAGA country.
You gotta have it said in a hard Nigerian accent, though. You gotta get the bass in the voice. MAGA country, MAGA country. Brother.
Don't go too Jamaican on it, Nate.
Yeah, brother.
All right.
Maybe hard
That-
Nigerian.
Well, Ugandan as well. The Ugandan knuckles. One of my
Check this out.
favorite.
Did you guys see this stuff yesterday about the two liberals that got kicked off of Twitch for using the word cracker.
Yeah, Hassan and
Yeah.
who else was it?
Vouch.
Vouch. Yeah. So and they go and they kept using it. But get this. Think about this. I was asking a couple. I was in a chat yesterday with a whole bunch of my I'll say extreme BLM black people, right? So they were all inside there, right? So we all talking about, oh, we should be able to say it. So I said, okay, let's say a black guy, let's say a white guy comes up to you and uses the N-word, right? The hard ER.
Yeah, right.
And then
like
so
Richards.
how would you guys
Grambo.
like Richard? So I said, how would you guys feel? They said we would hate it. But let's say this white guy that turns to you and says, well, listen, I'm 1/8 black. Would that give him a pass in saying the N-word? And so they were like, no, of course not. 1/8 black, he hasn't suffered enough. So then I said, well, listen, think about this. Plessy in 1896 from Plessy v. Ferguson couldn't ride on the front of the trains because he was 1/8 black. So I said, God damn it, Plessy was too white for the too black for the train. He was a hard NR back then. And now 100 years later, he can't say the word because he's not black enough. What about Plessy, right? Plessy loses all the time. He's losing in the 1800s. He gets up, he's finally like, all right, I can say it. No, you're too white to say it now. I was suffering back then, and it's crazy. This is the world we live in. Plessy now from Plessy v. Ferguson cannot say the N-word.
Can't do it.
Cannot say the N-word.
No.
Crazy, right?
Plessy was such an interesting plaintiff for that, right? Because he was he was like, 1/8 black, but he had red hair and very, very light skin. The people who had him thrown off the train knew this was like orchestrated, right?
Yeah,
they
it was all
knew
orchestrated.
that he would that he passed as white very, very easily. However, they informed the train people that he was indeed black, and so, or that he was indeed 1/8 black, and so then they came to throw him off, and so that it made it even more ridiculous in the courtroom to be like, yeah, this guy was excluded. They chose that. They did not choose one of the Nigerian brothers from Jussie Smollett to throw off the train.
This is a white guy.
Like, I don't care how much bleach you have; those guys are not looking like they're pasty or white complexion. Like,
but the one messed up thing about that law, one of the reasons why that's one of the worst Supreme Court decisions ever, is because the law was written in such a way where a non-American citizen Asian person could ride in the white only section, but a citizen African American person, or even Mexican, couldn't ride in that section. So that was like one of the big key issues of that case too. But I just find it crazy.
The objection is sustained.
Oh,
ooh,
whoa,
ooh, mommy's
that
not pleased.
surprises me a lot, actually.
She is not pleased.
Dr. Miller, just a few more questions. You reviewed video.
That was a
in
big
this
part of her
case,
cross.
correct?
Sorry?
You reviewed some video in this case,
Yes.
and you'd agree that the defendant's handgun was just inches below Officer Lucky's face.
Her
when
stress
she
and arousal
fired.
level went way up.
Don't be on the scope. That's
Yeah,
not
More
her area of
stress or arousal?
Oh, they shut down. That's it, huh?
Oh, is it, huh? Last desperate question.
Well, she had more, but it got shut down. It was... Oh man.
Holy.
Carlos
What?
Atala, doctor-patient confidentiality probably would not apply here, and also is pretty easily breached in court.
Yeah.
I wouldn't rely on doctor-patient confidentiality to protect you from anything,
That was
especially in a manslaughter case.
A couple of questions for you, Doctor.
Sure.
Oh, they feel good right now.
Look, talk about
Explain
hyper-arousal.
Error avoidance and error detection. In the industries that you've studied, action errors still happen.
Yes, we can control every circumstance.
In medicine, for example, how many errors occur? How many deaths occur every year
Huge
as a
amount.
result of action errors?
Objection, lack of foundation.
If you know.
The objection is overruled. You may answer.
According to one source, over 1 million a year. These don't necessarily involve serious injury or death, but just errors that occur in which an adverse outcome does occur.
And this is a profession that is highly trained to know that they can happen and they still do.
I mean, I'm not an expert on medical procedure, but that would be a logical assumption.
Not a million deaths, guys. If you listen carefully to his answer, it was a million errors.
Adverse events.
And they still occur.
But just like they think it's a million deaths, some people on the
where
jury
there's
think it's a
a
million
great deal
deaths.
of training
Yep.
involved.
Yeah, I mean, the broader point is it's unrealistic to expect zero errors in any profession. Our goal as responsible professionals is to bring that number as low as possible.
But it still happens. Yes?
I'm sorry?
It still happens, though.
And so far, they still happen. But again, that doesn't relieve us of the responsibility of still trying to reduce how often they happen.
Thank you.
Is there anything across?
Thought of another question.
Hopefully, it's within the scope of cross
Dr. Miller,
or
you
direct.
testified that there are many action errors that occur in medicine, correct?
That's my knowledge, yes.
How many of them are fatal errors?
I have no statistics on that. I don't know.
How many planes fall out of the sky every day?
Fortunately, very few.
Nothing further.
Anything further? Okay.
Did she think that was a
Thank you,
good
Doctor.
question?
You may
I think she thinks that was a good question.
Weak sauce.
That
In what world?
the question is not. This didn't happen every day. This happens rarely, but when it does, it's catastrophic, just like a plane crash.
Yes, like the Malaysian flight that disappeared that we still don't know about. It happens every once in a while.
Look, that
was a
that
bad
flight
question.
was eaten by Jeffrey Epstein.
And Hillary.
Yeah.
That's how JFK Jr.'s plane went down, right? Because he made a mistake and pressed one button and it was supposed to press another one or whatever.
Morning break, then Kim Potter.
All right, members of the jury, we're going to take our morning breaks.
Yeah, here it is.
That did not go
good.
well for the state. Not go well for the state at all.
Wow.
And again, tactical error in my opinion, because I'm pretty sure Aaron Eldridge is not going to do the cross of Kim Potter
Yeah.
because she prepped for the cross of this guy.
And folks, when we talk about how expensive these things are, these trials, and how a $200,000 legal defense is completely different than a $20,000 legal defense, this is one of the things we're talking about. This guy alone was 30 grand. If you don't have the 30 grand, you don't get him as your expert witness.
Yeah. Most experts are not Geiga Chad super cop from yesterday who will drive up for free.
When we were conferring with the headsets on, we were talking about the fact that my prior ruling was that although there could be testimony about slip and capture, no person could, no expert is entitled to testify that that actually happened with respect to Officer Potter on April 11. So there's going to be a rebuttal expert as well on the slip and capture issue. If you open the door to that, either side, well, if the state opens the door to anything of that sort, getting into her testimony or her statements to the expert, I am going to allow recall of Dr. Miller to have him testify. So just so we're clear on that.
And just to be
Okay.
clear for the state, Your Honor, we are asking that Dr. Miller not be released from his subpoena so that he may be recalled in the event we do wish to recall him.
Counsel, that's a legitimate request. That's a legitimate request. Okay. All right.
Available today, Your Honor.
Right. Okay. Thank you,
They're gonna,
counsel.
you know who they're gonna bring back for their rebuttal expert, right? Their expert.
Yeah.
They're gonna bring back that Weasley guy to testify.
Their experts are no bueno. Like the state's experts, man.
Yeah, they're not
they're-
good. They're not good in this one.
They're gonna. I didn't think they were gonna bring that guy back, but it looks like they are, because he was, in my opinion, kind of terrible.
Right.
But they didn't cross him as well as I think they could have, because
Yeah.
Earl Grey left a lot on the table. Like, he should have been destroyed. But we'll see. We'll see, because second bite at the apple of the expert is never goes well. So
Yeah, it's the weasel versus the honey badger, because this guy was great, man. This guy was just like, you could tell he had the experience and the wisdom. And when she was trying to go down that path of getting into the science and like the actual fundamental principles, you're not going to win that argument with an expert. I don't care how much you've prepped. Like, they know more about their field than you do. So don't try to do that on cross. Let your expert do that, right? Separately, but don't try to get the gotcha question, right? Because of exactly what Nick said, because you read something on NPR, right? And you think you're smart.
And what you read was probably wrong. They were using the terminology incorrectly. I mean, we all have areas of expertise, right? When I read news articles on my area of expertise, it's all wrong. They just don't know what they're talking about.
Yeah.
Right.
And
They're journalists.
Just so you guys know, I think I Googled Kim Potter or trial or something yesterday I was looking for something, and that article popped up. It's what they're going to talk about tomorrow. And it was why slip and capture is controversial or whatever on NPR. Someone wrote a big opinion piece about it, and they were talking about how it was the same type of stuff. This is not accepted science. This is not this. This is not this. This is not that. But what happened there on the stand was her basically regurgitating those types of talking points, and that guy just saying, actually, you're incorrect. Nope. It is an accepted piece of science. It's just got this special phrase for police because it's easy for them to think. My brain slips and then it captures the old training, exactly as he said. So he's like, it's not about the term. The term is irrelevant. Action errors occur everywhere, and everybody can relate to them because we do them all the time.
Yeah.
So
if you haven't done something automatically that you didn't intend to do at least once in your life, right? I mean, it'd be odd. It'd be odd if you didn't act like automatically do something that you didn't intend to do.
Well, the simple thing is, a lot of people forget the whole gas pedal, brake pedal confusion.
Yeah.
That happens a lot where people are being parked and they hit the gas pedal instead of the brake pedal. So,
Yep. Or people,
We've all done it. Just the other morning, I went to make some scrambled eggs, and I cracked the egg, threw the yolk down the garbage disposal, and put the shell in the bowl. I mean, and you're like, well, why the hell did I do that?
Yep.
Because you've been up too late with Nick. That's why.
It's tough to run with the big dogs.
He's saying scrambled eggs, but you know what he was actually doing? He was making that hangover drink.
That prairie oyster.
Does that work?
I
gotta try it.
I don't drink raw eggs. It sounds horrifying to me. Just the texture. Ugh.
I saw it first on Cowboy Bebop, not the live action that was canceled.
Right. Oh boy, did that ever get canceled?
That was horrible.
Did that ever deserve it? Here we go. There's some chats I want to read. But if you guys have any thoughts about testimony so far today or what's coming up, please feel free to share them. Mark Gee says, isn't it weird that we have never seen Legal Mindset on the stream when Legal Mindset Senior is talking in the court? I do find that odd.
It's my age jutsu, you know. I just can't be on at the same time as my uncle. You know, that's why we don't invite him to Thanksgiving or Christmas, because nobody really likes his prosecutorial ethics.
There you go. Don Pedro says, what an eclectic crew here. The limitless energy of Rackets, the humor of Bronca, and the melancholy Eeyorness of Uncivil. Great stuff. Tyler Smith says, so y'all have talked of how risky taking the stand is. Do you think it's a negative or positive for her to be on the stand?
I think it's how do you hit her? How do you attack her? Like she has a perfect record. She's got this. I think if you're gonna put anybody on the stand, this is probably the best witness you can put. Her and Kyle, right? They have no criminal history. So the risk is low. It's just you just hope that she doesn't say anything crazy. That's the big risk for her.
Yeah.
Why didn't you spark test? You should have spark tested.
And remember, so these are general concepts that you talk in generalities until we have specifics. And the specific for Kim Potter, as we've learned through this trial, is they even said yesterday during the character witness discussion, or it was when they were discussing the character witnesses the day before yesterday, they said, we have, as the state, no intention to try to attack her credibility or her character for peacefulness or truthfulness. They have nothing, because if there was anything, they would be chomping at the bit,
right,
to have those character witnesses come up and open every door possible. They were happy to have those character witnesses limited. And again, if you've got someone who's going to defend their good actions, I mean, if you found out that they have an HR file at all, like they said spicy jokes at a bar during a company outing or something, right? Think Blizzard Activision. You want to kick open the door on character on anybody named in the Blizzard Activision suits, because then you get to talk about the Cosby suite. Then you get to talk about the improper passes at female coworkers that are alleged and all that stuff. You want that stuff to come out as much as possible. With Kim Potter, they would revel in it, but it seems like she's this ideal little officer who everybody likes.
So that's the big risk, right? With any criminal defendant, most of them are criminals. Most of them are going to have a bad character record that can be brought up. But there's two other risks, right? One is some kind of implosion, some kind of outburst on the witness stand because they're goaded, by Larson or whoever's doing will be doing the cross on her. And the other is, the prosecutor can ask very carefully phrased question to fish for very specific words to come out of the defendant's mouth that, when said out of context in closing, could look damning. And the defendant has no idea what those words are. They're just talking.
Right.
And we saw this in Rittenhouse. Binger kept asking basically the same question in various variations over and over and over again, because he was trying to get specific words out of Rittenhouse that he could then repeat at closing as some kind of damning confession. It didn't happen there. I think Rittenhouse came out fine. But when you put your client on the stand, you don't know if that's going to happen beforehand. And once they're in that chair, you have no control over what comes out of their mouth.
Right. That's the big risk. Let's see. Billy Witch Doctor 99 says, here's some grift funds. Keep up the good work. Hey, thanks, buddy.
Yeah, that's what I would worry about here, that, whoever's doing the closing will be able to say, even this defendant herself admits whatever.
Right. Yep. And they're fishing for that line, whatever it is.
Mm-hmm. One thing I think the defense did well yesterday was by bringing that black officer she used to work with to the stand about the character. They killed that whole she's a racist, like, because that was in the background. She's a racist that just shot this kid because he was black and all that stuff. So by having a black officer come on saying, hey, this is not true, this is I think it did two things. It played to that, but now also kind of it limited that line of attack. So now I don't think the prosecution, even though they're not supposed to be trying to use that line of attack, we know that's what they were going for. So
yep. And it just completely, it was obliterated in one simple moment of having that witness.
Hey, is Stoughton, does he have psychology expertise, or is he just like a police policy guy?
Someone in the chat says he's not the expert they would be offering to rebut.
He has a bachelor's degree.
Yeah, he
once bought a graphic novel on psychology.
Pizza Girl says the state's expert to rebut this is Dr. Steve Kasner. Read the November 1st ruling, page 1 footnote. He agrees with Dr. Miller. So he agrees with this guy. According to this chat person, he agrees with him in the footnote. But
I think the underlying concepts are well known and well understood. I mean, we all get it. The only thing I can imagine the state expert would say is, well, that exists, but it did not happen here, which the judge just basically told them, I'm not going to let you do that.
Yeah, if you do it, then they get to rebut, and they get to say it did happen here. I talked to her.
That sounds inappropriate.
I just don't understand what his
rebuts are the best.
Her question was essentially like asking him, like, hey, so the thing that you've been writing about, that's junk science, right? Like, that's totally like trash science. It's like, you think he's going to say yes to that? Like, in what world does he agree to that sentence? Like, in what universe of delusion does he agree to that?
No, even the ancient aliens guy would be like,
it's such a generally accepted concept in psychology. We all know it. We all experience. I mean, this shout out to Bill Lewinsky. I've taken his course, the Force Science Institute thing. a week-long course. It's interesting. They do a lot of studies on a very small scale because that's all the resources anybody has. No one else is doing anything even close to what they do. But because a lot of the studies are on a small scale, you might argue, well, maybe they don't have scientific power you would like in a major field of study like psychology generally. But this slip and capture thing, that's not a Bill Lewinsky research topic. That's known throughout the field of psychology.
See, the problem is that the term is maybe junk science, but the principles behind it are not, because the principles behind it are for all, for anything that you do. And I'm thinking that's kind of where the flip here is like, okay, that those terms really represent junk science, but the fundamentals behind them don't, right? Because in every job people make these type of mistakes. So
but isn't that antithetical, Nate, to the definition of junk science? Isn't to me, junk science is something where you have neither, the term doesn't make sense and the principles are bunk. Right?
Yeah.
Like versus a controversial hypothesis. I think we're allowing that language, that junk science language in when really it's not permissible. It's like calling Kyle a white supremacist when, okay, he had a photo with a Proud Boy once.
Right.
Like,
the phrase is not the science. The phrase is just a label on the science. If the science is sound, there's nothing wrong with the phrase. It's like I talk about these 5 elements of self-defense. There's no state that has 5 elements of self-defense in their self-defense statute. But it's a framework that happens to apply effectively to the self-defense law in all 50 states. So it's a good way to kind of simplify the concepts and make them understandable to a lay audience.
Right, because shockingly, when you're working with police officers who are not PhDs in psychology, it doesn't help to use clinical terms with them. It helps to have things that they can easily understand, relate, and relay to other officers and in trainings and things like that. It doesn't. They don't need a bunch of citation papers. That's how you qualify yourself to speak on the subject. That doesn't help the audience all that much. Right. It's just silliness. I mean, like her. Do you mean one OB?
OMFU?
Yeah.
OMFU?
No, OBFU. Right?
OBFU. Yeah.
Yeah. What does that mean? It's like you're talking to cops. Cops would say one big fuck up. They wouldn't say one big mistake. Like
he Jedi mastered that. He Jedi mastered by getting her to say it.
Right.
Yeah. And he's like, I wouldn't say that, but the police officers that I'm.
It's like when Richard
working
said,
with,
what was it? Richard said? Did he
hard
actually say
R
the
and
N-word?
hard R,
Yeah.
Twice in a row.
Just like Grambo say it. Just like Grambo say it. She's more lovable. Like.
Colin Archer says Twitter DMs for the Chad meme. Oh, is that where it was? If I could find this thing. Let's see.
407 Twitter DMs ago.
Hey guys, I'll just briefly, this is probably the last day I'll be on the group session. My wife has surgery on Monday, so I probably won't be back for that. I'll just have to play it by ear. But in the event I'm not, folks, just reminding you, my Law of Self-Defense advanced class, January 8th, a Saturday full-day class on self-defense law. People like it, so I encourage you to at least take a look at lawofselfdefense.com/advanced.
Man. So if you, up. There it is. There it is. Oh, that makes me happy. Here we go. I'll pull it up. Here we go. So here we go.
I knew it. Oh, this needed to happen. I was thinking about this morning.
But look, it's the Virgin defense expert versus the Chad state expert. So the Virgin defense expert, overdose of testosterone makes him go bald. 44 years of experience weighing down on his shoulders. Had heart surgery before testifying. Neutral suit with a boring complimenting tie. So old he was alive in the 80s, whatever that means. 4 to 5 page report. Too unimaginative to add verbose details. Testifies for free. Missouri accent makes him sound too folksy. Feet are worn from trotting the globe. And then we got the Chad State. Young and smooth mind, allows for sleeker arguments. Full head of hair and manicured beard. Has the time to take care of himself. Gets paid $95K for a day of work. Has an entrepreneurial mind. Over 9,000 page report clearly shows skills as verbose and prolific writer. Knows to stay hydrated, sips water every 69 seconds.
Wow.
Unafraid to wear clashing colors. Clearly a fashionista. Look, he's got the tie.
Got the tie.
5 years of police experience, left that life behind him 15 years ago. Hashtag BLM. ACAB and QOS. Unafraid to speak his truth under oath. Uses made-up legal terms. Shows his ability to improvise. Strong and rested legs from sitting at a desk for 4 to 5 years.
Wow.
Oh God. Oh, those memes are great.
Thank you, Colin Archer. That
made my
me
day.
very, very happy.
Can I get that framed?
Link it in the description. Okay, give me a second, guys. I'll link it. Well, no, it was sent to me in a DM. I don't know.
Just
I don't know
tweet
if
it
I
out.
can. Yeah, I'll just tweet it. Here we go.
You're welcome, Twitter.
Yeah, how are you so smart? You're like, just tweet it, dummy.
That's why I'm legal mindset.
Oh my goodness. Here we go. That's it. Hashtag Kim Potter. Oh, there's 510 Kim Potter trial tweets today. This has not been a very popular Twitter topic. I mean, despite the fact that we have lots of people watching on Twitter, the interaction on tweets about this for me has been lower than I expected. So kind of interesting to see it actually trending on in any way on Twitter at all right now.
If she gets found not guilty, though, these videos are going to be like, because people are going to know why she was found not guilty, because the news media is souping this up for she's about to get a hard, life imprisonment for these charges. So they're not watching the trial; they're spreading the narrative.
And just so you guys know, I will have a video dropping. I was going to drop it yesterday and then today, but with the live streaming, it's just it's weird to drop videos while live streams are going because people are typically watching the stream. But I'll have a video up on the state's expert witness and his shifty testimony between the state and the defense. So it's very fun. So I'll put that up so people can see exactly what was said when he was asked by the state and then when he was on cross with the defense. So I thought that was good. But yeah, I do think, and I think people are going to want to check that out because I do think she's not going to be found not guilty at this point. I mean, certainly it's up to the jury. You can't predict a legal outcome, but I think that the defense has done their job so far, giving the jury everything they need to find a not guilty. And I don't think the state has done their job, giving the jury what they need to find guilty. So we'll ultimately see. But I think what the judge just did to the state was pretty brutal. If you testify, if you bring in someone to testify that she didn't experience a slip and capture, I'm going to let the defense use their expert to testify that she did.
So what's the state's expert going to say? If they're not going to say that, they're not going to say action error doesn't exist.
Maybe they will.
Maybe they will.
Yeah.
No, it's going to be awkward.
because we all know it exists. It's just trying. They're probably going to try to walk some fine line where it exists, but in the way it's being explained, it's bullshit. It's BS.
Oh, they'll just talk more about training, right?
Figure it out.
But isn't the training supposed to eliminate action error? Doesn't she have lots of training? 26 years of training.
Yeah, that's what I'm thinking.
But that's overcome with one thing. This is the first time she's ever used the taser in the field, right? So you're gonna be trained for 100 years. But if I've never used the gun in an actual live scenario before, then it's a different story.
And of course, then the cross is just. But isn't it true that action errors occur in medicine, in aviation, in nuclear reactors, despite all the training?
In policing. And just say, isn't it true that it happens in policing despite all the errors?
don't planes fall out the sky because of action errors? Because that's true.
That would be good.
They have. Yeah.
That'd be good. Yeah, having planes fall out the sky because pilots are action. John F. Kennedy Jr., for instance. Boom.
Yeah, it'll be.
He thought he was flying level. Not
Yeah.
so much.
And and by the way, when you said
That's actually what happened to JFK.
That's what happened to JFK
right.
Jr. That's exactly what
Yeah,
happened.
he thought he was flying level, but it was overcast sky, and I think it was, I don't know if it was snowy or whatever, but basically the horizon blended with the ground.
Yeah, he didn't know how to. He
yeah,
didn't know how
Looks
to
like we're
fly.
coming back.
I went through
Yep.
a cycle of listening to those black
Here we
box
go.
recordings. It was really perverse, but
We have to have them stay at this hotel, which is at the Hyatt downtown. We have rides coordinated so we can bring them back here. I don't see any point in having them sit in the room for all day either, but I'll honor the speed, of course, but we'd like them to stay at this hotel instead.
How quickly can he get here?
Well, about 15 minutes.
Okay. That should be fine.
And
Right.
there is a rebuttal witness. We've not heard about it. The state has not
Oh,
any witness to be called today. And I know that the court referenced the rebuttal witness. We'd like notice.
All right. Is the state intending to call the rebuttal witness expert?
Your Honor, the state's rebuttal is entirely dependent on the testimony of the defendant at this point.
that's a bullshit
Okay, so
answer.
We haven't decided yet. All right. I just want to make it clear that if Officer Potter testifies inconsistently with what she said to Dr. Miller, I think it's fair game for the state to call Dr. Miller to testify. Okay, that is not going to open the door to the defense asking the ultimate question. I just want to make that crystal clear, okay?
So,
They'll allow them to
so I
impeach.
know, Your Honor, if they ask questions on that report, did you say this? Did you say that? And now the jury knows that she was interviewed by Dr. Miller, and they're gonna wonder what the diagnosis was. We never mentioned that she was interviewed by Dr. Miller. That opens the door, doesn't it?
No, because Mr. Gray, that would just be pure impeachment of her factual
Okay,
testimony.
what happens if she says, no, I didn't say that? It was on a Zoom meeting and it wasn't recorded. She says, I didn't say that. And then they recall Miller. Does that open the door?
No, because it would just be pure impeachment
Well,
of
now we
her
have
factual testimony.
Well,
Yeah, so
now
you're
we
stuck
have a
with the answer.
situation where he interviewed her, he wrote a report, and they're going into that, and we can't show the result of his interview and his report, even though they're going into it. That's not fair to the defendant, Your Honor. Totally not fair.
Well, Mr. Gray, that's my ruling.
Okay, I just want to make sure I didn't make any mistakes. So I
Okay.
don't want to do that.
She likes Earl Grey.
Okay.
She likes him. He just
Mr.
stood up and
Chair,
said,
Your
"That's a
Honor,
mistake,
before we
Your
do that,
Honor." And she's like,
If it
"Oh,
is
okay,
the
that's fine."
defense's intention to call the defendant at this point, I think we have to make a proper record before that.
We already did.
I think I already
did
asked
yesterday.
pay
Officer
attention, Aaron.
whether or not she still wanted to testify.
I would just confirm that as of today, I would just make an additional record, Your Honor.
Well, is your decision the same?
Yes.
Okay.
We don't need to belabor the 10-minute questions.
Obviously, if she takes a witness stand, her decision is the same.
Yeah.
Okay, just that.
Chris Singleton says, "In my town, there's a nurse that was doxxed for speaking out against masks at a school board meeting. The prosecutor is considering harassment charges against the person that doxxed her, and I'm in Michigan. Is that possible?" Look, it's always possible. The question is whether or not you'll be guilty. Typically, depending on the context, doxing is protected speech so long as they didn't illegally acquire the information and so long as it's not being used for the purposes of harassment as defined by the criminal harassment statute and case law.
In that state.
Right. And that gets very, very specific. But again, I don't endorse doxing. I don't participate in it, but people do it, and it is typically protected speech, unless it's done for the purposes. Harassment tends to be for the purposes of causing intimidation and fear or apprehension of harm. Those types of things. Like if you post someone's address with like a picture of a gun next to it, that's when you're getting into harassment. But you got to check with your individual states and how they interpret that stuff. I'm not giving anybody legal advice on that.
But also be aware, even though it's not illegal, all these platforms, if they find that you're doxing, they will terminate your account. So
Right. Yep.
Yeah.
And again, personally, I counsel against doxing just as a general practice. It's not something people need to do, but people do it. I'm not going to sit here and
The state
condemn
may call
people
its
either
next
way.
witness,
That's right.
or excuse me, the defense.
Yes, sir. Defense calls Kim Potter to the stand.
Here we go.
This is the
This
This is the
Thanks,
trial.
guys.
This is it.
We'll see if you change your prediction, Nate.
Hey, bro. I'm streaking hard right now. I'm still
Saint
not guilty.
Stradamus.
I do. I do, Your Honor. Please have a seat, and please remove your mask. And Ms. Potter, I gave the rules for testifying, and you've been in the courtroom. Do you need for me to repeat them?
No, Your Honor.
Okay. State your full name and spell it.
Kimberly, Kimberlyann, Potter, Potter.
All right, counsel.
Thank you. Ms. Potter, will you speak into the mic? Because both of your lawyers have a hard time hearing.
Yes, there's just the next here.
Okay. You stated your full name. How old are you, man?
49.
And are you married?
Yes.
And is your husband in the courtroom?
Yes, he is.
What's his name?
Jeff Potter.
And how
She's
long have you
nervous
been
as
married?
shit.
Over
Yeah,
25 years.
her life is on the
And
line.
Yeah.
when did you first meet your husband?
When I was 15.
You were in high school?
Yes.
And did you reunite much later?
Yes, when I was in college.
And what does your husband do?
He works for a healthcare system now.
Is he a retired police officer also?
Yes, he is.
And where was he a police officer?
Fridley, Minnesota.
Was he also a member of a drug task force?
Yes, he was.
And with respect to your children, do you have children?
Yes.
And what are they, 2 boys?
I have 2 boys,
And what are their names?
Nicholas and Samuel.
And are they in the courtroom?
No, they're not.
And where is Nicholas?
He's an active duty Marine.
And where's that at?
He's currently stationed in Florida.
And your other son, where's he at?
He's in college in North Dakota.
And are they going to be home for the holidays?
Yes, they will.
Is your mother in the courtroom?
Yes.
And your sister?
No, she's not.
But is your brother in the courtroom?
Yes, he is.
And besides your brother and your mother, your father is deceased?
Yes.
And do you have any other siblings?
I have another sister and a brother.
And what are they? Do you know what their ages are?
My sister, my oldest sister's in her 50s, and my other brother's in his 50s also.
And what do they do for a living?
My sister works for a medical device company. My oldest brother works for a parking company, and my other brother works for retail.
Going back to when you were a youngster, where did you go to elementary school?
Immaculate Conception Catholic School,
And where was that located or is located?
Columbia Heights, Minnesota.
And did you live in that neighborhood?
Yes, I did.
While you were at elementary school, while you were going to that school, did you have a police officer visit your school?
Yes.
And do you actually know his name today?
Yes, it's Officer Michael McGee,
And where was he a police officer at?
the Columbia Heights Police Department.
And why was he at your school?
He was doing bicycle safety for grade school kids.
And you remembered his name. Anything else that was significant about him that caused you to do something in your life?
He was on that occasion, he really influenced me as a youngster that the police are good people, and I wanted to be something like that someday.
And because of that, and because of him
Policing is
being
a
at your
lifelong
did you start
passion.
out doing that?
Yes.
And what was your first job or volunteer work as some type of a law enforcement officer, student, explorer, school cop?
Well, the first thing I did was when junior high was a school patrol officer, if that counts.
Yes, that does count. And what did a school patrol officer do back then?
It was junior high, so we helped the younger grade school age children get across the street.
And did you continue to do that throughout junior high?
Yes, 6th, 7th, and 8th grade.
And after getting into high school, what did you do?
The Fridley Police Department came to my high school and had a booth set up for the Fridley Police Explorers.
And did you join the Explorers?
Yes, I did.
Why did you join the Explorers? First of all, what is an Explorer?
It's part of the Boy Scouts of America. It's a area where you can have career enhancement, or you can learn about different jobs like law enforcement or firefighting, things of that nature.
They were letting girls in even back
And
then.
were you an
SMH.
Explorer throughout your high school days?
Yes, I was.
I can't remember if I asked you what high school you went to.
Totino Grace High School in Fridley.
With respect to criminal justice or law enforcement, while you're in high school, besides being an explorer, did you do anything else?
I had jobs.
Okay, what was your job?
My first job was at a gas station.
What did you do there?
Clerk, cashier.
And
All these police explorers on trial. Kyle,
Yes,
her,
into
what the hell's
college.
going on?
okay, so your next visit was college.
Yes.
Where did you go to college?
St. Mary's College in Winona, Minnesota.
And that's about what, 70 miles from here, 80?
Yeah, it's down towards La Crosse.
Okay, it's in Winona.
Yes.
And what was your major at St. Mary's?
Criminal justice and sociology with an emphasis on elderly studies or geriatric
Nothing
sociology.
catch errors.
Why did you take those courses?
I wanted to go into law enforcement, and I had an interest in serving the older community and understanding their needs and wants.
Did you graduate from St. Mary's?
Yes, I did.
And was that a 3-year program, 4
It was a
years?
4-year program. I finished it in 3.5 because I had an internship in the summer
And where did you internship?
of the Columbia Heights Police Department.
Columbia Heights Police Department?
Yes.
Okay. And what did you do at the Columbia Heights Police Department?
I was assigned to an officer who was in their community-oriented policing program.
Cop.
Did you also continue your explorer career while in college?
I stopped being an explorer after my freshman year, and then I role played at the annual conference.
What does that mean?
Every year, the
Wow.
Explorer program had an annual conference at Breezy Point Resort, and they needed role players, and they like to use students or people that were in law enforcement.
So you graduated from St. Mary's,
Yes.
and what did you do after that?
After that, I would have gone to Skills in the summer of 1994.
Okay, and what do you mean by that?
I went to Skills.
What does that mean?
I went to the police certification program so I could get hired.
And where was that at?
Alexandria Technical College.
In Alexandria, Minnesota?
Correct.
So everybody knows about 120 miles, 30 from
Yes.
here. And did you stay there while you were being educated?
Yes.
What kind of a program was that? How long was it?
It was 10 or 12 weeks.
And what do you mean? Is that where you obtain your skills to apply as a police officer?
Yes, it was a hands-on training. I had the college education, the book knowledge, and then I went there for my skills program or my hands-on apart from getting my license.
After this program, did you go out and try and get a job in law enforcement?
Yes, I did.
And were you successful at first?
Yes.
Well, did you have a job at Anoka?
Yeah, I worked at the Anoka Metro Regional Treatment Center because I graduated in January. I'm sorry, in December, I couldn't go to skills until the next summer, so I got a job.
All right, so, but you worked skills, you were in Alexandria, correct?
Yes,
And the job you got was at Anoka State Hospital?
yes.
No, that was between your skills? Say that again.
So
Slowly.
I got hired there in February, and I worked for a year on a calendar year. But the Anoka City Police Department would allow their students to, or their employees, I'm sorry, to go to skills and still have a job on weekends or when they would get back before they got hired as a law enforcement officer.
So at Anoka State Hospital, what did you do?
I was a security officer.
And Anoka State Hospital is basically a detox center now, is that right?
No, it had a detox. It had a countywide detox and a detox program. It also had drug and alcohol abuse rehabilitation and mental illness.
And what did you do there? You're in security?
Yes,
Does that mean you had to deal with the folks that are staying there, the residents?
yes,
And were you successful in that?
yes.
After working there, where did you go next?
I left there and got hired at the City of Brooklyn Center.
In what year were you hired at the Brooklyn Center Police Department?
1995,
And when were you sworn in?
February the 27th.
Of 1995?
Correct.
Who was that you're swearing?
My mother and my father.
So after you're sworn in, you started working as a Brooklyn Center police officer?
Yes,
And what year was that again?
1995.
So that would be, my math, 26 years before you resigned? Is
Yes.
that a fair statement?
Yes.
When you worked as a police officer at Brooklyn Center throughout those 26 years, did you remain a patrol officer all during that time?
I did.
And why was that? Why didn't you attempt to go up the ladder like the other officers we've heard from?
I liked my work. I enjoyed working with the community. I didn't want to be in an administrative role.
So she wasn't.
But
a
did
desk
you
jockey.
also, even though you were a patrol officer, you did take part in other programs, for example, the FTO program, right?
Yes, I did.
And that's the field training.
Yes, I was a field training officer for many years.
How many years?
I don't have an exact number, 10 to 15.
And we've learned in this case what a field training officer does. But very briefly, what did you do?
I would get probationers in different stages of their training, either in their first phase, their second phase, their third phase, or their final phase. Usually the primary phase or the first phase and the final phase were always with the same FTO. And then other FTOs would train the other two stages.
And why did you continue to do that for so many years?
I felt that I had knowledge and mentorship that I could help young officers develop into somebody I would want to work with and my partners would want to work with.
There are other programs that you volunteered for or joined while
Yes.
you're a police officer, is that correct?
Yes.
And after you became a police officer, what was the first program that you joined or volunteered?
I became an Explorer advisor for our Explorer post.
And what's an Explorer post? Is that the younger people that are,
Yes, the program through the Boy Scouts of America.
and in that program, you teach them about policing, is that right?
Yes.
And after that Explorers program that you joined, what else did you do as a police officer?
I was on the domestic abuse response team. I was also a crisis negotiator.
Let's stop at the domestic abuse program. How long were you on that? Approximately.
10, 12 years, maybe more, maybe less.
And what did that program entail?
We would respond. So officers would go out on domestic abuse situations or domestic calls. And if there was a victim of a crime or an arrest made or not an arrest made, we would follow up the next day with the victims to see that they were getting the things they needed, like domestic advocates, walking them through getting order for protections if they had questions, and then helping them and checking in with them through the court process.
And did you enjoy doing that?
Yes.
Why?
Sometimes there were great successes and sometimes there were very sad failures.
There's another program that you're involved in, was a hostage program?
I was a crisis negotiator for the parent umbrella of the EOU team, the Emergency Operations Unit.
And what did you do in that?
I was a crisis negotiator.
What does that mean?
We would go out on barricaded subjects, or we'd go out with the SWAT team would be the easiest way to describe it, on warrants. We would respond to calls where there may be people in danger.
And was your job to try and negotiate with the subject and get him to submit to being arrested?
Yes, he or she.
Is that your main job?
No, I was always a patrol officer.
No, I mean, as far as a hostage negotiator, that's what you did.
Yes, I was a crisis negotiator.
And what other programs were you in?
I was on the Law Enforcement Memorial Association Honor Guard.
And what is that?
So the parent is the Minnesota Law Enforcement Memorial Association. They do a lot of work to help survivors and their families make their way through the process of getting benefits after their officer is killed in the line of duty. I was on the Honor Guard.
What did you do being on the Honor Guard?
When I started in 1998, I was on the colors team for approximately a year or two, and then I went to the casket team.
Well, what's the color team?
The color team carries flags.
And the casket team?
We would carry the casket or the urn of the fallen officer and then fold their flag.
And would you be in contact also with the victim or the deceased family?
Sometimes with the family, a lot of times with the chief of police, because I would have to have to give the folded flag to the police chief.
And this was throughout the state of Minnesota?
Yes.
And these were police officers killed in the line of duty
Yes.
or other law enforcement officers?
Most of 99% of it would be killed in the line of duty, or we would do some retiree funerals.
Any other programs you're involved in?
I did a lot of crime prevention work for our police department and other presentations.
Crime prevention presentations?
Yes.
What were those?
I was assigned an apartment complex in the city, and I would meet with management, and we would do some programming for their residents as far as personal safety, locking your car doors, taking valuables out of your cars, just regular safety in an apartment complex. And then I would do some other presentations on robbery prevention for banks in the city.
By the way, when you were doing the carrying caskets for that program, were you aware of officers that were killed in a line of duty by making a traffic stop?
Yes, Sean Patrick from Mendota Heights.
Objection, Your Honor. Move to strike. Yeah.
The objection is overruled. I'll let the answer stand.
During your 26 years as a police officer, did you ever receive any complaints for abusing your power?
No.
Did you ever receive any complaints from the public?
No.
Shocking.
In training, did you attend all the training sessions required by the Brooklyn Center Police Department while you were there?
Yes.
And with respect to gun training, laser training, you attended all those too, right?
Yes, I did.
And did you pay attention?
Yes, I did.
With respect to that, and your approximation, and I'm not asking for exact numbers, but with respect to the training, what would you say the amount of training was for the firearm, for the gun, and the amount of training for the laser? What would be the percentages there?
For the firearms, it would be probably 80%. We spent a lot more time on firearms than we did on TASER.
And tasers didn't come into the being until years after you're a law enforcement officer, right?
Yes, I believe trainers in this courtroom had said 2002 or 2003.
And you started as a law enforcement officer, what year?
1995.
With respect to tasers, did I say lasers? With respect to tasers, there's been evidence in the case that you
Phasers.
had a Taser 7, is that correct?
Yes.
And the evidence in that was that the Taser 7 was shaped like a gun, fair statement.
Yes.
And the Taser 7 had a dark black, or at least a dark handle, and a dark top. Remember that? I'm trying.
The objection is overruled. You may answer.
Yes.
The Taser that you received, was it approximately a month before April 11th that you received this Taser? Do you remember?
In the courtroom, I was told I received it on March the 26th.
Okay. And also, while we're there, with respect to these tasers and testing them, the rule that we read said should test the electronics every day. Is that right?
Yes.
And there is testimony that you didn't test yours a couple days. Is that right?
Yes, that's what I was told.
And do you agree with that you didn't test it?
I don't recall if I would have or wouldn't have.
And was that an important feature for law enforcement officers with new tasers
No.
that never used them since they had them?
Correct.
And while we're there, did you ever use a taser, use it by actually shooting it in all your years career as a law enforcement officer?
I would take my taser out on rare occasions, but I don't believe I ever deployed it.
Okay, when you take your taser out, it's to de-escalate what is going on. Is that a fair statement?
Sometimes, or to prepare for what might be behind a door. Sometimes an officer has a gun and sometimes an officer has a taser out.
All right. And now the taser that was switched from you, did that go to one of your partners, that taser?
My old taser?
Yes.
I believe they were just put in storage at the police department.
And those tasers were all yellow, right? The
Yeah.
handle, the top, the whole thing was yellow.
Yes, except for the battery pack. I believe that was black and there was some
Okay.
markings on the side.
I'm going to show you these tasers. Show you this taser.
Yes.
I'm glad he's doing this. I thought he would have done this earlier, frankly.
I wonder what she's going to object to here.
So people in the chat were asking about leading questions. Why are they using leading questions? Look, on direct exam, leading questions for laying certain foundation are typically allowed by the court because it cuts down on a bunch of needless rambling stories.
It's just
And
more
then-
efficient.
And then leading questions here in this part, what he's doing is recalling prior testimony and other facts that are in the case that she was present for. She's a unique witness because she's sitting there at the table the entire time. And so he's leading, but he's leading to fact recall from a specific thing that's on the record in the court. So it's not like he's leading her down a narrative. I mean, he kind of is, but he's not doing it openly. He's doing it constrained by the evidence that's been presented. So if you're wondering why their leading questions are allowed here, that's your answer. But okay, Andrew, can you talk about what's going on with the taser? You said you thought he would do this sooner. So what do you mean by that?
Well, he's verbally talked about how the newer taser has a lot more black on the surfaces that you would see with your eye if you were holding it out in front of you. But he only did it verbally. He never actually showed a photo of them next to each other or held them up next to each other. And I think it would be much more compelling. One's completely yellow, but the new one's not.
Right. Which makes no sense to me.
Yeah,
Except
I mean, in
for
the
it
new one,
looking cool.
it's the top and the grip of the gun. So it's really the portions. I would think, I've never held a Taser 7 in my hands, but I would think it would be conducive to not observing as much of the yellow color as you would have with the previous model Taser, which
Right.
could contribute to this action error.
And that's and you know, stuff like when you're saying you're leading about the top of it being black. I mean, it's such a minor descriptive detail, and you're going to be able to see it in a second that leading is inconsequential.
And it just makes, if it's merely going to make for a lot more work and time, then judges don't like it.
Right.
Right. The real question is, what are they going to object to about this? Like,
All right, the objection is sustained.
Ooh.
Okay, well, Do you specifically remember your old taser? By that, I mean the one before the 7 being all yellow.
Yes.
And was that an X26 taser?
And I believe it was an X26P.
P? So
You had a line of questions with that one.
with respect to the tasers, there's been evidence about
Surprised she didn't write it
signing
in.
some
It's all been
forms
seen by
and
the jury.
warnings. Do you remember signing those forms?
In our annual training, we would be handed a form to sign, and I would sign it.
And
So she
do
didn't
you
read it.
remember the warnings on them at all?
Not from those days, no.
And with respect to weapons confusion, was there ever any training, actual training about weapons confusion as you remember it?
No.
Did you even know what weapons confusion was
Yeah.
before? Wait till I finish the question. Before April 11th?
It would be mentioned in training, but it wasn't something we physically trained on.
And by that, you mean what?
There was no training on weapons confusion. You wouldn't be set in a dark room and told to grab which weapon.
So I'm going to go now to April 11th, 2021, a Sunday. And you surely remember that day. Is that correct?
Yes.
And
Here come the tears.
you were an FTO that day for Officer Lucky.
Yes, I was.
And that day, what time did you go on duty?
6 a.m.
And was Lucky on duty at that time too?
Yes.
At about, what did you do during the morning? If you remember, did you just do drive around police work?
We just did police work. We would have checked a squad car if we wouldn't have had calls right away.
It was a Sunday.
It was a Sunday.
So approximately around 2:00, did you pull up in back of, or not you, Officer Lucky was driving the car, right, the squad?
Yes.
And you were the FTO. Where were you seated in the car?
In the passenger seat.
And tell the jury what you remember about first seeing the white Buick on that day, approximately 2 p.m. And
I
talk
would-
slowly.
Officer Lucky and I were driving south on Zane Avenue North. We were talking about pursuit policies, doing some regular FTO training, and he observed a vehicle in the turn lane with a blinker on inappropriately.
And was that the white Buick?
Yes.
And did you have a conversation with him about that?
Yes.
And what was that conversation?
We discussed a little bit of suspicious activity. He noticed a pine tree or air freshener hanging from the rearview mirror, and the tabs were expired.
And did you stop that vehicle?
Officer Lucky wanted to stop the vehicle, yes.
And let me ask you sort of a hypothetical. If you had been working alone that day on Sunday afternoon at 2:00, would you have stopped the vehicle for?
Objection, relevance, false speculation.
I can't even finish the question, Your Honor.
All right.
That's not fair.
The
It's simply, they know how to try a lawsuit, I would
Okay.
think.
The objection is overruled. You may answer.
Let me answer the question, damn it.
Earl's so good. He still
My
hasn't
question was, if you weren't with a field training officer that day and you were on patrol alone, would you have stopped that vehicle?
Most likely not.
And why not?
An air freshener to me is not, it's just an equipment violation. And during the COVID times, the high COVID times, the Department of Motor Vehicles was so offline that people weren't getting tabs, and we were advised not to try to enforce a lot of those things because the tabs were just not in circulation.
Okay, but you did stop the vehicle, right?
Yes, part of field training is that my probationer would make numerous contacts with the public throughout the day.
And what happened after the stop? Or if you remember, go ahead.
Before Officer Lucky stopped the car, he ran the vehicle, confirmed that the registration was expired and that the registered owner had a petty misdemeanor type warrant for some type of drug offense.
And that was the registered owner of the vehicle.
Yes,
So after you did that while you were still in the squad car and not,
yes, it's part of the multitasking that a probationer will have to do is run a vehicle license plate, call into dispatch, and initiate their lights.
okay, and try and talk a little slower. I know you're probably nervous, but I'd like to get all this in. All right.
Yes, sir.
Okay, so you stopped the vehicle, is that right?
Officer Lucky initiates the traffic stop.
And what happened after he did that?
The vehicle stopped kind of in an entrance to the church on 63rd, and he got on the PA and told the vehicle to pull ahead just a short distance.
Was that because he was parked in the driveway of the,
Yeah, and I think there was a vehicle trying to come out, as I recall.
okay. What happened next?
Officer Lucky and I exited our marked squad car. Officer Lucky walked up to the driver's door, and I stood at the right rear corner of the white Buick.
So you did get out of the car.
Most definitely.
And why did you stand where you were standing?
Part of it was so I could see where Officer Lucky was, and to provide cover to see what else was in the vehicle.
In your experience of 26 years and being a patrol officer all those years, is stopping any vehicle at any time that you don't know, does that be considered a dangerous situation?
Yes.
Why?
Sometimes there's guns in the car. Sometimes there's uncooperative people. You don't know who you're stopping.
Yeah, that's because you don't know, right?
Right.
So while you were standing there in the rear of the vehicle, did you hear what Officer Lucky said?
I could hear parts of the conversation. He didn't seem to be in any distress when he was asking questions. He took out his notepad, and it looked like he was writing down something which would end up being a name and date of birth.
Okay, and after he did that, did you two go back to the squad car?
Yes.
And at some point in time during the stop or right after it, did Officer Lucky do anything in connection with obtaining another squad car?
Yes, he called for a second car to come.
What is that about? What?
It would just be a backup officer. The registered owner had a warrant of some nature. It wasn't a bad warrant. It was just a regular petty warrant, which would still, you'd want a second officer. Or I guess in this case, a third officer. Officer Lucky and I are considered only one officer.
And why are you and Lucky just one officer?
Because we're
Because
married.
he's in field training and he's a probationary employee.
Oh, I got it
All
right.
right. So did the third officer, Officer Johnson, arrive at some point in time?
Yes, Sergeant Johnson arrived.
And was that before you looked up in the computer about this driver of the vehicle, or after?
I don't know exactly when he arrived. I know Officer Lucky and I were Officer Lucky and I were discussing running the name he was given through some various systems.
Okay, and did you do that, you and Officer Lucky?
Yes.
Was there any correction that you told him about during this time that he shouldn't have put the name in one?
He had gone to the Minnesota because the driver didn't provide him with any government issued ID. He would have had to verify some information to run him properly in our system through TriTech. So you run them sometimes through Minnesota DVS with just a name and a date of birth. It'll give you a Soundex hit on various people with that either same name or common name with a date of birth.
So did you correct him on that?
We were talking about, I don't know if I corrected him on it, but
So what happened after that?
he would copy the OLN, which is a driver's license number, off the screen and then put it into our TriTech system or CAD, and that would run him through the state for driver's license and warrants and other hits.
And did you find anything about the driver?
The driver came back with a suspended driver's license, gross misdemeanor, bench warrant for weapons, and protection order.
So a gross misdemeanor for weapons ordinance. What went through your mind, if anything, when you read that?
It would be concerning that there'd be a weapon on the person or in the vehicle.
And why would that be?
In my experience over 26 years, I have found guns in cars, either by accident or by them just being sitting out in plain view.
And what about a person with a weapons warrant? Would that-
They're more likely to be carrying a weapon or have a weapon access to them.
So, what about the temporary, was it a temporary restraining order that came up? Was that it? Or-
Yeah, I think they're called ex parte orders. It would be a temporary protection order until the parties would either have a court hearing in front of a judge to make it a permanent order.
And there would be a name of a female on that?
Yes, there was.
And was there a female in the Buick or in the automobile that was stopped?
Yeah, in the front, yes, in the front passenger seat.
So after you learned that, did you also learn something? Did Officer Lucky tell you something about drugs or marijuana?
When he initially got back to the car, he told me there was a obvious smell of marijuana and some seedlings or shake residue on the center console and inside the vehicle.
Okay. So with all of that information, what did you do next?
We told Officer Lucky explained to Sergeant Johnson what was going on. I corrected.
Where was Sergeant Johnson? Was he in your squad car?
He was standing at my passenger door.
Go ahead.
And Officer Lucky was explaining to Sergeant Johnson what was happening and what he wanted to do. Officer Lucky only told Sergeant Johnson that he had a warrant. And I told Officer Lucky that he needed to tell Sergeant Johnson what the warrant was for. A weapons violation warrant would be cause for care and concern.
By the way, none of this
All
is
right.
hearsay
And
because
after
it's being
that
offered for
conversation,
her state
what
of
happened,
mind.
if anything, next?
We got out of the vehicle. Sergeant Johnson was going to the passenger side. And Sergeant,
Excuse me, don't mean to interrupt you. Back up a little, I'm getting ahead of me. What was the plan when you got out of your vehicle with Lucky and Johnson was outside? What was your plan?
The plan was for Officer Lucky to get the driver into custody for the warrant, and we'd further investigate with the female who she was and if she was the petitioner or the subject of the restraining order.
Were you required by policy and law in learning about that warrant to arrest the driver of that car?
Yes, it was an order of the court.
And with respect to the restraining order or whatever you called it, did proper police procedure that you knew of for 26 years required to find out who that lady was?
Yes,
And why would that be?
it's my duty to find out who she is to make sure she's not in harm's way. There's been times when that hasn't happened and somebody has ended up killed
That's a rock.
because that wasn't followed.
So now we're at the Buick. It's a Buick car, white car. Is that
It's a
right?
white car.
And now we're at the white car, and you three went up to it, correct?
Yes, Sergeant Johnson went up to the
Where did
passenger
Johnson
side.
go?
He went up the passenger side to provide cover.
And what does provide cover means?
Keep an eye on the occupants of the vehicle and just to monitor what's happening outside in the world. See if
And-
people are walking up on you or things go wrong.
And where were you located?
I was towards the left rear corner of the car.
And where was Officer Lucky?
He was advancing to the driver's door.
And how, by the way, before this, how long had you known Officer Lucky?
I think we were on our 5th shift.
And he was pretty new arrival, was he? Or,
I believe he was in second phase maybe, but he had been a police officer before.
okay, what does second phase mean?
He wasn't in his initial 4 weeks. He was in the start of his second 4 weeks.
And you testified you knew at least back then that he had come from another police department, correct?
Yes, I think he worked at 2 previous agencies and he was an explorer.
Okay. Now let's go back to when you three arrived at the white car. We've already said where you're located. Officer Lucky was at the driver's door, is that right?
Yes, he would have been standing behind the post between the driver's door and the rear passenger door.
What do you mean by that, standing behind the post?
He wouldn't have been directly in front of the door because that would be unsafe approach.
And this was this a warm day? Was the window down? Remember?
I don't know if the window was down or not.
Okay. But in any event, where were you standing again?
At the left rear corner.
And did you hear what Officer Lucky said?
Yes, I heard him ask the driver to step out of the vehicle a couple of times.
And did the driver step out of the vehicle finally?
Finally, he asked Officer Lucky a couple of times what was going on, and Officer Lucky said he would explain to him.
When he got out of the car?
Yes,
And so did the driver get out of the car?
yes.
And what do you remember happening next?
Officer Lucky had him turn around, and I think he was still asking what was going on. Sergeant
he?
John,
Who's he?
the driver,
Go ahead.
and Sergeant Johnson and Lucky told him he was under arrest, and I told him he had a warrant.
Okay, so who said he was under arrest first?
Sergeant Johnson, I believe.
And Sergeant Johnson testified here. You remember that?
Yes,
And after he said that, did Officer Lucky say he was under arrest too?
yes,
And you heard that?
yes.
And what did you say then?
I told him he had a I told him he had a warrant.
You just said warrant.
I think so.
Did you specify what kind of warrant, if you remember? If you don't,
I don't think I would have. It wouldn't have been in my normal.
okay. So what happened after Johnson and Lucky said you're going to be handcuffed or you're under arrest, and you said that there was a warrant? What happened next?
Officer Lucky had him put his hands behind his back, and I noticed that in the driver's right hand was something. It was paper or something, and I took it out of his hand and had it in my left hand.
And you had that in your left hand?
Yes.
And then what happened next? Why strike that? When you did that, I take it you got closer to the driver?
Yes. I reached into the driver's hand and took out what he had in his right hand. And had it in
Right
my-
hand or left hand?
His right hand, and I held it in my left hand.
Okay. And what happened next?
Officer Lucky started to say something about don't do that, don't tense up, stop doing that. And then it just went chaotic.
What do you remember happening after that?
I remember a struggle with Officer Lucky and the driver at the door. The driver was trying to get back into the car.
Well, he was trying to get back in the car. What did you do?
I went around Officer Lucky as they're trying to get back in the door. I'm between the door and Officer Lucky and the driver. And the driver's getting into the car.
High arousal, tunnel vision, memory
And
loss.
what happened next?
Everything just testified to by the expert.
They're still struggling, and I can see Sergeant Johnson and the driver struggling over the gear shift because I can see Johnson's hand, and then I can see his face.
Here it comes.
And you knew Johnson for many years before this, is that right?
Yes,
And by looking at his face at that point in time, what did you interpret it to mean?
he had a look of fear on his face. It's nothing I've seen before.
Did you say anything when you saw this? What did you do?
We were struggling. We were trying to keep him from driving away. It just went chaotic. And then I remember yelling, "Taser, taser, taser," and nothing happened. And then he told me I shot him.
Tears on cue.
Exactly when you would expect them.
Yep.
I know people are going to be like, "We're so cold," but this is the way it goes when you're at a trial. You got to have prepared for this, and you got to know this was coming now.
Can you proceed or you?
Yeah.
Doesn't even
Fine.
mean it doesn't mean she's acting either. They just have
No.
questioned her like this, and they know this is when
the
she'll cry.
driver said you
Yeah.
shot him, do you remember what you said, or do you? If you don't remember, did you look at the video and see what you said? Or do you actually remember what you said? I guess is my question, not with help from a video.
I don't remember what I said.
And what do you remember next, if anything?
They had an ambulance for me, and I don't know why. And then I was at the station. I don't remember a lot of things afterwards.
Do you remember saying something about prison?
No.
If you did say that, do you have any idea now why you would say that?
No.
Was the climate back then about police officers a little rough?
Objection, Your Honor.
The objection is sustained.
All right. You don't remember saying it,
No.
and you don't know why you said it.
No.
Do you remember the response that our Sergeant Johnson or Major Johnson gave you?
No.
And when next do you remember what happened, if anything, if you remember?
I remember getting an ambulance, and then I was at the station.
Okay. And you remember being in the ambulance, arriving at the station?
No.
You don't remember the
No.
station?
I remember getting to the station.
Once you got to the station, do you remember what happened next?
The next thing I remember is Officer Fricky was in the room with me
And where were you located? Do you remember that?
in the front office.
Okay. In the front office room, do you remember, were you sitting down, standing up?
I was on the floor.
And after that, at some point in time, did your husband show up?
Yes.
At what time do you believe, from back there, April 11th, at what time do you believe that your memory came back to you?
Probably when my husband got there. So much of it is missing.
After that night, and for the last few months, have you been in therapy?
Yes.
And did you still work as a police officer there?
No,
Did you quit?
I did.
And this was your career?
Yes.
And when did you quit?
A day or two after the incident.
And why did you quit?
There was so much bad things happening. I didn't want my coworkers, and then I didn't want anything bad to happen to the city.
And did you own a home in Anoka or Hennepin County at the time?
Yes.
You and your husband?
Excuse me,
The objection is relevant.
the objection is overruled. Please.
Did you own a home, your family home, for years past?
Yes.
And did you sell it?
Eventually.
Before you sold it, did you move out of the state?
Yes.
And you now live out of state?
Yes.
We have a moment, Your Honor. Thank you. I'm done, Your Honor.
Here comes the cross.
Yeah, this is where the money's being made at right now.
Oh, Aaron Eldridge is going to do the cross.
Oh
Okay.
boy.
Smartest move,
Yeah.
in my opinion. You can't have Frank or Larson, badger her down.
Yeah, but Aaron is also going to come off as a.
Say it.
It rhymes with witch.
Oh, I was thinking of a
A
different
Nintendo Switch?
Yes.
Good morning, Ms. Potter.
Good morning.
You've been a police officer, we're a police officer for 26 years. Isn't that
Yes.
right? You said you started in 1995,
Yes.
and that was with the Brooklyn Center Police Department for that entire career, right?
Yes.
And you said that you resigned from the Brooklyn Center Police Department, right?
Yes.
And that was on April 12th of this year, right?
Yeah, within a day or two of the incident.
Right after you had shot and killed Dante Wright.
Yes.
And
She's
throughout
gonna
that
say that
time
a
period,
lot,
you
I
were a
bet.
licensed peace officer, right?
Yes.
And to become licensed, you had to go through a number of requirements. Fair?
Yes.
You had a college degree.
Excuse me, Your Honor, the prosecutor speaking to that mic too.
Sure.
Thank you.
You have a college degree, right?
Yes.
And you also had to complete the peace officer education program. That's that skills component that you talked about.
Yes.
And that included skill sets and classroom training as well.
Yes.
You had to pass an exam to become an officer.
Yes.
And then you did all that before you started with the Brooklyn Center Police Department in 95, right?
Yes.
And then you got your license through the post board, correct?
Yes.
And that stands for Peace Officer Standards and Training.
Yes.
So you were licensed throughout that whole 26-year career, right?
Yes.
And you maintained all of the requirements to keep your license,
Yes.
including all the training that was required for it as well, right?
Yes.
And that training that's required for your license has all different kinds of components, true?
Yes.
You have things like use of force, use of firearms, tasers, all kinds of things.
Yes.
And you did all that training
Yes.
Taser,
And you did all
tasers,
that
specifically.
every year throughout that 26-year period, right?
Yes.
Sometimes multiple times a year, right?
Yes.
And all of those requirements were in place to make sure that you were at the beginning of your career and continued to be, competent and capable of performing the requirements of the job, right?
Yes.
You mentioned on direct that you were also a hostage negotiator as part of your duties, right?
Crisis negotiator.
Crisis negotiator. Did that involve some hostage type situations?
I've never had a hostage situation.
Okay, but crisis negotiation.
Yes.
And that involved some de-escalation tactics, I presume, correct?
Yes.
And you had to develop that skill set and be pretty good at de-escalating situations as a crisis negotiator, fair?
Yes.
So you had some experience in stressful situations doing that.
No.
So you were a crisis negotiator, but never experienced a stressful situation?
We talk to people.
Talk to people in crisis.
Yes.
And part of your job as a police officer is dealing with people on their worst days, right?
Yes.
People who don't want to cooperate with you sometimes, right?
Most of the people we talk to in crisis are either barricaded behind a door or talking to you from another room.
Okay. For 26 years, you were a patrol officer, right?
Yes.
So you saw people out on the street every day as part of your job duties. fair?
Yes.
And you talked about doing a lot of traffic stops during that career, correct?
I did some traffic stops.
Okay. Well, in some of those cases, there are people who have weapons, right?
Yes.
Sometimes people want to flee, right?
Yes.
Sometimes people are violent.
Yes.
And all of that's part of being a police officer, dealing with people in those situations, right?
Yes.
You'd agree that you're bound by policy and the requirements of the job that Brooklyn Center, the police department, sets for you, right?
Yes.
And you heard Commander Fleslin testify, but you had to acknowledge those policies and essentially agreed to abide by them every year you were an officer, fair?
Yes.
And you'd agree that your fundamental duty as a police officer is to safeguard life, right?
Yes.
And you also have the duty to never employ unnecessary force. True?
Yes.
Part of the policy also includes some of your responsibilities as an officer, right?
Yes.
And that includes being alert and attentive and capable of performing your job, right?
This is what they taught her to
Getting
do, to
back
not
to
have bad words
the
slip out.
training
To
and
stick to yes,
requirements.
no,
There's a lot of
as much as
training that
possible.
goes into being a police officer. Fair.
Yes.
To mitigate those
and
other
we
two
talked
risks
about a
we
couple of
talked about
those
putting
things,
your
but one of
client on the
those
stand.
subjects is use of force, right?
Is that a yes?
Yes.
And use of force can include things like restraints, handcuffs, defensive tactics, chemical irritants, using batons, tasers, less lethal weapons, and firearms as well, right? All those things are options available to you. True?
Not all of them.
Okay, well, you carry a whole number of things on your duty belt every day, right?
Yes.
And that includes a firearm and a taser, right?
Yes.
And you also had other items on that duty belt as well, correct?
Yes.
And as part of the training that you went through every year, they cover topics of all kinds of uses of force, right?
Yes.
Including the things on your duty belt and maybe other options that the department could use additionally, true?
Only the things I was assigned on my duty belt.
Okay. But in any case, that use of force training was a pretty key component of being an officer, right?
Yes.
You were trained about when you could use force, how much force to use, and what would be appropriate force. Fair?
Fair.
And not only were you trained on that, but you had a lot of policy that that dictated what you could and could not do in a particular situation, right?
Yes.
And you were also trained on the readiness aspects of use of force, right? Being ready to engage whatever force might be required, right?
Yes.
Including making decisions under stress, right?
What do you mean?
Well, you had a lot of scenario-based training, right?
Yes.
And in those situations, those scenarios were set up to be as close as they could be to real life, right?
I suppose.
So you would be trained to have to make decisions in the moment about what to do and what force to use, right?
Well, it was a training situation, so it was usually slow and meticulous and controlled.
Well, you did this year after year, right? For the entirety of your career, correct?
I think scenario-based training started later, probably the last 10 or 15 years.
Sure. But use of force training has been around for a long time, right?
Yes.
Because since you started as a police officer, you have, in some cases, had to use force. True?
Yes.
And there are limitations on how and when to use that force, right?
Yes.
So you've had training on that throughout your entire career, right?
Yes.
And as part of that process, the way that it's required for you to maintain your license is that you sign in and you sign off on attendance forms, and you basically, you have to be there, right? You can't not be there, right?
Right.
And every year you have a certain number of training hours that are required, right?
Yes.
And you said on direct that you participated and you were paying attention during all those trainings, true?
Yes.
And some of those trainings had classroom instruction, PowerPoints, things like that, right?
Yes.
Some of them also included reviewing policies and other documents, right?
Yes.
And then there was also the hands-on training with the practical components, things like using drawing weapons, things like that, right?
Yes.
And over the course of your career, you completed many, many, many hours of training, right?
Yes.
Would you say you were trained?
And in terms of credit hours, we're talking somewhere in the ballpark of 1,700 credit hours. Does that sound right?
I don't know the number of hours, but if that's what you have, that would be probably right.
No reason to dispute that your training hours would have been in the thousands of hours over that 26-year career, right?
Yes.
You indicated that there weren't tasers available
Less than
when
100
you
hours
first
a year,
started
though.
at Brooklyn Center. True?
No, they came in the early 2000s.
Okay. But in 1996, you had a firearm, right?
In 1995, yes.
Sorry, 95, and then you were sworn in 96, right?
No, I was sworn in February 27th, 1995.
Okay. So in 95, when you first started, you had a firearm available to you.
Yes.
And you were trained to use that firearm.
Yes.
Trained how to handle it, right?
Yes.
Trained how to load it and unload it.
Yes.
Trained how to draw it,
Yes.
right? And fire it. And how to safely handle it. Yes?
Yes.
And that included when not to fire it, right?
I suppose.
And that training started at the beginning of your career, you said in 95, but continued every year up until the time you resigned, right?
Yes.
Now, you indicated that tasers came later, but you were first trained on using a taser in 2002, correct?
If that's what the documents say, I'm not sure when they came out.
And if the documents say you were trained in 2002, you then would have been trained every year thereafter, right?
Yes.
And you started carrying a taser on your duty belt regularly as of 2005, right?
Yes.
But at a minimum, in addition to all the other training you had, you would have had taser training year after year for at least the last 19 years, right?
Yes.
And the taser training that's required, you saw the documents that were in court, also requires not only it requires review of policy, right? The taser policy, right?
Yes.
And it also requires practicing those reaction side draws, correct?
Sometimes.
All right, if we could put up exhibit 334, please, the last page.
Oh, don't hit us with the policy again, please.
I'm gonna
Dear
promise you
God.
it's already been admitted.
You know it's coming.
334.
Karen from HR is going to bring the policy,
The
Nick.
very last page.
Would you agree that this is
and
an illustration of you
highlight
shooting
the,
Dante Wright in cold blood?
Subsection C, please.
Can you reenact
So,
shooting
as
Dante
part of
Wright
the
in
taser
dance
policy
form?
includes that all training should include performing reaction hand draws or cross draws to reduce the possibility of accidentally drawing and firing a firearm. That's part of the policy, right?
That's what it says.
And that's part of what you're trained to do, correct?
We didn't always we aren't always drawing our tasers from our holsters. A lot of times we were in plain clothes during training.
Okay. Well, your policy that you're required to abide by, that you signed off
She's
on,
not the trainer.
requires that you perform
Exactly.
reaction hand draws. True?
No,
During
not
the training, yes.
It also includes the reason for that, right?
Yes.
And that's so that you reduce the possibility of accidentally drawing and firing a firearm, right?
Yes.
Yeah,
And
that word reduce, though, is a big word.
Yep.
part of the reason for that
It doesn't
is
say it stops it. It's just can
weapons
reduce it.
confusion, right?
Yes.
And that was known in the field and has been known for a number of years. True?
I guess.
Well, you were trained on it, right?
We talked about it.
It was part of your PowerPoints, correct?
Yes.
You were made aware during PowerPoint after PowerPoint after PowerPoint that drawing and firing the wrong weapon can happen, right?
We were told it wasn't something that they expounded on.
You were told that.
Yes.
And you signed documentation every year you were certified, acknowledging that you knew the risks, received and reviewed the materials required for you to carry that taser, correct?
Yes, I signed the document.
I don't think this is the nail that they think they're hammering.
No.
Now, in terms
Conviction
of
by PowerPoint.
weapons,
That's their case.
You were told
reaction
over and over
side
that the mistake you
means
made
what
could happen.
for you?
That'd be my left hand.
Okay, you're right-handed.
Yes.
So carrying a taser, you have done for years on your left side, correct?
Yes.
And your firearm you carry where?
On my right side.
How many years have you carried your firearm and your taser that way?
My firearm for 26 years and my taser according to your documents for 19.
So as long as you've had that taser, you've carried it on your left side, correct?
In the beginning, I carried it on my right side in a drop holster.
And when did you switch?
When we were given new holsters,
And when would that have been?
I don't know.
Okay. But far before 2016, you saw the images that were up in court. Long before that, you were carrying your taser on your left side, correct?
Yes.
Years and years, right?
Yes.
But the expert testified you go back to the first training.
Yeah. That's the slipping capture. You go back to your original training.
We talked a little bit about reality or scenario-based training. When you go through those trainings, you have available to you all the options that would be on your duty belt, right? Although inert for the purposes of training, right?
Yes.
That's not true, but
No, that's not true.
no,
And
it's
the
not.
purpose of that training is to try to recreate real life stressful situations as best as possible to practice making those types of decisions in the moment. Fair?
Fair.
Let's talk a little bit about your taser. You'd agree that the TASER 7 that you have and the TASER you had before that has a safety mechanism on the side of it, right?
Yes.
And you have to flip it up to arm the TASER.
Yes.
And when the TASER is on and armed, it beeps, right?
I don't know if it beeps.
There's a display screen that turns on.
Yes.
And then there are two lasers with the TASER 7 that appear on your target, right?
Yes.
A green one for the top probe, right?
I believe so. It was a new taser.
And a red one for the bottom.
I would guess so, yes.
Well, you were trained on it, right?
Yes, but it was a while back.
Well, you were
Been a while.
trained in March of this year on that TASER, correct?
Yes.
That was a
You
while
have
back.
to successfully operate and handle that TASER in order to be certified to use it, correct?
Yes.
And you went through that hands-on process of turning on that TASER and safely handling that TASER in order to be certified, correct?
Yes. In March.
In March. And before that, you had had an X26P, correct?
Yes.
And that TASER also had a laser and a safety and things like that, right?
Yes.
The screen that turned on.
Yes.
And the TASER, and that was the TASER that you had been carrying for years before, right?
Yes.
Very similar to the TASER 7 in that way.
Similar but different.
All right, so I'm going to put on the screen
Good answer.
next to each other, please, exhibits 210 and exhibit 212.
Again, in court, it sounds really easy to say, do you remember what training you did in March when it's December? But in reality, it's not that simple to remember what you did, what,
Now, this
8
is a
months ago.
picture, side-by-side pictures of you on April 11th, correct?
Yes.
And your TASER is pictured on the left side of your duty belt, correct?
Yes.
And that's the way you'd been carrying it for years and years, correct?
Yes.
And your firearm you carried on the right side of your duty belt, right?
Yes.
And you'd agree that the standard procedure for a reaction side, left-hand draw for your TASER in this case, would be to draw that weapon with your left hand, correct?
Yes.
All right, you can take that down. You were asked some questions on direct about spark testing, the function test of the TASER. The policy says that you should do that before the beginning of every shift, right?
Yes.
And you didn't do it the last 2 shifts that you worked, correct?
That's what the documents say.
Right. You didn't do one for the last 4 of your last 10 shifts that you worked, in fact, correct? That's what the documents say.
Which dates?
You didn't do it on March 27th, correct?
I guess.
You didn't do it on March 28th.
Your Honor, object to this cross-examination if she doesn't know. She should
All
know.
right, okay.
She should have
Okay,
known.
one word objections, please. If she doesn't know, she can say she doesn't know.
If the documents show that you didn't do a spark test 4 of your last 10 shifts, you have no reason to dispute that, right?
No.
And the day of this incident on April 11th, you didn't do a spark test that day, right?
No, according to the documents.
And even though, that day was a slow and uneventful day at the beginning of the day, right?
I don't know. I don't have a log.
Well, you told Dr. Miller that that day started as a slow and uneventful Sunday, right?
I don't know if I did or not.
Council Sligo.
Man, she just looks angry. Like the prosecutor, like she does not look good. I mean, I said in the chat, but I'm convinced that, I know you guys think it's like woman on woman, but I think Rugrats or my uncle over there could do a better job. Like, I really do. I don't think she's doing a good job of this. And I don't think, and guys, I do not think a woman that needs to necessarily be there for a woman. I don't agree with that necessarily. So
how progressive of you.
They're playing the averages. They're obviously playing the averages. You'd rather a woman be beating up another woman than a guy beating up a woman. It's just the optics of it. So
yeah, the problem is they shouldn't have had her beating her up from the start. They should have had her build rapport and empathy from the start. And then you subtly move into beating her up to the point where she doesn't realize she's being hit.
And who else is going to do it? You can't have Larson do it, right? He'll be throwing pens across the courtroom. You can't have, Matthew Frank just puts the whole courtroom to sleep for 4 hours.
Yeah, I mean, what about the other guy back there? Get him up to try. Give him a swing at the plate.
I think that might be the research team, the people behind back on them, that they're research people. They
should have had Ellison come up and do it. That would look really good right there.
Keith Ellison probably hasn't been in a trial in how many years?
Yeah.
the guy tells everybody else, you go do it.
Continue.
But his name is on this trial, right?
Yeah, he made an appearance at the first day of voir dire.
All right. So April 11th started as a slow and uneventful day, right?
I guess it's a Sunday.
Okay. I'm going to put on the screen exhibits 224 and exhibit 178 next to each other, please.
They should have told her not to fight. Of course, yeah, Sunday. Yeah, Sunday's an uneventful day, right? You don't try to win on every question.
Get her to agree.
Yeah.
Build rapport.
All right, Ms. Potter, on the screen are exhibits 224 and 178.
A sleazy one.
You'd agree that these are photos of your taser and your firearm, respectively, yes?
My firearm for sure. I'm not sure if that's the taser that was taken that day, but I'm guessing it is.
And you carried a taser 7 that day, correct?
Yes.
And that's what's in this picture, exhibit 224?
Yes.
She can identify her firearm specifically, but not the taser. That's weird.
Items look different, don't they?
Yes.
Your Honor's argument.
The objection is overruled. I think you answered. Did you answer? You may answer if you didn't.
Yes.
Interestingly, Earl
Just to
Grey
be more
wasn't allowed to
specific,
show her pictures of the taser.
The taser is
Yeah,
yellow.
that's really
correct?
weird.
Yes.
The firearm is black, correct?
Yes.
The taser weighs about half as much as your loaded Glock, right?
I don't know.
Doesn't weigh the same, correct?
Well, I want to know.
I don't know.
Testified too early, but I don't know.
When it comes to the Taser 7 that you had just been recertified on or certified to use, your department used long-range cartridges for that Taser 7, correct?
I don't know.
You were trained to use it, correct?
I don't know now. I don't remember.
You don't remember being trained to use the Taser 7 at all?
No, I remember being trained, but I don't remember today what cartridges we were issued.
Okay. So you went out on the street with a taser, not knowing what that taser did?
I would assume that on the day I worked, I would know, but I don't know. It's been months now.
Okay. No reason to dispute that the Brooklyn Center Police Department used long-range cartridges in the Taser 7, correct?
No.
And the reason to do that would be so that you could fire at a farther distance with your taser, and you wouldn't need to approach someone up close, correct?
I don't know. I would assume so, but I'm not positive.
Well, that's why someone would use a long range cartridge as opposed to a short range cartridge, correct?
Yes.
And you've been trained on tasers since 2002, correct?
Yes.
You know
Put
how
on
they
a
work,
cartridge is,
right? And you know
Yes.
what they do.
yeah, doesn't mean you train
She
on a
actually was
cartridge.
only trained on one of the
Can
cartridges
we
that's
take
on
those
the
down, please, and
document.
put up exhibit
Yeah.
The long range
213?
cartridge.
She
It's
might
a
not.
weird hill to fight on.
Yeah.
I don't know.
They're trying to
enough
make it
about
seem like
tasers.
it's not. It wasn't a mistake. In other words, they're trying to say she should have known that she pulled the gun.
Okay,
Well, she should have known.
14 that's been admitted
I mean,
on the screen.
I don't think that's in dispute, but that doesn't get you to
The picture of
reckless.
Your duty belt.
Mm-hmm.
Yes.
You'd agree that the holsters for your taser and your firearm are different, correct?
Yes.
And your firearm holster is empty in this picture, right? There's no firearm in it.
Correct.
Is that this right here?
Yes.
The taser holster, it's made of plastic, right?
Yes.
You have to push a button, this button right
And
here.
the whole point
rock
is she
back
didn't
to
know.
Get it out of the
Yeah.
out of the holster, correct?
If you didn't
Yes.
know, it's not reckless.
Your gun holster is made of leather, is that right?
Yes.
And it has a little snap. Is that right?
Yeah. Yes.
And how does that gun come out of that holster?
With a hand.
Smooth like butter.
It would rock forward.
How do you pull it with your hand out of your holster?
It would rock forward and you would pull it up.
Okay. And the taser, on the other hand, you would press the button, rock it backward, and pull it up, correct?
Yes.
All right, if we could take that down, thank you. Now, you testified that you have never deployed your taser or your firearm while on duty out on the street, correct?
Not that I recall. I know for sure my firearm.
Okay. But you have drawn your taser multiple times while on duty, correct?
Several times.
And you said that you did that as a way to de-escalate. I believe that was your testimony on direct.
Yes.
And approximately how many times did you pull your taser but not deploy it while on duty?
For de-escalation, maybe a few times.
Now, there are
For 5
times
years or
that
so.
You pulled your taser and didn't deploy it. One was in 2013, correct? No reason to dispute that it happened once in 2013, at least.
I would guess no reason.
There was a situation where one of your colleagues, a former officer, was hanging on the back of an individual, and you pointed the taser at him, but didn't tase him because you would have tased your fellow officer. Is that right?
If it's the one I'm thinking, yes.
And instead of
She was on his back.
deploying your taser, you called for extra help, correct?
Yes, and we'd probably continue to fight with him.
You never deployed your taser then.
No.
There was another incident in 2016 where someone was not complying with commands to place them under arrest, right?
I don't know what event you're talking about.
Well, in this case, there was an individual who was struggling, a female individual. She didn't want to get in handcuffs, and then one of the officers took her down to the ground by force, correct? And you pointed your taser but didn't deploy it, right?
If that's what the documents say. I don't recall the incident.
Okay. But you recall that you have drawn your taser and not fired it in your 26-year career.
Yes.
All right, I'd like to talk a little bit more about April 11th. So on April 11th, you were serving as an FTO, right?
Yes.
And you said that you have done that for 10 or 15 years.
For many years. I don't remember when I got certified, but it's been many, many years.
Okay. And you said that on direct, I believe your testimony was that you had knowledge to impart and that mentorship skills that made you suited for that job, right?
Yes.
So you were serving as Officer Lucky's FTO on April 11th. How long had you been his FTO?
I believe it would be 5 shifts. It would have started the Monday after Easter Sunday.
Okay. But you were essentially in a supervisory position, right? Serving as his FTO.
Yes, I guided him.
It's a big responsibility, true?
Yes,
You have to be a good example, sort of set the stage for what a good police officer should do in any particular situation, right?
yes,
And to do the job of an FTO, you have to be really familiar with policy and training and proper uses of force, right?
yes,
And you have to make sure that someone else is doing it all right too, right?
correct.
And you testified that that morning, the morning of April 11th, you reviewed pursuit policy with Officer Lucky, correct?
That afternoon.
Okay. But that pursuit policy includes not shooting at the driver or occupants of a vehicle, right?
A moving vehicle.
And you told Officer Lucky, we're not in the city, right? Did you tell Dr. Miller that you told Officer Lucky in reviewing pursuit policy, you used the phrase, we're not in the city?
Because we're on Zane Avenue, which is in Brooklyn Park.
And why did you say that?
To remind him of geographical boundaries.
And you were also reminding him of the limitations of the pursuit policy, correct?
What do you mean?
That you can't just get into a high-speed car chase or shoot up a car without specific reasons, right?
Yes, for our pursuit policy limits what we can pursue for.
And a gross misdemeanor warrant doesn't qualify for a vehicle pursuit, right?
Not according to our policy.
And you had just reviewed that policy with Officer Lucky that day, correct?
Yes.
So getting to what happened with the stop, you said that there was a turn signal misplacement, perhaps. You saw the wrong turn signal. That was the first thing that you saw?
Officer Lucky saw it first.
Okay, so you didn't see the wrong turn signal. But after that, you saw the air freshener, right?
I saw the expired registration.
Well, you had said on direct that you would not have pulled that vehicle over, right?
Probably not.
And you said that you knew that there had been some delays because of COVID with people getting their tabs up to date, right?
Yes.
But you also mentioned the air freshener to counsel on direct, didn't you?
Yes.
But regardless, expired tabs, air freshener, this is the kind of traffic stop that it's pretty routine for you in your 26 years as a cop, right?
No traffic stops routine, but it would have been something I would have done several times.
I'm sure you've seen lots and lots of cars with air fresheners and expired tabs. True?
Yes.
How many of them had warrants
And then
and
the
felonies under
decision
their
was
belt?
made to pull over the car. You mentioned that there was some information that maybe there was some other warrant that you learned about around that time. You didn't discuss any of that with Officer Lucky, did you?
He would have had the same warrant hit that I would have heard.
None of that was mentioned. None of it was even worth discussing with Officer Lucky at the time you pulled over the car. Fair?
I don't remember if we talked about it or not.
He already had
But
grounds
in
to
any
pull
case,
over
you
the
pull
vehicle
over the
anyway.
car, and Officer Lucky approaches the driver's side, approaches Mr. Wright, right?
Yes.
And he came back to the car with a name, date of birth, all kinds of information, right?
I know a name and a date of birth.
Well, Officer Lucky told you that he believed him. He thought that essentially that Mr. Wright was telling the truth, right?
Yes.
And then when Officer Lucky put in all this information into the system, you corrected him, you admonished him, you told him he was doing it wrong, right?
I told him better ways to do it, probably.
And that's your job as an FTO, right?
Yes.
To correct him if he
You
messes something up,
admonished him.
right?
Yes, when there was an opportunity.
So you
She
corrected
chose
him.
that word.
He re-entered the information, and then you found out about the warrant, right?
Yes.
Now there was also a conversation about Officer Lucky code 4ing himself, right?
Doing what?
Code 4ing
Oh,
himself.
code 4ing, yes.
And did you also correct Officer Lucky for doing that?
He did it before he ran the driver, and he shouldn't do that.
And you told him that, right?
Yes,
Don't code 4 yourself before you have all the information. Something to that effect, right?
yes.
Did you do that
And again,
because
that was
you're
your
a
job as
racist?
the FTO to correct whatever he was doing that was wrong, right?
Yes.
So you got this information and then made this decision to go arrest Mr. Wright, correct?
Yes.
And you didn't talk about going out there with guns drawn or anything like that. You didn't talk about using force on the approach or anything like that, right?
No.
And then Officer Lucky pulled or asked Mr. Wright to get out of the car, which he did, right?
Yes.
And you stood back and watched this happen, correct?
I was just a couple feet away.
Okay. But you didn't correct the way that had happened. You didn't tell Officer Lucky to move or to put Mr. Wright somewhere else, right?
I wouldn't do that to a rookie in front of a suspect.
Okay. But you didn't do it regardless. Didn't happen.
No.
And then as you approached and got closer, was there a moment that you got closer after things didn't quite go the way you had hoped they would go?
I got closer before that happened.
Okay. And you'd agree that you unsnapped your gun holster as you approached, right?
No, I wouldn't agree to that.
All
You
right,
made
if
that
we
up from a
could
video.
Mm-hmm.
Put on the screen Exhibit 12, just the still image at 2:01.
Of course, just a still
You
image.
touch the top of your holster all the time, folks, just to make sure
And
everything's
zoomed in
okay.
on, yes, the squad car view. You see yourself in that picture,
Yes.
and you see your right hand on the right side of your duty belt.
Yes.
And it's your right hand on your firearm here.
It's blurry, but it's possible.
Okay.
Aren't
You
you
can take
clearly
that down, thank you.
unsnapping your gun right now?
Pinch and zoom.
Yeah. Print and zoom.
We have the enhanced image, Prosecutor Kraus.
I've never heard about enhancing. Hold on, I'm
so-
closing handbrake.
As you approached, and Mr. Wright got out of the car, was there a moment where it appeared that Mr. Wright was going to flee or attempt to flee?
When he started struggling with Officer Lucky.
Okay. And ultimately, was Mr. Wright able to get back in the car?
Yes.
You never saw a weapon on Mr. Wright, did you?
No.
Never saw a gun.
No.
He never threw a punch,
Never saw a knife.
right?
Never
No.
saw a
Never
bat.
kicked anyone.
Remember that? From
No.
Never said, I'm going to kill
Rittenhouse?
you.
No.
Never said, I'm going to shoot you.
No.
Never said, there's a gun in the car and I'm coming after you.
No.
Okay.
By the way, I would not, if I were the defense, have let them get away with there was no assault here. There was an assault. The
It's
assault
not
is simply putting
uncommon
the
in your
officers in fear of harm.
experience
Yeah.
To find someone
That's
who
true.
It doesn't
Yeah.
have to be a punch to the face.
Stuff, right?
Assault fear. That's a battery if
It's
you
not
get
uncommon.
punched in the face.
And you've done hundreds of traffic stops in your career, correct?
I don't know if hundreds, but yes, I've done plenty of traffic stops.
See, I'd be bad because I would have
And-
said
and
he
gross
sent me a
misdemeanor
text saying he
offenses
was
are
coming
not the
after
same as
you,
felony
actually.
offenses. Fair?
Correct. They're different order by the judge. For the
Less
crime.
serious crimes, correct?
All crimes are serious, but yes.
Well, in terms of the
All crimes are serious.
laws of the state of Minnesota that you're duty bound to enforce, a gross misdemeanor is a lesser offense than a felony, correct?
Yes.
And you don't get to shoot someone because they have a gross misdemeanor warrant, correct?
Not for,
Your Honor.
Yeah, I would object to that.
Okay, but the objection is sustained. The jury will disregard that question.
You also testified about learning about an order for protection, correct?
yes.
said
Do you
it
get
was
to shoot
a
people for those?
temporary, one that you saw, correct?
I believe it was an ex parte order.
And essentially, the order that you're describing would limit contact between two people, correct?
Yes, in various ways.
It doesn't prohibit all contact with all members of the opposite sex, right?
Just certain parties that they're not supposed to have contact with.
Right. And you'd agree that half the world's population is female, right?
Bigot.
Nice
50%
presuming.
plus one.
So just having a female passenger in your car is not in and of it and by itself a violation of an OFP, correct?
Cause to investigate.
It has to be investigated.
Sure. And you did not see a need to rush up to the passenger side of the vehicle and pull this woman to safety, right?
Not at the moment.
Okay.
It calls for an
There was also
investigation,
some
not a seizure.
Yeah.
conversation, as you
You
saw in
can't
the
just
videos
do that, by
were
the way.
offered in court in this case, conversation about the Wright brothers. You made a comment about the Wright brothers joking about not the ones that fly, right?
Yes.
And then any concerns about whether there was some other Wright family in the area. Sergeant Johnson told you not that family, not this situation, right?
I wasn't sure who they were.
Okay. But he didn't cause you any greater, he didn't tell you this is the family we should be concerned about. We got to be worried about this guy, right?
No, he didn't say anything like that.
Okay. And when you got over to that car and Mr. Wright got back into the car was still running, right? It was running that whole time.
I don't know if it was on or not.
Well, you told Dr. Miller that the car was running, didn't you?
I don't remember that.
You told Dr. Miller that Wright pulled away and got back into the driver's seat of the car, which was still running.
Okay, then I said that.
And the entire time this is happening, you're standing behind Officer Lucky, right?
At what point?
As Mr. Wright is getting back in the car.
I came around Officer Lucky's left side to help him.
And you indicated that Sergeant Johnson had approached on the passenger side, but he wouldn't have been in front of the door because that would have been unsafe, right?
Yes.
Okay. I am going to put on the screen Exhibit 13, starting at 2:01:48. Just that, if you could just leave it with that time frame, please.
Someone in the chat earlier said showing a hand motion through a still frame. Brilliant.
Okay.
With the
Ms. Potter, on the screen we have Exhibit 13 at 2:01:48. I'm going to slowly advance the
It's like we see things in real life.
frames and then pause it periodically. So let's advance just a bit. Okay, stopping right there. At 2:01:48, do you see yourself here taking a piece of paper in your left hand?
Yes.
All right, now advancing to 2:01:49.
Would you agree that your hands
please?
look like old lady hands?
Okay, now stopping at 2:01:49, do you see that you've transferred that piece of paper to your right hand?
It looks like it.
You can advance a little further, please. Okay, would you agree that the piece of paper at 2:01:49 is in your right hand?
I don't know where it is.
Is this the piece of paper right here?
Yeah, it's a piece of paper.
All right, let's advance a couple more frames, please. Okay, stopping right there. Would you agree in this frame of 2:01:49 that the piece of paper is in your right hand?
Yes.
All right, and if we could
This is to show she dropped the paper.
play stopping at 2:01:54.
She's going to put it back in her left
please.
hand in just a second.
Okay.
That's probably what caused the confusion.
A few frames,
The
please.
fact she had that in her hand.
Paper is in your right hand, correct?
Appears that way.
She may break down again in just a minute when she sees the gun.
And then at 2:01:55, could stop right there. You've just transferred the paper back to your left hand, correct?
That's what the video shows.
Okay.
Why did you transfer the paper
And then
from your
if
left
we
to your right to your
could,
left?
Not
fucking
seen.
Advance
no.
a few more frames, please. To 2:01:56.
Once again, life does not happen frame by frame.
Remember, there are 29 frames
Okay,
in
you'd agree at
201:56.
2:01:56, the piece of paper is still in your left hand, correct?
Yes.
Okay, let's advance. Actually,
She
let's
does
play
not
until
want to watch this
2:02:01,
shooting.
please. Okay, so stopping at 2:02:01. You have the firearm in your right hand, correct? And you are pointing it directly at Mr. Wright, correct?
We have a break. My client is.
Okay. Miss Potter, do you need a break? Okay. This is moving away. So, okay, members of the jury, we're going to break for lunch, and we'll start up again at 1:30.
That's a good attorney right there.
Yep.
Very good.
Very good attorney.
Very good move.
See her breaking down. Yeah. They go
Call
to lunch with her
attention to the
breaking
jury
down.
that she's traumatized by this event, that she knows she's screwed up.
It's hard for me to see a conviction from this one, guys. I just don't see it. I understand where they're going with it, but I just don't see it, because if this seems like just such a mistake. She made a mistake, unless they're saying you criminalize mistakes now.
And that will be a radical shift.
Yeah.
The implications of criminalizing mistakes are catastrophic.
Yes.
Well, YouTube just informed me the post I did on this case 4 days ago has been approved for monetization after my appeal. So if anybody wants to read my analysis of what happened 4 days ago, which even I don't remember what I wrote about it or what happened, it has now been monetized. So thank you.
Welcome to the club.
YouTube is ultimately a bro. This time of year, by the way, it be like that. This time of year especially. Everybody's getting up for Christmas.
Hello, everyone. Tim Blotz in the Fox 9 studios.
So the
Sorry, Tim.
The testimony is predictably dramatic. Although long periods of boredom, Aaron Eldridge is, as Andrew had stated, focusing on the word training quite a bit, because that's the idea. Of course, we've had an expert testify that you train to reduce, because despite the amount of training, these accidents still happen. So,
I mean, again, they're essentially trying to convict on manslaughter based on negligence, because that's all the training gets you, is that you shouldn't have done it. I think everybody in the world would agree she shouldn't have made this mistake, but that's not a crime. That's a mistake.
Right.
That's the.
Oh, go ahead, Nate.
No, see, that's the weird part about this is I'm just trying to look at it as a juror, as somebody who's just sitting there listening to all this stuff. Okay, I agree. She's committed negligence. But where's the conscious disregard? Where is this? The fact that, she had to move, she's moving this paper around in her hand, she pulled the wrong thing. They've not given me any facts to show this conscious disregard of an unjustifiable risk. They've shown me a mistake. And I'm just not seeing where they're going with this, right? This cross-examination has not even moved the needle at any.
I mean, based on the complaint, it looks like what they're trying to argue is going to any weapon created a risk of death, even going to the taser. So even though she intended to go to the taser, that created a risk of death. But I'm sorry, using a taser does not create a foreseeable risk of death. That's why officers are trained to use it in non-deadly force situations where deadly force is not called for. Is it theoretically possible? Of course, but it's not reasonably foreseeable. That's not the expected outcome.
It's called, it's a less than lethal option. That's what it's called, less than lethal.
Yeah.
And based on what's gone down in the courtroom and what I'm sure the jury is seeing and feeling, right? Just the credibility of the defense experts, the credibility of their cross, right? And also just Kim Potter here testifying now. I'm sure they're feeling that, hey, this is something that is looking like, as we all say, a genuine mistake, not something that is a conscious disregard for human life.
I mean my concern here is that the judge in her jury instructions is not going to make clear this distinction between negligence and recklessness, the conscious disregard, because if she doesn't, we run the same risk we run anytime there's ambiguous jury instructions. The jury could convict in good faith, believing that they're following the law as instructed, because they've effectively been misinstructed on what the law requires.
Well, Andrew, but in closing though, the defense, they could bring up the fact, right? I mean, it's totally within the bars, then bring up the fact that, hey, conscious disregard, not negligence. They can say that. There's nothing against the.
I mean, they can speak to what the jury instructions actually say, but like what we saw in the Ahmaud Arbery case, that judge never clarified the ambiguity in the citizen's arrest statute. He simply read the language of the citizen's arrest statute, which is ambiguous. And I'm not talking about the probable cause issue, because all the parties seem to agree on that definition, but the question on whether immediate presence was required. So my reading of that statute is immediate presence is required unless it's a felon in flight situation, and then it's a different set of requirements. But that wasn't made clear to the jury. He just read the two sentences together as it's written in the statute, and for all we know, the jury convicted because they were not immediately present for this crime they believed to have occurred. We don't know.
And as they were arguing over that, I mean, the defense in Ahmaud Arbery said essentially that, Judge, if you read the jury instruction in this way, you're issuing effectively a guilty verdict, because that
no one's claiming they were immediately present, right?
Right.
Yeah.
And
That was the big issue there.
So that's it. And to give you guys an idea of what I mean with the implications of criminalizing mistakes, I mean, if you're driving a car and you're going the speed limit, but maybe it's raining or there's some snow on the ground or whatever, and you go to stop at an intersection and you happen to slide into the intersection, right, and hit someone and kill them, even though you did everything right, but there was some sort of issue, that's still negligence. You still should have stopped earlier, but you didn't consciously disregard the risk. You were going the speed limit. You were obeying the traffic signs. You just were unable to achieve your goal of obeying the traffic signs. So you could be civilly liable for wrongful death or something like that. But you don't criminalize that. We don't put people in jail for criminal vehicular homicide because they slid through a stoplight while going the speed limit due to weather conditions.
Right. The difference would be if you'd been pulled over by a cop for something and he happened to notice that the tread depth on your tires was inadequate and he wrote you a ticket for that. So you're on notice. You have bald tires. Then you slide through the intersection because you continue driving on bald tires and run somebody over. Well, there you knew your conduct was creating a risk of death to others and you intentionally disregarded the risk. That's recklessness. That's criminally culpable.
Right. And so the idea that we put people in prison all like as a matter of law for mistakes is
bad outcomes
that we don't do. Now, some people do go to prison for mistakes for bad outcomes. I mean, it happens, but that's not the way it's supposed to work. That happens with things like ambiguous jury instructions. That happens with things like bad statements on cross-exam or whatever happens in the jury trial. But typically speaking, we don't criminalize those types of mistakes in that way.
But do we criminalize pulling somebody over for an air freshener? Because clearly that is the most material thing which we should pay attention to. And it seems like today, I mean, they're bringing to light. I mean, we said it earlier with the article when they're talking about the junk science and the air freshener. They're trying to play to this public narrative. Right? Like this is the narrative, right? Dante Wright was shot and killed for an air freshener, right? You know, I mean, and they're leaning into that. And we see these prosecutors, especially these type of prosecutors, we saw it in the Rittenhouse case, leaning into the public narrative. And I think that's a dangerous thing because they're not relying on the facts or what they have at hand or their expert testimony. They're leaning into a narrative that may or may not even exist.
But maybe they're prepping for the loss, right? Those are the clips that will be played in the news after the fact. Look, the only reason they pulled them over was for the air freshener. Here's the prosecutor saying it, right? And on cross-examination of the witness. So they're prepping the media narrative battlefield to make themselves look better if this goes bad.
Mm-hmm.
Yeah, and
that's what I would do.
I mean, theory. annoyingly dumb question from Aaron Eldridge. You didn't feel compelled to run up to the passenger side and rescue this woman in the car. You can't. Like, an officer cannot do that. I think Nate can help me out with this. As a police officer, Nate, could you run up to a vehicle and just grab a passenger and drag them out of the car without sufficient grounds?
No, well, I think with the prosecutor, it's got to be weird for these prosecutors, because in one courtroom, they'd be arguing with these facts the exact opposite if it was, let's say, Dante Wright survives, and this was a case against Dante Wright.
Yeah.
They would be arguing these same facts in reverse. Oh, the police how do they know who they were, right? So it's interesting to see, and this is what I always talk about when it comes to justice. If you can argue, if this case, the narrative of this case can bring you so many drastic outcomes, then I'm not sure if they're arguing for justice here, where it seems like they're more or less arguing just to convict this poor woman.
Yeah. I mean, you see that a lot in these cases, right? If Trayvon Martin had not died, he probably would have been charged with assault. If Michael Brown had not died, he would have been charged with assault and battery on a police officer. Right?
Right. Yep, absolutely. And if that was an argument I brought up in Chauvin, someone asked, why didn't someone in the crowd come and Spartan kick Chauvin off of Floyd, right? It's like, well, if they had done that, then what happens is Floyd gets charged with counterfeit currency, resisting arrest, and the person who Spartan kicks the officer gets charged with assault of a peace officer in the commission of their duties. All of the bad, of course, comes after the fact of the death occurring. Without the death occurring, you don't get to with the death occurring, you don't get to any of the criminal liability for the underlying issues. Here, I mean, Dante Wright not dying, he gets resisting arrest. He gets booked on his gross misdemeanor. He actually has to make his appearance for his outstanding other charges that they haven't mentioned. A whole bunch of things go poorly for him if he does not die. I mean, certainly probably preferable to dying, but other than her yelling taser, 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 this case doesn't exist. And I would say that if she pulled the gun and just was silent and pulled the trigger, I don't think she's charged at all.
And the death
I don't know.
changes
I don't
everything
know.
because
This happened during Chauvin's trial, while BLM was on it. They were on it like that. She's a white officer. I think she's charged. Yeah.
Okay. Maybe.
And one of the reasons the death matters so much is because the death suddenly, ironically, gives birth to an enormous bucket of political capital and financial capital that politicians can take advantage of, that guys like Benjamin Crump can make another $10 million off his portion of a settlement on. It simply changes all those dynamics, and it's like chumming fish parts into a pool full of sharks.
Man, do I wish I could figure out how to do the Crump move, right?
Isn't that amazing?
It's a master level grift.
I want his jet.
Show up at every single incident like this, negotiate out a settlement with the city prior to a guilty verdict or not, getting paid, a family getting paid between $10 and $30 million, and you taking 30 to 40% of it. Woohoo! Good.
But he doesn't have to practice law. He doesn't even have to do a law vlog.
Well, what does he do? He does it's called pre-litigation, where you just go in and say, here's the case. But here though, the family should get paid. I don't see like this. This is a textbook negligence case, right? So the family should get paid. Yeah. So if they want to get Crump, and a lot of times when you get an attorney, big name attorney, they're going to be more likely, let's settle this instead of having Crump do his thing about telling everybody that Brooklyn Center is the most racist place in the world. Yeah. Give them the $15 million.
And they're spending other people's money, right?
Yeah. So it's like, okay,
it's not coming out of their paycheck.
And this one, I think, I guess there's a contributory negligence argument, though.
Yes.
There is.
Hell yeah.
And we were talking about this the other day. I mean, there's an argument. Uncivil made the argument that, hey, this could have raised to like 50% plus one and block the recovery. We can have that debate, but I think as a city and as the
city's going to pay it.
I've represented cities. We pay every single time, and like especially on a case like this, you're paying because the nuisance just to get rid of it, right? You don't want to see it.
Especially
politicians love to spend other people's money to make their own political problems go away. I mean, that's a no-brainer every day of the week, twice on Sundays.
You got a
Yep.
Democratic AG, the Democrats. It's you're gonna
writing
want
a
this to
check.
go away quick. Yeah, quick. And Ben Crump is probably going to be the man to do it, right?
I think he is representing the family.
mother,
I would assume so.
Yeah,
He's
he
still-
accompanied the mother to her police interview a week after the event.
And by the way, all of these families are absolutely correct to call Ben Crump. I would
call
the
him.
man gets results. He gets them again a lot of times prior to the criminal trial or conviction. I mean, he had the Chauvin.
Oh yeah. I
Chauvin
mean, if I
thing
was in the
locked down.
family's position, I'd call him. I wouldn't hesitate. I mean, he'd be my go-to guy.
Yeah.
Yep.
He gets it done.
He does. What was there was something else. Oh, there was some confusion in the chat from some people. I don't know how many, but about the fact that there was a second warrant that was mentioned. That was not actually brought up in prior testimony, but that warrant was a misdemeanor warrant for
The older brother, Dallas.
Yeah, for
The
drug
person who's
possession
renting
or
for the car.
something. Yeah, for the older brother. So again, it's another valid reason to affect the stop. And
The family that
investigate.
non-appears together stays together.
When you
Were they trying to
got
make that
warrants,
Wright
right?
brothers joke a racist thing, or was that like why was she bringing up the Wright brothers joke? Like,
because I'm assuming these cops know the brother has a warrant,
Right.
the other
Yeah.
brother has a warrant. They know these people.
The mother's
are
got a
troublemakers.
felony drug conviction from just a few months ago. I mean, this
Yeah,
is
so they
obviously
know
a
these
family that's
frequent flyers.
probably familiar, known to law enforcement, as we
Yeah.
would say.
Well,
Yeah,
yeah,
no,
the interesting thing about families in certain socioeconomic statuses is that they will find themselves in contact with law enforcement far more than the average person. And it's weird because as a defense attorney, you encounter these people multiple times over the course of your career, no matter how long it is, and you're stuck wondering, man, how often are you interacting with police? Like, how does this keep happening? But typically, people.
it's.
But I mean, for people who
I
engage
found-
in these kinds of activities, police interaction is just part of
Part of
the
the game.
life. You know, it's like you own a car, it's going to get scratched eventually, right? When it's brand new, you hope it doesn't happen, but a month, a year, whatever, you're going to get a couple scratches in the car. If you're dealing drugs or stealing stuff or whatever it is that you're doing, police contact is just, you hope it's not going to happen, but the odds are every once in a while you're going to have that interaction.
But I do want to say though, in New York, for instance, it really depends on the neighborhood you live in. Because let's say, for instance, I live in a neighborhood where there's zero crime. I'm going to have a lot less police contacts because police aren't going to be there looking for things and trying to say. But if you're in a minority community that has a heavy crime presence, then, for instance, I've been stopped many times. As law-abiding as I am, I've been stopped many times. Hey, listen, we've had this happen. Were you around? Have you seen something? So there are a lot more of those incidental contacts with police, and I think you're right. If you're in that life, you're going to have more. But sometimes if you're just in a poor neighborhood, you're going to get more police contacts because police are out there doing more to try to prevent crime.
Yeah. So two clarifications. When I'm talking about socioeconomic status, I'm talking about what you're talking about, Nate, with the presence in communities where you're going to have high likelihood of police contact. And then the which depends on the city you're in as to the demographic makeup of that. It has nothing to do with demographics. But the other part of that is there's two types of police contact, right? There's sort of the incidental police contact. Have you seen anything, or you encounter an officer on patrol or whatever? And in urban areas, you can encounter like literal walking beat cops. Out where I live, walking beat cops would be completely pointless because you'd be walking a really far distance between each house. So it doesn't make sense. But there's that other type of police contact that ends up with the defense attorney involved. And that's what I mean, is that I would have these repeat clients and they're ending up, on the bad end of a traffic stop that ends with a DUI over and over and over again. Well, the reason is they're making the decision to drink and drive frequently over and over and over again, or they're doing something in such a manner where they're ending up in these encounters. Drug charges, a lot of times you have repeat offenders because they're addicted to a particular drug. So it involves them engaging in the criminal activity over and over again. So with the right family to some extent, I don't know about the others, but Dante, they went through his list. They listed 5 or 6 active case numbers from 2019 to 2021, plus 2 civil matters that could be criminal if
Right.
maybe they don't have enough to actually convict him on, so they haven't charged him, or maybe they're waiting to charge him on those. We don't know the full details, but I mean, you've got basically 7 serious
Or maybe he
criminal
was charged, but
incidents.
the charges have gone away because he's dead.
Right.
You know, the
That's
convictions are on the record, but any pending cases effectively disappear, right? There's no adjudication there.
yeah.
You know, I've actually had self-defense law consults for a client. And then a year later, I had to do another consult for the same client because they pulled out their gun again and threatened somebody with it.
Yeah.
And you know, sometimes poor decision-making is a lifestyle, and you can reasonably expect to see those people come through the system more than once.
But I do want to say one thing about, and this goes back to my criticism about statistical driven law enforcement. And that's what happens is here in New York, we have what they call CompStat, where they take all the neighborhoods and say, well, in this neighborhood, we have X amount of calls for robberies. So we're going to deploy resources to that neighborhood and try to have cops stop robberies. So, but what they do is that they'll have what they call a goal system. So if you're, let's say, in a poor neighborhood, let's take out the demographic, a poor neighborhood, then for a cop to be assessed on how well they're doing, they're saying, well, in this neighborhood that has a high crime, we expect X amount of tickets, parking tickets, and let's say 1 arrest or 2 arrests for the 3-month period. And that would be a determination on how well you're, doing your job in that community. If a cop doesn't get those 3 arrests or 5 tickets, then they would get, let's say, a poor evaluation. But now if you're in a good neighborhood, let's say if you're in Sunnyside, Queens or something, which is a really good neighborhood, your numbers, they would say, well, we don't want you to know there's no arrest, right? Or there's maybe 1 ticket instead of the 5. So what happens is that it becomes a negative feedback loop where the cops in good neighborhoods don't want to get more arrests. Why? Because if you get more arrests, then the next month you're going to have to get more. It's a negative feedback loop. So those cops are more likely to let someone go for, let's say, a minimum weed violation, right? Because that hurts you. If you get 2, now I got to get 2 next month. But if I only get the 1 and let everybody else go, then my numbers are going to be low. But if you're in a minority neighborhood and you're supposed to get 2, and the more you get, the better, then you're going to be stopping people, you're going to be interacting with people, you're going to be searching for people more because the system is built that way. And that's so here in New York, they're trying to fix that, where you stop making those individual officers have to make those choices based on their own, whether their evaluations are going to be good. Now, I don't know how you do it, because you do want cops to be active in poor neighborhoods, but then how do you but that's where you start getting the statistics, like here in New York, where you had 80% of the people who are getting caught for weed happen to be minorities, but that's because that's where the cops were. Those cops who need those tickets are going to get it in those neighborhoods, and the cops who don't need the tickets in the white neighborhoods are not going to be writing those tickets.
The white kids are smoking weed too, everybody.
At the same rate.
Yeah, that's the statistics. But Nate, what I learned from this, most importantly, is that Queens has changed since the filming of Coming to America.
Oh yeah.
That's what I've learned. It's a very different place than it was.
There's some good places there, but there's some bad places. Don't get me wrong. I know there's some bad places in Queens, but there's some good places. But it's interesting because like even with this case, a lot of times it's the personal responsibility of this family, right? This mother knew no license, no insurance, possible warrant. The oldest son got a warrant, the smallest son she's just come out of jail. There's no personal responsibility. Is what could we have done to fix this? And like some people are saying, this is just hitting the lottery, right? And even with George Floyd, I do understand the over policing aspect of it, but then there's a second piece to it where, how can we tell people not to put themselves in this position, not to pass the $20 bill, not to be driving without a warrant and all this stuff? Because let's say this, and think about in this particular case.
I mean, frankly, not to be eating fentanyl, right?
Exactly.
That's a big one.
No matter what.
Whatever you think, and again, either side, whatever you think about the effect of the fentanyl on his physical health, some people think it killed him. Some people think that it based on maybe his tolerance, it wasn't enough. The fact that he had consumed a mind-altering substance right before an interaction with, or shortly before an interaction with a police officer, it changes the calculus of the entire thing. Whether or not the police officer is specifically aware of that, they're going to interact with this person who is acting in a way that is not consistent with normal activity. And you find that pretty quickly in reviewing video of the Floyd arrest before Chauvin's even on scene. He is his excited.
His mannerisms, his
Right.
mannerisms were completely that of somebody who had an intoxicated interaction, right? Not just
Right.
with the police, right, but also with the staff, with everybody else. You know, you could see that, hey, he was intoxicated. So now that you're all back, I can ask you the question I was waiting for, which I've been thinking about a little bit, because I've been wanting to. I can't steel man the argument, but what I'm curious about what you guys think is whether you think Kim Potter, in terms of all officers in America, right, all officers, do you think that Kim Potter represents an averagely trained officer, a below averagely trained officer, or a highly trained officer? Like, at what level do you think she is in terms of amount of training? Because let's entertain a training, mindset for a second. Like, where do you think she is before I say anything?
I'll start. I think she's a moderately trained officer. This is to me, I formed that based on she's a patrol cop. She's not SWAT. She's not on. I mean, she's got some training on de-escalation, but aside from general patrol cop weapons tactics and weapons usage, she seems to be normally trained. They mentioned 1,700 hours. You factor that in over 26 years of service. You got 60 hours of training a year. That's a week and a half of work days total. She seems like an averagely trained patrol officer with basically with very little specialization in any particular thing. But that's me. I'm not a cop, so I don't know how much training goes into it. That's my impression.
We talked yesterday about how much of a cop's job is not use of force involved, right? I mean, most of it is not use of force involved. And in many respects, I think she was probably an exceptional officer. Look at all the stuff she volunteered for, the domestic abuse thing, the casket carrier, the crisis negotiator. But you'll notice that none of those things are things that involve any particular expertise in use of force. They're the opposite of anything. So she's more of I don't know what to call it, a soft police officer, as opposed to a police officer who, I mean, I used to teach at the SIG Arms Academy, 6 Hour Academy up in New Hampshire, and they do a lot of law enforcement training. And I used to take a lot of those classes. And those are guys who are really comfortable with use of force. They're not looking to use it, but you wouldn't want to fight them.
Be right back.
Because they're trained to an exceptionally high level, partly because they're personally motivated to seek that additional level of training. It's not required by their department. They're going above and beyond. But their area of interest is not crisis negotiation and domestic abuse follow-up. It's how can I fight better if I have to fight?
Right.
That's not Kim Potter. That's on her.
No.
But I don't know. Because I've done training. I've trained law enforcement officers at the academy I was a part-timer. So I trained the Aspeton defensive tactics. So Aspeton, handcuffing, and I did some interview and interrogation training. I'll say Kim Potter, I think she's gotten above average training because she was an FTO. Now, for the FTOs generally, you have to have separate training to be able to train other officers, right? So that's another level above the training, and you have to be kind of fundamentally sound. So just for her being the FTO, I'm assuming she would be considered well trained. Also, you're trained every year for your weapons. A lot of people don't know this, but for your firearm, for your Aspeton, and for your offensive weapons, you have to do what they call the in-service training every year. So every year you go in and you requalify on this stuff. Even for the here they had the TASER, so you'd have to do that every year. So you're talking about 26 times per over 26 years. For us here in New York, the weapons requalifications is a week, and the Aspeton training is I think 2 days, and so you're talking about 2 weeks every year on requalifying for all your for everything on your belt. That's
a requirement.
As a requirement. So for here, it's about 2 weeks of training every year to re-up. And now, if you don't go through the training, you lose your weapon. So if I don't go through the gun training, I lose the gun. Or if I don't go through the Aspeton training, I lose it, because that's an insurance thing too.
So in terms of level of training, that's a minimum, that's a bare minimum, right? And it's not what Andrew's talking about, where he's talking about advanced classes, people very comfortable with use of force doctrine, use of force policy.
Some of it is a matter of context, I think. When I was a very active competitive shooter, I would either practice or in matches, which I shot at least once a month, be firing that gun or dry firing that gun maybe 300 hours a year. And I think that's probably a lot more than most law enforcement officers do it.
Yeah, most people only fire their gun when they go into the when they go into the range or for research.
Qualify.
So yeah, that's about it.
Right. There were years I would shoot 10,000 rounds a year.
Oh, that's a lot. Yeah. No. You're doing it for that week, and then you're like
almost 1,000 rounds a month would be pretty typical.
I remember when we did the training with the because they at one time they give you the shotguns for the riot training. And they tell you don't shoot the they tell you don't shoot the dummies in the head. And guess what? Everybody shoots the goddamn dummies. We all blasted them in the head. But the last day to qualify, so you get your certificate. Everybody's like, now everybody's dumb. We're all practiced on killing people in the head. Now they're like, we got to shoot to the mask with these shotguns, and still people are still pinging heads again. It's crazy.
But I guess my point was here is that, and based on what you guys are saying, and I'm kind of putting together, is that it seems like Kim had either, the average or the minimum training, at least, right? That's required to be an officer. And it almost seems like if this came out against Kim Potter, right? If the ruling went in the favor of the prosecution, I think the minimum threshold, the requirements that are minimum would actually have to be raised in most circumstances to come to a satisfactory level to meet the
It just doesn't
requirements of
happen.
the prosecution.
It doesn't happen. It costs too much money.
Right.
Cops are not that interested in more training for the most part. Those that are already going out and getting it themselves on their own initiative. So it's one of the reasons training is so low. Training is expensive. I mean, not just to pay for the training, but now you have that cop off his beat to take the training. You got to fill that spot with somebody else.
Well, there are doubles to that. Like for us, we used to get we as an organization got paid from other law enforcement organizations for the for training. So that was good. So like for instance, the hospital police, they would come to us for training. So that was great because each one of those offices. And then the second point is that the trainings were free and they were handled. Like for my Aspeton training, it was a company, Aspeton, who did the training and then they give you all the tools. So that I got all these handcuffs and all this stuff.
I'm sorry.
So I look
at the chat. I'm sorry, guys. I read the chat.
But that's generally the way they would do it, is that they'll say, like, for instance, for the Aspeton, they'll say, well, for this organization, we'll let you train the trainer. So I became a master Aspeton instructor. But now for my job, they didn't have to now pay for somebody to get that training. And now I could train other officers in that. And then they can make money off of me by having me train other officers in other departments to make it. So that's generally the way it goes.
I have to break this up for a potential Maxwell update. You with us, Joe? Your camera's not on, but are you there?
He got Epstein.
Joe, are you in distress?
Are you in purgatory?
Did they tie you to the front of a plane on the way to the Virgin Islands?
Say McAfee 3 times.
So while we're waiting for Joe, someone asked in the comments about the 10,000 rounds a year I mentioned. That was 20 years ago. The ammo prices then are not what ammo prices are today. Plus, I would reload my own ammo. 45 ACP cost me about 4 cents a round to reload at the time.
Joe, did they tell you you're going to give a massage? Don't do it. Don't do it. There are bad things involved in this. He's trying to rejoin the stream. Hold on. Joe, are you with us? He's a circle now. Hey, what's up, Ty?
Hey, everyone. How are y'all?
Ty. Good
Cheers,
to see you, brother.
Just got out of our office Christmas party.
Hi. Oh,
did you play Santa?
Indirectly, yes.
Yeah. Bonus checks were handed out. I see.
Yes, Nick. Opinion.
What is that? It's the little fuzzy.
Brothers Bond.
Never had it.
Okay.
Sounds questionable. What type of brothers are they?
Are they the Wright brothers, not the ones who fly? Very dangerous.
That's okay. One of our people brought this up, so I thought I'd get a professional opinion.
Yeah, I don't know. I'd love to try it at some point.
So is Joe just a rotating circle?
Yeah, he is. Yeah. He is a disc of confusion. Right. Almost like that Phil.
What happened to all that superior courtroom technology in New York City that he's always talking about? I mean,
yeah. Well, they don't have Wi-Fi there, apparently. So, anyway, well, we're watching the trial today. They had to take a break. I don't know how much you've seen, Ty.
I have seen very little off and on. I was watching her without the sound earlier today. I'm just kind of curious as to what. There we go.
Ty, I don't listen to women beard.
Yeah. I could already see it being tweeted out as we speak. Y'all bear with me. I got to get my desk all straight. She looked, I mean, it's actually kind of interesting sometimes just to watch somebody without listening. She looked very sympathetic. What was y'all's opinion?
She was very flat demeanor for the first part. I mean, understandable. I guess she's obviously under the rest of her life is at stake in this trial. And then she got, of course, as you would expect, quite emotional when the questioning got around to the actual shooting event itself.
Yeah, and then at the they took a break at lunch because she was starting to break down as they were playing her the video of her shooting Dante Wright. And so
I came in at that point, and Krusty, my favorite defense lawyer now, can we stop now?
Yep. Which is the appropriate move there. You can't have your client being. It also is subtly saying that I'm not trying to make my client, or we don't want her to just sit and cry and weep on the stand for the jury, right? Like, oh well, we need to get her off the stand so she's able to compose herself, type thing. So it's interesting.
I saw they had a female prosecutor. How effective was her cross?
Not great.
Yeah. She comes across like a piece of 60 grit sandpaper, going across your underarm or whatever. Like it just, she's not pleasant.
If we're taking on a female witness who is going to act nice, but we know her to not be particularly likable, I usually get one of the Amazons to do the cross. But for someone who is genuinely sympathetic like that, they might have been better off getting some really nice, deep voiced guy to just kind of, I don't know. What do y'all think?
If only they could find one.
Right. That's the problem. They don't have a guy like that. It's either her.
Right. Because
they got Matthew Frank or they got Larson. Joshua throw a pen across the courtroom, Larson.
I'm just saying, letting
Kraus
the harpy,
minus 300 pounds, Larson.
Yeah, letting the harpy attack isn't the best look for the jury.
Well, if the witness is in fact really obnoxious and pretending to be likable, a female attorney can slice right into that. But I don't know that going after her from the harpy angle, if she's genuinely sympathetic, was such a smart play.
I mean, if Eldridge was smart, she would have started quite sympathetic. You've been working as a cop a long time, serving the community a long time, then kind of move into the training, emphasize all the training, and then wrap up with, but you shot him and killed him, right? And you knew that it was important to keep that gun.
She just lied into her. She just lied into her from the get-go.
Pretty much.
She was on it from. She was never friendly to her. She never came off as friendly.
Yeah, no time spent. No time spent building any rapport or anything like that, and that's the real issue.
Because no one's claiming malice, right? So right. So I think you just have to build up to a point where at the end of your cross, you're saying, basically, listen, we know you're not a malicious person, but this was recklessness, and that's a crime, and you have to be held accountable.
Yeah, that gummit, I was going to ask Nate how he'd do it. He left us too soon.
Nate has left us too soon. No, R.I.P. to Nate.
Wait, come back to us.
He went to the same shadowy place that Mufasa and Joe from Good Logic went to.
Hey, Google, play taps.
By the way, Andrew, the Amazons were watching, and I'm sorry, Nick, I didn't see your email Tuesday. I was out of the office.
How dare!
Amazons could have come onto your show Tuesday, but they were watching, and apparently someone's going to call. I think someone is going to call Adult Protective Services on you, Andrew, for your.
What did I do?
Him or me?
No, Andrew. You. They said you had a very fiery interaction. So.
Totally.
Yeah. I whatever. I mean.
It was, sometimes we get into debates over matters of fact and law as we are all lawyers, and I thought it was a productive debate. It settled the issue.
Who are you kidding? You thought it was funny.
Well, yeah, but But also, I think
we're all comfortable with debate. You know, like every lawyer is comfortable with debate on a certain level, and it may make other people uncomfortable. But certainly, I can speak for myself, and probably all of you guys, that like I'm okay with being a little bit uncomfortable during a debate. That's fine. I should be a little bit uncomfortable during a debate.
Yeah.
I mean, my stepfather
is,
sent me to law school with the observation: look, you're just as obnoxious and overbearing as any other lawyer I know. So
yeah, may as well make the money out of it.
Yeah.
I don't care if people agree with me or not. That makes no difference to me. But what I love is quality argument, right? If their reasoning is sound, even if I don't agree for whatever reason, but if their reasoning is sound, I love that. I mean, that's what I live for. That's awesome.
Well, because someone might have caught something that you missed. And then you get to learn, or
they may just be weighing the facts differently. You know,
right?
I mean, we're just human beings. We come to these kinds of decisions. It doesn't mean my view of the facts is universal and everybody must adopt it.
Right.
And
make things a lot easier if everybody would adopt my version. But I understand.
And without speaking for her, but she's not here. I believe she said later that one of the things she was doing was she was making argument and positions based on kind of the expectation that the state would elicit certain elements out of the testimony. And then when those didn't manifest from the expert, she was like, oh, well, I mean, this is silly then. This doesn't need to happen. But she expected, and this is what I saw. I experienced the same thing in Rittenhouse when I was like, they're going to charge this kid. And then I see the charge, and I expected the charging document to be written in the way that a prosecutor might write it, where it's entirely slanted against the defendant. And then I read the charging document and I went, then why the hell are they charging this? I mean, I said they should charge him based on the expectation that they would write it in a manner consistent with how prosecutors do things, which would, again, implicate guilt. The way they wrote it was like a self-defense read through. Like he was being chased, running away, turning around and firing at the last moment. It's like, why are you doing this then? So that was, I can certainly sympathize with that. Well, you're expecting a certain level of performance because if the state isn't going to bring it, then they shouldn't have brought the charges. And that's what seems to happen here. I could see the state, if they had some evidence of her making statements against her interest or something, they don't see, or if she had a history of violence in her service record, they don't have it. Ty, you probably missed this. In her 26 years as a police officer, 0 complaints. 0 from coworkers.
Complaints.
Well, I mean, this is clearly a civil, not a criminal matter. I mean, that's this whole thing. By the way, somebody in the chat may have the best idea I've read all year. The Legal Mindset, Tiebreaker, Decade of Law. Can we have a mock trial to determine if Han Solo was justified to shoot Greedo?
He was justified.
I'm down.
Absolutely. Yeah, I'm down with that.
In the original cut too.
We should prosecute George Lucas for vandalism, though.
I'll take
no, and negligent hiring of Kathleen Kennedy.
Look, yes. I would say that's reckless.
That's reckless. Yeah, there's criminal culpability there.
Like I'll represent Greedo only because I don't want to pay Andrew's consulting fee. So.
Well, Andrew, I've tried to tell Nick many years that justice can't be done unless the lawyers are paid.
You know what though?
Well,
how do you guys feel
resonate?
about
I don't do anything until I get that check. So
how do you guys feel about the consultants, like in the disclosing the consultants' salaries and how much they get paid? I feel like you should. I feel like that could be excluded. I feel like it's a little prejudicial to imply because it implies, it
goes to potential bias or interest in the outcome of the case, and I don't have any problem with that.
I think it goes both ways. I mean, right? Like if you're in a civil matter and you pay your expert $12,000 or $25,000 or whatever, but you're suing Tesla and Elon Musk pays their expert $130,000, right? Like that's a big deal.
But
I think that actually could matter.
But for criminal cases specifically, when you've got a state employee who's got a salary, of whatever, $90,000, right? Yeah, I guess you can bring that up, but he's not paid for this case specifically $90,000, right? Even though he might be an expert and he might just be a professional testifier, right? Like the FBI, for example, they have people that pretty much are professional testifiers.
All the BCA people, are they're quasi experts, right? They're not qualified as experts, but they're testifying to things consistent with their training and experience as if they're an expert. They're all salaried employee by the state of Minnesota, so there's no extra appearance fee. But they did actually hire a specific expert who is separately qualified, and he's the one giving opinions on legal matters and opinions on facts related to the case as it applies to this. And so I think his does come out. I thought it was a stark contrast, actually. The state's use of force expert has this cap of $95,000, which why on earth, you're going to have to testify to what's in the contract. Why would your contract have a cap on it? Very stupid.
Well, it may be a state requirement.
And if the state did
the state may have been grifted so often by these outside consultants that they said, listen, before we sign this, we want a maximum cap on exposure.
And imagine that
first time they got a $900,000 bill.
Right.
Imagine that the state of Minnesota, and this happened because the government did it, got grifted so hard that they set their cap at $95,000.
Right.
Which, if you're paying $95,000 in a case like this, you're insane. Or
you're spending someone else's money.
Yeah. Right.
That's
God,
but Legal Mindset, I think if I hear you right, you don't object to that in civil, right? It's
no,
just
I was talking specifically in criminal, specifically for the burden versus the prosecutors, which have access to state resources, which are funded by tax-paying people like all of us, right? Versus the defense, which is having to go out of their own pocket. They're not getting any free resources. The PD's office isn't going to bring out use of force experts for free, right? I mean,
let me clarify. I support complete non-disclosure requirements for the defense not just on this, on every matter. I don't think the defense should have to disclose a witness list. I don't think the defense should have to produce an expert report. I don't think the defense should have to prove anything. It's the state's burden. The state's in control of the entire prosecution, and the defense is solely at their mercy. The idea that that the defense has to disclose anything to the state by law is appalling to me. I think there's a lot of interest
in self-incrimination kind of thing, right?
I'm trying to muse here because we've talked about in the Rittenhouse case, this case, we're seeing the power of the prosecutors, and I'm just trying to spitball. So we're kind of talking, okay, what areas can we try to tip the scale back, right? What areas can we try to level the playing field a little bit more than where it's at right now? Because I think right and left, if we could agree on something, it would be that prosecutors have too much power. The problem is that the left is loving these prosecutors right now. They're simping for them real hard.
But the funniest thing is anytime you hear a prosecutor ever say, well, this isn't fair. It's like, wait a minute. If you lose, you still have your salary. Home. You don't have to bill. You don't have to do anything. Nobody has to come up with the resources to pay you, to pay your team, to pay the forensics lab, to pay your experts. You don't have to do anything like that. And you're going to say it's not fair. And the other person, not only do they have to probably sell their property a lot of times, sell their house, sell their cars. They probably have been fired from their job because of the prosecution. They're already on limited resources, and they have to pay out a whole bunch of money. And if they lose, they go to prison forever. Yeah, no, thank you. Don't talk to me about fair ever again.
Yeah. In fact, I would support a law that would require the court to play a rim shot every time the prosecutor uses the word fair in front of the jury.
I mean, the most common cases I consult on are aggravated assault cases. So no shots were fired, nobody was hurt, but someone pointed a gun at somebody else over a property line dispute or some equally idiotic reason. And they get charged aggravated assault with a firearm. They're looking at 10 or 15
in
years
Texas
in prison.
A lot more than you might think.
Yeah. And those clients, and we almost always get the charges dismissed or at least put into a diversion program. So if they keep their nose clean, the charges will go away. So they're not going to trial for the most part. And those clients are spending $40,000, $50,000 between their lead counsel and myself. And I don't know what else they're spending. And that's for cases that don't go to trial. I mean, obviously trial would add enormously to the cost.
And these people don't have Kyle Rittenhouse money.
No,
right?
they don't.
They're not, they don't have deep pockets. And that's the sort of everyday, cut by cut, these are the attacks we're getting every day on self-defense rights, right?
Yep. And that's how they do it. That's how they do pretty much it's a soft policy change through prosecution.
Mm-hmm.
again,
Political
without
prosecutions.
right, without caring whether, not always political though. I mean, without caring care as to whether or not they win.
Yeah.
And I'll go back to the case of Howard Root here in Minnesota. He wrote a book on it called Cardiac Arrest. Ran a medical devices company. They sold stents. One of the stents was not approved for a specific type of treatment by the FDA, but was approved generally by the FDA. They were then therefore allowed to advertise the stent as FDA approved. However, one sales manager to 3 salesmen in Colorado specifically. Remember, this is a Minnesota company. One sales manager created a flyer for 3 salesmen saying that this could be used for an off-label purpose, which was legal to do. And
But you
there
can't
was
market it.
no, you actually could, because they had
For
the
off-label
general
use.
approval.
Okay.
Yeah, so it's recommended that you do not market it in this way, but it was still legal to do so. But the other thing is there's no evidence that this was ever actually given to a doctor as an advertisement. It was only a sales meeting. He was prosecuted, federally indicted, 18 months, cost $20 million for this defense because they had depositions in, I think, 22 different states, something like that. And under federal indictment, he was indicted in Texas. Remember, Minnesota company, happened in Colorado, indicted in Texas because they picked a judge with 0 acquittals over 11 years or something like that. And they ended up winning without raising the case. The defense rested right after the prosecution. He doesn't get his money back. He doesn't get his reputation back. He spent 18 months being called a federal felon on the front page of the Minnesota Star Tribune, the St. Paul Pioneer Press. I mean, his professional reputation was completely wrecked by this. And it was all because those prosecutors saw an opportunity to put a medical device company CEO in prison for something he didn't even do or approve. It was also the company's policy that they could not do this. So he wrote the policy that says, don't do this. A sales manager went rogue and did it. He gets criminally charged, but it's the incentive. They want this soft enforcement. We'll charge you.
Llama Wizard, you asked a question: how do prosecutors get away with this? Qualified immunity.
Mm-hmm.
They're just doing their job, bro.
If we could hold those bastards personally liable for this kind of stuff, that would
If
go
only we had a Kyle's law
putting a stop to that. Now, if only somebody had come up with a law that would protect against that. Andrew.
I mean, there is one state that specifically in self-defense cases does allow for reimbursement by the state if the defendant's convicted. That's acquitted rather. That's the state of Washington has a provision. You can ask for a special jury finding if not only is a person acquitted, so cool. Self-defense was not disproven beyond a reasonable doubt, but if it wasn't even disproven by a preponderance of the evidence, the jury can check the box on that form, submit it with the rest of the verdict, and the state's obligated to pay their legal expenses.
I like that.
I mean, that's one of the components we've included in our kind of draft Kyle's Law proposal that we.
I'm going to get that to some state legislators here.
That would be great.
Texas,
it's at lawselfdefense.com/Kyle's Law. In fact, there is an Oklahoma state senator who submitted a related proposal. I guess he's actually submitted the bill, and I've embedded that on that same page so you can see what language he used.
Okay.
Yeah.
We quite sensibly only let our legislature come in session every 2 years.
Yeah.
I actually think that's an important thing. Even in absence of Kyle's Law, and you said it's reimbursement, right, for legal fees.
Reimbursement,
even in absence of the reimbursement, it would be nice to see a jury fill out a box that says we found a justifiable use of deadly force specifically, right? We found self-defense was shown in this case, because I think the not guilty on both of those things matter. Not guilty because we didn't find that the facts added up to the killing in the first place, or that this person was specifically justified for self-defense. Because part of the media narrative about Kyle Rittenhouse specifically is that he was found not guilty. They didn't actually say that he was justified in shooting these people. It's like, I mean, that was the entire theory of the case, but I guess if you want to go with that narrative, they didn't specifically say it because no jury has to say it. But,
right. I mean, but technically it's true, right? I mean, because we don't know. I mean, strictly speaking, for him to be acquitted, all that has to happen is the state fails to disprove self-defense beyond a reasonable doubt. The jury could believe it's more likely than not it was not self-defense, and that's still an acquittal.
Right.
I think a separate finding that we do find by a preponderance it was self-defense would be helpful, not just for the Washington reimbursement scheme, but for civil liability after the fact. I mean,
Civil
just because
liability.
you're acquitted in criminal trial doesn't mean you're not civilly liable for that use of force, unless your state has very specific self-defense immunity type provisions. And by the way, an acquittal doesn't automatically trigger those either. So an actual finding would be a good foundation on which to say, hey, this has already been adjudicated both criminally and civilly.
Is that
and
is
for
that a good thing, then?
reputational repair. Wait, what's I?
The adjudication. Well, if you had a jury finding that it was beyond that it was a preponderance of the evidence, would it be a good idea for that to be dispositive in a civil suit?
That's really a public policy question. So I'll defer to argument on the other side, but it's.
But you could very easily exempt it. I mean, you
could,
because the purpose is to simply establish that level of culpability that will let you go after.
Yeah, and there could be different factors and different parties that are in on a civil versus a criminal case, right? So I think you can make that distinction.
Yeah,
I think we just need to get rid of qualified immunity.
Florida's self-defense immunity statute, if you're criminally charged for use of force, you demand that pre-trial self-defense immunity hearing. Yeah. And if you actually the standard is different. It's the state has to disprove self-defense by clear and convincing evidence, which is beyond a mere preponderance.
It's like 78% or.
But if they fail to do that, the judge grants you not just criminal immunity but civil immunity, even though any civil party is not present.
Yeah. Ooh. It's well, I mean,
because they're not there. It's you and the state.
Right. And what the states are trying to avoid is a cumulative effort to destroy someone who defended themselves.
Yes.
And they say, look, if the state can't prove it, we don't want some wishy-washy legal argument, 51% to come in with just enough to make this person guilty. They want to allow people to use self-defense in confidence rather than die.
Or you mean a Gavin Newsom claim, under his proposal there to, only give a private cause of action, just like with SBA in Texas, right? Those private causes of action are coming, right, for gun-related issues because they're going to attack the Second A that way if the Supreme Court, is going to allow these sorts of things to ride, right? Because they haven't really resolved that issue yet. The procedural issue that they just resolved in Whole Women's Health is not on point with that.
I still think there's real issues with the liability. I think there's issues with the SB8 liability when it comes to anyone who's not particularly involved in the family, right? Like I think a grandparent may have an interest in the child. I think a dad may have an interest in the child, something like that. But I think you get to Joe watch someone walk into an abortion clinic. Joe sues. I think a judge throws that out. They say you have no interest in this child. And I think that's how the Texas Supreme Court pares down that law into a place where it comports with the typical ideas we would have around civil liability. You have to have some sort of, I don't want to call it privity, but you have to have some sort of interest.
Some kind of standing.
Yeah, some kind of standing in the outcome.
So in California, if you just saw a video of somebody using an AR-15 and you're outraged, right? Because it's the whole thing, the tort of outrage, right? You just saw a video and you're so outraged. Does that give you standing?
Yeah, and that's the question. And of course, the other mitigating factor on this for SB8 is that you're not suing the woman who did the abortion. You're suing the person who assisted her, which gets around this idea. She could take a morning after type pill, right? An RU48 or whatever it is. She could take that, and that's an abortifacient. Abortificants have been around literally forever. It used to be various teas that they would brew that probably tasted really gross. Now they've condensed it into a pill. And I don't think a lot of people are interested in getting in the way of that. That's like a private decision. But in every other area of law, a private decision does not encompass you employing a third party to do something to you. And especially when that third party involves multiple nurses, a check-in clerk, and all of that stuff. Abortion is unique in this way that it's the only privacy right that involves you for the purposes of business employing a third party and still having your privacy right protected. Whereas if you merely deposit a check at a bank, they can take your bank records without even a warrant. They could just ask, the bank because they keep the records. They can't ask an abortion clinic if a particular woman had an abortion. They can't do that.
It looks
They
like
can't.
we're coming back.
Okay.
Better take me some Red Bull if the judge is going to speak.
Let's see.
You better intervene us that one, Ty.
Good afternoon, everyone. Tim
I'm
Blunt.
going to wait till this guy's done talking.
Yeah.
Eugene says, WTF, in what circumstances does the CV of an expert witness could be hearsay? Why even make it? Second time, a judge will not grant it. A jury will ignore it as lawyering BS. Look, so the hearsay rule is an out-of-court statement made by a party. So that's why if they don't specifically get to a certain part of the CV, they could technically call it hearsay.
Mr. Frank? Oh, you're just standing up. Okay.
They could call it
All right.
hearsay, but a
Are we
judge
ready
isn't
for the
going
jury?
to uphold, sustain that objection.
Oh, yes. Okay. I had my law clerk send you a copy of a new draft. Okay, well, we can talk about jury instructions after we get the testimony in, okay? All right, thank you, Deputy.
Christina McNary says, first super chat. Hey, thank you. Just wanted to say happy belated birthday and thanks for the
Yeah,
coverage.
see, Krusty hates those masks just like I would.
Yeah. I'm enjoying
tell.
spending my work days with you all and learning some stuff too. Keep up the great work. Hey, thank you, Christina. And then Broly Power Maximum says, hey, bigot, a brick broke this camel's back when my ex-wife drove intoxicated to pick my 4-year-old up from school. I'm pushing for custody. I threw beans at you at Matsuri 2019, made a bean dubstep. Please wish my son luck. Broly Power Maximum, I hope you get custody, man. That is extreme endangerment of a child, and that should never be allowed. And good luck, brother. Eugene says they should have mentioned the nose on direct. Amazing thing. It's always in your field of view, but you almost never see it. I guess. I see mine. Johnny Bunn says, hopefully David Goggins does not come after Bronca for the promo. Get hard.
Well, I hope he doesn't.
He might. Look, we've been talking about arousal and everything all day. I'm not going to rule it out. Hippoopy.
Okay, please be seated.
Says, hangover, drink Pedialyte. It works. Drink the entire liter. Gatorade probably works too. Ideally, you drink it before you go to bed.
All right, counsel, you may continue.
Cut Gatorade 1/2 with water, which actually makes it Pedialyte, I think.
Thank you, Your Honor. Ms. Potter, before we left for the break, we were walking through what happened on April 11th. You'd agree that for a large part of the interaction at the side of the car with Mr. Wright, you were standing behind Officer Lucky, right?
I was next to him at some point.
Okay. And you testified on direct that after you saw a scared look in Sergeant Johnson's face, that's why you decided to use the taser? That was your testimony?
Yes.
But you also told Dr. Miller that you don't know why you decided to use the taser, right?
I haven't seen his report.
Would it refresh your recollection to see his report?
I've
Yes,
never
please.
seen his report.
May I approach Your Honor?
You can't refresh my recollection with something I haven't seen.
Don't get bullied into saying yes.
I would object to this, actually. She said, I haven't seen my report, not I don't
Yeah.
remember his report.
They may have prepped her well enough that they already know that she's going to just.
But the report's not what she said. It's not a transcript.
No.
Is it?
No. And that's why I would, I mean,
Yeah, that's why
personally,
it's
that's what I would
objectionable.
object.
You know, that's what the report says. I don't remember saying that. Those are his
Have a
words.
chance to look at that, Ms. Potter?
Yes.
And did you see the portion where it explains, when asked by this
Here's,
examiner why she decided to
no,
draw her
sorry.
taser Officer Potter states, I don't have an answer. My brain said, grab the taser.
Well, that's a
Well,
okay.
Okay.
I
Yeah.
don't recall it, but it's in his paperwork.
So on April 11th, you reached down and drew your weapon, right?
Yes.
And you said, taser, 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 so Officer Lucky and Sergeant Johnson would disengage, right?
Yes.
And they did disengage, didn't they?
I don't know.
They
That's
let
what
go of Dante Wright and stepped back.
According to the video.
And after you shot Dante Wright, shot him. I'm going to go to prison.
What the
and I killed a
fuck
boy.
was that?
That was like a
Turned into the
possession.
dwarf from Twin Peaks.
I don't
That was the
remember.
ex-wife filter.
That's
No,
the
it's the
video,
dwarf
that's
from
what
Twin
you said,
Peaks.
Right?
Yes.
And you said that there are a lot of things that you don't remember, and that on direct you testified that your memory came back when you saw your husband that day. But didn't you tell Dr. Miller that you remember seeing the gun in your right hand? You said that, right?
I don't remember my interview with him. I was distraught. I wasn't in a good place.
Is Aaron Eldridge actually Satan? I mean, that's the question.
After you shot Dante Wright, you didn't behave like someone who had just saved Sergeant Johnson's life, did you?
What?
What?
I was
Object to
very
that.
distraught. I just shot somebody. I've never done that.
Well, you never asked Sergeant Johnson if he was okay, right?
I don't remember the conversations.
You didn't check in on him at all.
She doesn't remember.
I don't know.
Asked and answered.
Well, you saw the video when Sergeant Johnson fed you the line, that guy was trying to take off with me. You
Fed
didn't
you
fight,
the
right?
line.
You didn't respond to that at all, did you?
The video, I was crying. I was in shock.
And he was trying to make you feel better, wasn't he?
Check that what foundation is.
The objection is sustained.
She's
Well,
really
he
on
didn't
thin
remember
ice with
saying
this
it,
questioning at all.
Right?
Object.
You heard that
Object
testimony?
again.
Yes.
And you don't remember him saying that, right?
No.
And you didn't say anything like, thank God I shot that guy and saved your life. You didn't say anything like that, right?
Object to that is not argumentative.
Why
The
would she say
objection
that?
is overruled.
You would bury her if she
You
said
didn't say that, right?
No.
And you didn't ask Sergeant Johnson anything except to call Chuck, right?
I don't remember what I asked him.
That would be on the video, right?
Yes.
You'd agree that as a police officer, you have the duty to render aid and communicate information to other officers, right?
Yes.
And it's part of your job to assist those who are hurt or injured, true?
Are they going the Chauvin route with this?
And to communicate to
Why
other
didn't you
officers
run
what
down
you know
and
about a
save
particular
Dante
scene,
Wright?
right?
Yes.
Why
Give
did
them
you get
whatever
on your
information you
radio?
can to help them do their jobs, to help render assistance, things like that, right?
Yes.
But you didn't do any of those things on April 11th, did you?
No.
You stopped doing your job completely. You didn't communicate what happened over the radio, right?
No.
You didn't make sure any officers knew what you had just done, right?
No.
You didn't run down the street and try to save Dante Wright's life, did you?
She actually said it.
You didn't check on the other car that had been hit, did you?
Super cop.
That all happened just down the road from you.
She's not on trial for that. She's
This
not on
is
trial
tough
for
to
that.
watch.
Yes.
You were focused on what you had done because you had just killed somebody.
I'm sorry it happened.
There it is. I knew this was coming. I said she would say, I'm sorry it happened. It has to come out. This is why she's on the stand.
Sorry.
Ms. Potter, from your
Oh,
reaction,
now this witch is going to try to be
reaction on your
sympathetic.
video,
This ought to be good.
you didn't plan to use deadly force that day, did you?
No.
You didn't want to use deadly force, did you?
That's irrelevant. If you planned it or wanted it, it's a constructive error.
The objection is overruled.
No. No.
No, I never.
You knew
wanted
that
to do
deadly
this.
force was unreasonable and unwarranted in those circumstances.
I didn't want to hurt anybody.
You didn't want to hurt anybody. That's why you said, I'm going to go to prison.
I don't.
That's 3 times now, Aaron. Repetition.
All right. The objection is sustained.
Ms. Potter, you know the difference between left and right, don't you?
That's objective now. She's asked that before. It's argumentative.
It's not been asked, Your
The
Honor.
objection is sustained. Argumentative.
Nothing further, Your Honor.
You went too hard, Aaron.
Nothing
You went too hard.
further.
You let her
Ms.
say,
Hunter,
I'm
do you
sorry.
need grace?
No.
Okay.
You let her weep about how remorseful she was, you moron. You should never have gotten to this.
Stupid prosecutor. And a
But
bitch.
she's a woman.
And a bitch.
But
also.
she's a woman, though, Ty.
Well, I find this witness extraordinarily credible myself. And if I were the jury, I would be angry having to watch this.
Yep. You let her and she let her do it. She
Yeah.
didn't have to do this.
No.
She beat her over the head with it over and over, and she got her to the point where she said, I'm sorry. She never answered her question, by the way. You didn't go help him. I'm sorry.
Just going to ask you a few questions.
Trustee, my man.
Do you remember your visit by Zoom with Dr. Miller? A little bit at least.
We had a Zoom interview, yes.
Okay. And that was Miller in Florida, correct? As far as we know.
Yes.
And you and me were in my office, correct?
Yes.
And that was the first time that you had ever seen any of the video, correct?
Yes.
And were you able to watch it?
No.
And you did tell Mr. Miller that when Wright pulled away and got back into the driver's seat of the car, which was still running, Potter, that you could observe Johnson and Lucky struggling over the console, and it appeared that Johnson was trying to prevent Wright from putting the car in drive.
Objection, leading. The objection is overruled.
If you don't remember that, because it was a while ago, I can show it to you to refresh your memory.
I don't remember.
May I approach, Your Honor? Read to yourself, Ms. Potter, the last sentence of the second to the last paragraph. Does that refresh your memory as to what you told him?
Karen,
Yes.
the prosecutor.
Did you tell him that? Pardon me, I didn't hear you.
If it's in there, I must have. That day is so blurry.
What's up, Joe? This is probably going to be cut down in just a minute here. We're on redirect.
Did you also tell them that you yelled taser, 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 so your partners would disengage from Wright?
Yes.
And just a few more questions here. Would it be routine, thinking back when you're a law enforcement officer for 26 years, would it be routine for you to unsnap your holster on the way to a car?
No.
And why not?
I'm only 5'3". If I would get into a fight, I could lose my gun.
Did you ever in your career shoot your gun at anybody?
No.
Did you ever shoot your gun in real life during your career?
No.
And did you ever shoot your taser during your career?
It was never deployed.
Is that what it means?
Yes.
And that would be real life. That would be when you have to use those weapons. That would mean it was an emergency situation, would it not? Now, what would it mean to you? Yeah, sorry. Thank you, Judge. What would that mean to you if you had to shoot your weapon?
That I might kill somebody.
When you three law enforcement officers, and excuse me, by the way, as far as reporting this shooting, would it be Sergeant Johnson, your boss, would be the one that would be required to do that?
Objection leading.
Well,
rephrase that. Who would be required, according to policy, to report the shooting? Would it be the shooter or the other person who was in charge there?
Real quick, look at how cool Joe looks on his freeze frame. What the hell is that?
And that's
Cigarette, everything.
Johnson.
Because he was your supervisor, correct?
Yes.
Then I got a couple more questions. If you stopped a vehicle in Brooklyn Center and you learned that there was a bench warrant for a weapons violation, you learned that there was a temporary restraining order a female had lodged against the person that said he was in the car that gave his identity, but he really did. Mr. Wright ever give a valid identification for himself?
No.
And the other office, now you've got no valid information. You've got a gross misdemeanor. You got a temporary restraining order. You got marijuana smelled by your partner. You got no license, no insurance. Would you let that car go if you went up to it and were attempting to handcuff the individual and the car, he jumped back in? Would you have thought you should let him go, drive down the street?
No.
On the temporary restraining order, if you learn there is a temporary restraining order, is it protocol? Is it policy to, as soon as you learn that, jump out of the passenger side, run up to the car and ask the lady what her name was? Has that ever been heard of in police practice that you know of?
No.
Clowning the prosecution right now.
Making them look like
when that bitch asked you.
That's how I do.
Drop the facts, Bronca.
Thank you, ma'am. That's all I have to.
Earl's good, man.
That was good.
Judy recross.
Oh, you know there is. They just
Oh,
got
and she's gonna
annihilated.
come
Let
up
it go.
so angry. Look at her.
Look at yeah. She's just gonna stomp into it further.
Yep.
And look at her motions. They're all so angry. Like,
Ms.
everyone.
Connor, you were asked about some statements that you made to Dr. Miller on redirect,
She's got a lot of
right?
cats.
Yes.
You also told Dr. Miller that you resigned on April 12th to protect your police family, right?
And the
Judge,
community.
objecting this is improper cross-examination. I never got into that. I just got
Okay,
into
You're under the question, the statements to Dr. Miller are at issue.
I'm going to overrule the objection. You may answer that.
You told him that, right?
Yeah,
Can you repeat the
you
question?
brought up the interview. They're going to
You
get to go
told
into
Dr.
it.
Miller that you resigned on April 12th to protect your police family, right?
If it's in the report, yes. I haven't seen the report except today.
Well, if it's in the report that you also said that they're very important people to you, would that be accurate?
Yes.
You have a very close relationship with the police officers, other individuals you work with or used to work with at Brooklyn Center, right?
Some of them.
Trying to use that to
Sergeant
establish
Johnson is a good
bias.
friend of yours.
Judge, I object to this and outside the scope.
The objection is sustained beyond the scope.
Yep.
You also told Dr. Miller that you don't make
I'd
mistakes.
object on her every
right?
question.
You told him that?
If it's in the report, yes.
And you told him that you don't want to hurt or injure anybody. Right?
Right?
But you mentioned to Dr. Miller your relationship with the individuals that you work with, right?
Yes.
And that was very important to you, right?
Yes.
You advocated for their interests in a lot of settings, didn't you, for the people that you worked with?
Objection.
I advocate for everybody.
You had a very close relationship with them.
Objection
You referred
outside
to
the
Sergeant
scope.
Johnson as a rock star, haven't you?
What?
Where are
I
you
don't
going
know
with
what
this
would
woman?
have done that.
They're trying to establish
Nothing further, Your
bias.
Honor.
Bias of the
Mr.
other
Green.
officers through her perceptions of them.
Oh, redirect.
In all of your years there as experience in all of the patrols that you conducted, did you have to rely on your partners for assistance
There you go.
anytime you did a stop or an investigation of any nature?
Yes.
And that would be the family of the police department at Brooklyn Center, correct?
Yes.
And they were your second family, weren't they?
Yes.
As far as complaints, in the 26 years that you were a police officer, did you ever have one citizen complaint?
Objection, Your Honor, outside the scope.
The objection is sustained beyond the scope.
I have no further questions.
You didn't have to get an answer.
They already got it earlier.
We got it earlier.
Just reminding the jury. That's
Keep
all he
your
was
ass-
doing.
Sit down, Karen. Don't.
I think Aaron Eldridge fumbled that very hard.
She came off horrible.
Absolutely wretched.
Hey, Joe, you with us? You're frozen, so I imagine your audio's dead too.
Nah, he just froze it on that really cool, stance
Oh.
he's got there.
He's trying.
Now I see your video, but I don't hear you, brother.
To our viewers on Fox 9, hello, this is Tim.
Wow, Joe
Walsh
sounds
of
different.
Fox 9.
Yeah, no kidding.
Joe just got hired by Fox.
Why are they talking? Why would Fox be talking here? Yeah, Joe, we can't hear you at all, man.
StreamYard doesn't endorse smoking.
That occurred on April 11th of
Oh, shut that guy up.
Yeah, I'm just trying to, because I imagine they're going to go into arguments in just a minute. Oh, look at that. Look at that hug.
That Grandpa Lee hug.
No, that's good. Again, show the jury how much you care. She did a
I've
good
never
job.
seen this woman. I know I didn't really watch the videos. I didn't see anything, and she looked exactly like somebody that has just been devastated by this. And that prosecutor looked like just a vicious bitch.
And you know what? I wasn't that.
Potter
I
should have
wasn't
brought
that-
a tray of cookies into the courtroom.
Yeah.
I wasn't that sympathetic to her on direct. Like, frankly, I wasn't feeling it. She was coming off kind of more rigid, more like a cop. But on cross, I completely flipped. I was like, nope, I'm sympathetic to her now. Fuck these prosecutors.
Well, and that's it. I mean,
Don't let outsiders influence
Well, they're going to be
you.
done for
This
the day.
includes family members and friends.
Well, they may still argue jury instructions.
Actually
Oh, yeah, they're
involved
going to
in this
dismiss the jury.
trial.
That's right.
Don't discuss the case
I was
with
gonna say, you
other
got 3
jury
hours of
members
court
during
time
the
left.
trial. Again, you'll have plenty of time to do this at the end of the trial. Once you have had all the evidence, I've sent you to the jury room with my instructions and the verdict forms. Don't talk to anyone involved in the case, of course, the defendant, the lawyers, or the witnesses. If anyone tries to discuss this case with you,
Matthew
outside
Frank
the
is looking at that 3 hours of court time like Eldridge
me
looks at another
when
cat.
you go home over
can
the
talk for
weekend,
so long.
do not talk to your family,
Harsh
friends,
but fair.
about the case. You may tell them that you are a juror on a criminal case, and that is all that you should tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, LinkedIn, Google, Plus,
This means the
YouTube,
state is not doing
or other
redirect,
social
by the way.
networking sites.
What about TikTok? Can you make
trial,
TikTok
even if
videos?
I have not specifically mentioned other social media sites. Don't visit any chat rooms where this case may be discussed.
Stay away from
Read or
Pornhub.
listen to news reports on newspapers,
How about
magazine,
Kiwi
radio,
Farms? Can I go there?
television, podcasts, or other media about this case. Don't do your
What
own
if you had to do that as a
investigation. Do
juror?
not
Because
ask
on
people
Pornhub
about
and in the
case.
comment section
Do
of
not
this video,
visit the locations
He's
mentioned.
got to
in the
disclose to the
trial.
court.
Do not use internet.
someone said
map
he shot harder than
applications
Kim
such
Potter.
as
I mean,
MapQuest
I
or
don't know.
Google Earth or
Oh.
social media to view the locations. Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media, including Google, Safari, Firefox, Bing,
She said it
or
right this
other
time.
similar search engine. Do not create your own demonstrations or reenactments of the events which are the subject of the case.
How about charades?
Remember, you can't consider anything you hear or learn about this case outside this courtroom. If you don't follow these instructions, again, you may jeopardize the trial and we might have to start all over again.
With you.
If you become aware that the juror may have violated any
Please, jury, please
Do you
listen.
want another week of Matthew Frank?
Okay. So, members of the jury, first of all, I want to thank you for your attention during this trial. I want you to have a good weekend, and we'll reconvene on Monday at 9:00.
It's awful tight. I thought she was promising everybody they'd be done by Christmas.
Said they think so. Apparently, closing arguments are going to be Monday.
Yeah, that's probably good enough.
But yeah, I think it's important. The state is not redirecting. The state said it was entirely on Kim Potter's testimony whether they would, or not rebut, that they would offer rebuttal. They didn't. They didn't find anything in her testimony worthy of bringing their rebuttal witnesses. Tell you what, guys, that means Kim Potter did far better than the state expected. And I lay that at the feet of Aaron Eldridge for screwing that up royally.
Right, please be seated.
Just a horrible, horrible
Okay, counsel.
presentation.
Get in there, Earl.
Bring it home, Earl. Bring it home.
All right. All right. Okay. You should have received another draft of the jury instructions by email. I had Zach do this or Mr. Kramer do this in 14 points, so us older folks can read it. Okay. So
Looking at Earl.
chance to review the new draft.
Never learned to read, Your Honor.
Okay, I'd like to have a discussion about
I'll
jury
have somebody tell me
instructions.
in my earpiece.
Why don't we take a half an hour break? And Mr. Frank, if you could send me your suggested language on the non-deadly force.
Single piece of paper
I've
says
got one
guilty.
in here, a clarifying provision in it, but I'd like to see yours. So a half an hour should be enough? Okay. Okay, we'll reconvene at 2:30. Yes, you may be excused.
Well, that was sympathetic sounding.
She's coming back for jury instruction argument, right? Okay.
I think the judge was mad
2:30.
at how Aaron Eldridge did that. I think the judge felt bad for
You could
Kim
tell.
Potter.
Who
Yeah.
wouldn't be? What
Yep.
normal person?
Her
wouldn't be
intonation gave it
offended
away.
by that? Yeah.
Yep. Her intonation, her rulings immediately afterwards on the objections. I mean, some of those were she ruled the wrong way.
Yeah.
And I think she ruled the wrong way in direct response to what had just happened on the stand. She felt the need to give that witness a break. That what was going on. And that's I mean, I can't know that. That's just my feeling from what I perceive from the judge. And I think that is indicative, in my opinion, of just how bad she fumbled that. They went to a break to avoid the breakdown, and she badgered her right back into it. And that's what you don't want. You don't want a female cop credibly breaking down over her extreme remorse over the death that she caused. Even if you're just thinking about the Blakely factors that the judge is going to have to consider later. the Blakely factors, sure, you may have evidence of aggravating factors because she's a peace officer, but now you have a mitigating factor in obvious remorse. That's on. It's in the record in court. She got to cry out, "I'm sorry, I killed him. I'm sorry. I'm sorry." And again, never answered the question of why she didn't go help. She just cried, "I'm sorry." You don't need to let that out, because anybody
if
who
you'd gone
watched
to help, they would have said you were going to shoot him again, weren't you?
And yes, they would have.
I mean,
Yeah,
and anybody who watched the video, she's rolling around on the ground hysterically. Her hands are over her head. She's going back and forth. I can't believe this. Oh my God. Oh my God. I did, all this stuff. There's no way she would have any capacity to get up and walk down to the scene or even get on a radio. The jury knows this. The jury watched her immediate reaction. She's out of control. Lucky calls it in. Lucky says, "Hey, we've got shots fired. We need backup right away." There's already a squad on scene at the time that he's calling this in. The fact that Officer Potter didn't get on the radio and say, "Hey, I shot a person and it went transverse through both lungs and his heart because I have X-ray vision," is not a detriment to her. And the jury probably doesn't see it that way because they saw what really happened. It was just a stupid line of questioning. Again,
if it antagonized the judge, imagine what it did to the jury.
Yes.
Yeah.
Yes. And regardless, I mean, you heard the test, we heard the footage. Under no circumstance would they have rushed in there anyways, right? Because they didn't know that he was inactive yet. And for all they know, he could still have a weapon, right? He could still have something on him. They're not going to rush out there and immediately know exactly what the wound is and save the guy, right? That the rendering aid thing, it may have gotten them the W in Chauvin, but it's not a winner here.
Yeah, the reason it was a W in Chauvin is because he's right there. He fails to stop kneeling when informed that the pulse is stopped. He doesn't do any mitigating action at that point. Huge difference here. Kim Potter just testified that she didn't even know her gun went off.
You've got somebody showing genuine remorse on video when it happened, and you got her showing it again on the stand. That's very different from Chauvin too. They're just not the same case.
But they're the same prosecutors, and I think that does get to your head. I mean, it does go to your head.
Yeah. Well, these prosecutors are idiots.
She says she knew she shot him, and he told her, "You shot me."
Yeah.
I mean, even then she didn't know she had a gun in her hand. She just discharged.
She said, I tried to use my taser and nothing happened. She didn't hear the shot. She's in the state. They'll argue, right? Whether you believe any of this or not, right? So to be clear, I'm framing this the way the defense will frame this in their closing arguments if they get to these issues. They just had an expert testify that in a high stress, high arousal situation, you don't perceive the things around you. You focus on the danger. The danger is Dante Wright to her. He's a danger. She testified. She saw Officer Johnson, a giant of a man, capable in the field. Her superior officer, she's never seen him look that way before. He looked in fear. This is a man. It's like when you hear about your grandpa. You've never heard your grandpa cry or be afraid, and then that thing happens that you do. This is how she's perceiving this guy. This is this big behemoth. He's scared in this moment. She's focused on the danger of Dante Wright. She tries to use her taser, and nothing happens. She doesn't hear the gunshot, according to her testimony. Again, disbelieve her all you want, believe her, whatever, but nothing happens. And now they have an expert in there saying that this is consistent with people who are in this type of state, that they don't perceive things around them because they're hyper-focused on the danger. And then he tells her, "You shot me," which is on video. She's like, she didn't even know. She had no idea. Whatever, again, believe her or not, that's the narrative. It's a very good narrative, and the question will simply be, does the jury buy it? And I think they will. I
would just note that Matthew Frank didn't exactly rush out there to provide first aid to Aaron Eldridge's cross of Kim Potter.
Matthew Eldridge, objection, Your Honor. This is your attorney. But it sucks.
She's killing her case, Your Honor.
Yeah.
Well. That's what happens whenever you win all of your cases all the time. Like most prosecutors do. They get cocky and they think it's because of them and not because of the basic fact that, most of the time the defendant did it.
Yeah.
And your basic ham sandwich could probably rack up a pretty good kill rate score on that. That was horrible. I mean, that was tough to watch. To
Blue Water in the chat, who says she failed to turn on her taser. She failed to turn on her taser. I'm inferring from the context of your other comments that you think that makes her more guilty. If you think that's idiotic. If she failed to turn on her taser, that would only explain why her taser didn't work when she tried to fire it in her mind. That's not a component of guilt. If she failed to turn on her taser, it's because she just was in this zone. That doesn't mean she consciously disregarded turning on her taser. That does not get to the criminal elements of this case. It's not actually helpful to the prosecution if she quote unquote failed to turn on her taser. And I don't know this because I'm not a taser or a frequent firearms user or anything like that. I mean, I like guns, but I'm not out shooting all the time. But I had an officer email me and say that, when you draw your taser, the flick of the safety is automatic. And if you drew your gun, you would flick in the same way, not even thinking twice about it at all. Yep. Whether you hit the switch or not, your thumb just goes, it's just part of the draw. And so, again, she failed to turn on her taser. That's obvious because she didn't have the taser in her hand. She couldn't have turned it on. You have no idea what her thumb did. That's not on video. And her perception is, I'm pulling my taser to use it. And that's, if you think it's a different perception, you're going to have to show where. I mean, you can just disbelieve her. That's fine. But you can't assert that it's something else without some evidence.
Yeah, I don't think it's disputed that she shot him.
No,
that she didn't pull her taser.
Oh, we had that DNA and ballistics testimony, so that was.
Oh, thank God we had that.
That cleared up that open question and dispute.
Yeah, it's
I was talking with the Amazons about that though. Y'all were suffering through that that stuff, and I said, yeah, but if I was the defense, I'd make them work for. I wouldn't stipulate anything.
No. So you don't stipulate it. So they have to have the testimony, but it doesn't have to be at that duration.
Well, it
seriously,
does if
like
they're a bunch of grandstanding morons.
Yeah, that exactly. But under a reasonable testimony, hi, you're so and so. How long have you been with the BCA? What is your qualification? What is your job title? Oh, that means you test bullet casings and match them to guns. Cool. Great. Did you do that test? Or could you explain that test? Well, we take these lines and they line up with the rifling of the barrel of the handgun or the rifle or whatever it may be. And you go, okay, cool. Did you do that test on this one? Yes. Did you find that based on your traditional means of testing and experience that this bullet casing is consistent with being fired from the Officer Potter's gun? Yes, it did. You just go through it very basically. Yeah. You talk about the test. It takes 10 minutes. There's no cross exam because what do you got in this case? There's no dispute. And then you get done. They had those guys up there for an hour each. Like, what are you doing?
That's tough.
Let's see. Mark Gee over on Odyssey says this prosecutor is not a bitch, but rather a witch. We need to check if she floats like a duck, as we already know that she speaks backwards.
I got no perps whatsoever for the gratuitous Twin Peaks reference.
By the way, I heard, was that a laugh in the background of you, Ty? Because I
the dwarf character in Twin Peaks that speaks backwards. Yep.
Oh yeah.
Yeah, you can have it.
Your wife is a national treasure.
Man, I haven't watched Twin Peaks in so long. But yeah,
that's
the
some
dream
trippy shit.
That was the dream sequences. But yeah.
A classic.
Automata says, a long while back, I needed to hit the restroom and punch out for the day. I caught myself standing at a time clock reaching for my zipper. Luckily, I stopped before peak hilarity ensued. And yes, those are the kind of... But that's the action error that they're talking about.
See?
Right?
I understand.
Most action errors are actually not very harmful. They don't involve someone dying, but they happen.
No, like accidentally sliding into somebody's DMs. I mean, it happens. It happens, guys.
Yeah. Yeah, you're like, what up, Pokimane, or whatever. Just a hypothetical, I guess.
Yeah. I sim for you. Here's my Catboy pics. No, I mean, it just happens.
Mad.org says,
Go
are
ahead.
you aware of the lawsuits by Lawyers Committee for 9/11 Inquiry? Really long list of evidence. For reference, check the Unspeakable documentary on YouTube. No, I'm not aware of that. I don't typically follow 9/11 stuff, but I might give it a look. We'll see. Things that happened 20 years ago are typically off my radar on a YouTube channel because I don't have expertise in them. But oh, by the way, chat, if you're enjoying the stream, make sure you click like. It helps with engagement. I noticed today that when I went to the search, and you might have seen this, we're at the top of search on Kim Potter trial live, even on my own channel. And the reason is because we've been consistently destroying all of the other networks, and your guys' viewing and likes and comments help do that. If you like this type of commentary versus the commentary and coverage provided by other networks, the likes and stuff really, really do help, and your continued viewing is very appreciated. Thank you. Lamb Chop says, rather than junk science, pop science, terminology that might not be scientifically rigorous but illustrates the concept to the lay population. Yeah, there are two different levels, or there are three, I think, different levels of writing, but there's academic and popular that are at issue here. This expert witness has written popular level books and academic level articles and journal entries. So that could be distinguished. Eugene says, I'm going to bet ADA Frank will do the cross. Never bet against prosecutors' ego bingering up the case.
That's fair.
I didn't think Eldridge was going to do the cross of both of these witnesses.
Honestly, but that's
because you would assume that she prepped for the cross of the expert and then to also prep for the cross of Kim Potter, the biggest fish in this case, that she would not have prepped for both. I would add her prep for Potter and not for the other one.
I would have had two completely different people prepped to cross her. If I didn't know how she was going to be, I'd have somebody for she comes off phony or whatever and likable, because this prosecutor, Eldridge, is that her name? She was horrible.
Like Eldritch horror.
You bigots. Females can do it all in heels and better than men. Come on now. Come on. She could do it all.
Yeah. Well, I mean.
No, I think she should have done the cross of Kim Potter. She just, I think she just screwed it up.
Yeah.
Because again,
what I'm saying is that if you're, again, that is not the right look, sound, approach, body language, whatever. That you couldn't have had worse cross-examination in terms of technique, not the merits of the cross-examination. The thing is, the technique was so awful. I'm not sure anybody got any of the content out of it, because I was too busy being angry at the prosecutor for acting that way.
The whole thing is, you have a unique opportunity as a prosecutor to actually cross-examine a defendant in a case like this, and in a national case. So what you do is you have to. This is a sympathetic witness, and they know she's sympathetic because they haven't challenged her character at all, despite the full opportunity to do so. So they know she's sympathetic. So you have to be sympathetic, empathize with her. You have to build rapport and trust that you're not there to bury her on the stand, even though everybody knows you are. You just want to fool her. You want to convince her that you're her friend, that you understand her position. Look, everybody makes mistakes. It's really horrible. It's really awful. However, you had a lot of
you don't have
training
to
on
treat her
this.
like an evil person. I mean, she's
Right.
not charged with a crime of malice.
Exactly.
You just have to paint her as maybe well-intentioned but criminally reckless.
Right. You messed up in a way that killed someone.
I think that would have been a far better approach.
And you can walk her softly into that, right? You could walk her soft. This was the worst mistake you ever made of your life, right?
Yeah.
This is a mistake
Cost somebody's
you would
life,
never make.
cost a young man's life. Yep.
It's a big mistake, right? It's not just a small one. It's a really big one, right? Walk her softly into that. And
Even you feel bad about it. Even you feel bad that this happened.
And when she starts crying,
clearly feels awful about it. You're right. They could have done that. They could literally have gotten her to just basically confess on the stand if they had done it right.
and when she starts crying, you say, "Look, I know this is hard. I know this is traumatic, but let's take a minute. take a minute. We need to get through some of the facts of what happened. So I don't want to bring you through this. I don't want to make you revisit it, but we have to get through some of the facts of what happened. So take a minute and then we'll move on. Let her collect herself or take the break, whatever you have to do. But notice what happened. I mean, I think they had a discussion at break. You're not going to get her through that video. You're not going to get her through that video. If you try and show that video again, she's going to break down right away. It's going to be a big mess. Don't do that. And then she did exactly. Yeah, she got to exactly what she was getting to with the video anyway. And if you think
it would have been smart for Eldridge to ask for a break.
Yeah. Yes, it really would have.
That would have required some level of self-awareness, at least what a snail has.
Empathy.
Or,
and
you don't have to hate this woman.
And the other thing is, if you think that she's lying, because I know some people on the stand think that she's lying or fake crying or whatever, that's fine. The prosecution should anticipate that possibility from a witness, and you don't let her. If you're anticipating that she's lying and looking for these opportunities, by the way, opportunities that I explained would happen yesterday, and all of them did. She was going to cry. She's going to express extreme remorse because it's the most obvious outcome for this type of defense. The prosecutors know this, so you don't let her go to
well, you
those
say
places.
that, Nick. You say they know that, but apparently...
I mean, it would have been smart to analogize the prosecution to a lawful use of self-defense by a police officer. You know, every police officer wishes it doesn't have to happen. And when it does happen, they wish it didn't have had to happen. Yeah. But it did. It did. We had to save innocent life. Somebody had to die because we had to save innocent life. We wish that Kim Potter didn't have to go to jail. But she does. Because she recklessly caused somebody's death. We wish that had not happened. But it did. And she did it. And she has to be held accountable.
And you get her to say it too. Mm-hmm. You can do that.
Like Legal Mindset was saying, you could walk her right into it. I agree that.
Right. Make her.
She's wanting to confess.
But it's this mindset because they, especially on a certain side, right? On a certain side of the political spectrum, you know, you've got to demonize the other side rather than think about, hey, let me humanize them. Let me acknowledge that this is a gray area. However, this is a gray area that leads to criminal culpability, right? Like, but no, you have to demonize them and you have to attack them at all sides because how dare you view this as a sympathetic scenario at all, right? How dare you show any human empathy?
And imagine unironically having video of the defendant saying, I'm going to prison and not being able to get over yourself for long enough to just skip the shooting. You don't have to show the shooting. Everybody's seen the shooting. She knows the shooting.
It's a weird thing, right? The prosecutors, it's like they think it's all about them. It's not about them. I mean, you're playing a role here. There's some overarching mission you're trying to accomplish. It's not about you and your personality and your wants. It's how you accomplish the mission.
You know, I'm seeing a lot of people in the stream saying that there were no tears. I don't know how many times you've been around people who are very, very, very upset, but you run out of tears.
And I'll say,
and this woman has probably been crying for about 3 days solid.
And another very important factor is
so that doesn't get us very far.
This is compressed video over an internet that is not at full resolution.
Right.
I think the Fox stream is at 720p. In the second time, I noticed you actually can see tears rolling down specifically her left side, although she may not remember right from left. The left side of her face are right as you're watching it. So go back and watch the replay if you want. I did not notice tears at the beginning. But I did notice tears when she was saying, I'm sorry. They're actually present. Again, some people can make themselves cry.
You would expect her to try to steel herself up to testify. You would expect
maybe we just need to add some pixels, Nick.
It's not
just zoom in on your iPad.
Zoom, interpolate those tears. No, I mean, because I was thinking the same thing. I was like, if the jury doesn't actually see tears, they may not believe her crying. But to me, and look, I just had in court a female client being convicted and sentenced for felony convictions, right? Their breakdown looked remarkably similar to this. And I know this person. I know that breakdown was genuine. And that breakdown was during sentencing. They have no benefit to breaking down like that. They're not getting out of this. It's not on some, examination. It looked remarkably similar. And and similar aged female. So I mean, to me, it was fully believable. You could see her tensing up and shaking, and I think Andrew, you were mentioning her testimony on direct was kind of it's kind of stiff,
flat.
Yeah,
That's
flat
what
is how you said
correct. Yeah,
and I think if I'm guessing, it's because she's trying to steel herself up, right? She's trying to get through this issue, and yeah. So I mean, to me,
Yeah, I don't think there's
believe
anything wrong with it. It's understandable.
Yeah, yeah, and
It's understandable, the flat demeanor, but I don't know if a jury would understand it, but
right.
that's just
Fortunately, the
people are like that.
prosecutors jumped in there and gave her the perfectly plausible and reasonable opportunity to break down, and then just hammered on her. That's
Yep. You again, when you've got a witness that's sympathetic on cross exam, they're breaking down, you call the break. You let them have a moment, and you don't do it for them, you do it for you because you're failing. you're failing at that moment, and then it gives you time to reassess your strategy, get her back, and then navigate around the crying. Again, I think they could have gone to the after parts of the video without going to the shooting parts of the video and maybe avoided some of the crying, or at least it would look less genuine if she's watching herself cry and she starts crying than if she's watching herself about to shoot someone, a decision she completely regrets. So again, to me, I'm like, you've shown the shooting 50 times to the jury. There's no point in showing it to the witness who was there. Ask what happened after. Ask about her saying, "I'm going to prison." You thought you were going to prison. She kind of tried to do that line.
Why did you think you were going to prison?
Yeah. I don't know. You do know, don't you? I mean, of course you
why
know.
would somebody go to prison, right?
Yeah.
Like,
Yeah.
You're training as an officer. Why would someone think they're going to prison?
based on this policy you signed.
Yeah.
Because we all do everything in every policy that we signed. We all follow it to the letter.
Yeah.
Yep.
Yeah, absolutely.
So it was
Yeah, I can't imagine that this is going to show up in a trial advocacy class going, that's how you cross-examine somebody.
Yep.
Nope. No, how you do that is you show the first couple of days of Earl Grey and Paul Lang.
Oh, yeah.
Or Sheriff Easy, man, from Rittenhouse.
Yeah.
Yeah, he did a good. He did it well. Oh God.
Yeah.
I should be arrested.
It's more of how not to do it, because I remember in law school being played the Texas deposition, if you guys have ever seen that one.
Joe Jamel?
Yeah.
No, he did that right. Joe won that case.
I know. I have a friend whose dad worked with him.
Yeah, if I'm not mistaken, that's the largest individual tort award in the history of humanity. Listen here, fat boy.
That was a good play. If any time you need a laugh, just play Texas Deposition, guys. That's a good one.
Oh, it's so good. Okay. Abe Eckstein says, turns out that Biden, the at Nate the lawyer, isn't real. What? I DM Nate the video.
Biden is not Nate is not Joe Biden.
Well,
Nate
okay.
is Joe Biden.
Who knew?
I'm going to read this exactly as it's written. I don't know what it's trying to say. It says, turns out that Biden, that at Nate the lawyer, isn't real. I DM'd Nate the video. It's embarrassing. I don't know what that means. I know there's typos in it. Or there's a lot of drugs involved. One of those two is true. By the way, don't go to Brooklyn Park tomorrow.
Maybe Nate showed a video and this guy is saying turned out the video was not true or something.
I have no idea. I genuinely don't.
Sounds
know.
about like my phone's autocorrect.
Yeah.
And
again, real quick, just briefly, look at Officer Johnson. I mean, he's up on the curb, but he's a big guy. He's physically imposing. She's testified that she saw that guy, and the jury all saw that guy too. And she testified, this is the first time I've ever seen him look scared. She's in reasonable fear at that point. And they navigated her through that, the direct navigated her through that instance very, very well without ever asking, did you ever see Johnson leave the car? She didn't need to. Her perception was that Johnson was in the car, in fear, was at risk. She had to save her fellow officer. It's her family. These are the people that she relies on, that she cares about. They all care deeply about her. Thank you, state, for reminding the jury that they all still love her very much.
It's really a remarkably small department too. What was it, like 50 patrol officers, something like that? A
46,
half dozen sergeants?
Yeah, it's
Okay.
like 46 patrol officers. Ty, what were you going to say?
I got it. Something about her just seemed disquietingly familiar. I kept going, how do I know her? Has anybody watched Resident Alien?
What
No.
type of weird
Sci-fi
stuff are you
series?
watching?
Sci-fi series. Oh, it's hysterical. I'm sure
Nerd.
plenty-
On the Sci-Fi
Yes.
Channel?
I don't know what channel it's on actually, but we watch it. Anyway, there is.
He watches it on rotoscope.
Yeah, on a kinescope. No, there's a character, sheriff's deputy character on there. Yes, the chat's feeling me. The deputy.
The chat always knows.
That is her. That's her. I mean, they don't just. This woman appears to be one of those people. A lot of organizations will have somebody like this who works their guts out, handles all the crap nobody else wants to do, is always diligent, always there, and this kind of thing. And,
There's a movie about this.
You
There's
know.
a movie about this, about Kim Potter's life. It was Rudy.
Well, if you haven't watched Resident Alien, do yourself a favor and watch it. It's hysterical.
How
Chad, am I
darn-
right? Should they not have a separate show just for the sheriff?
How high on a level of Dante Wright to sober do I have to be to watch Resident Alien?
That's a game day decision.
Aliens. Yeah.
I love the ancient alien memes.
Oh, yeah.
No, some people were commenting on her attire.
That
giving
guy
her
actually has
better-
a cameo on Resident Alien. Sorry.
that they wouldn't have her dress like this or whatever. No, I think this is they said you're
She's
59 you're 59 years old. Dress like a 59-year-old woman going to church or like a nice little dinner, right? Like she's wearing and dress in neutral colors. She's wearing yellow. It's very unimposing.
What would you wear to Olive Garden?
Yeah, there's not bright contrasting colors, right? Like she just looks nondescript. You're a 59-year-old woman. Go sit down that's all you need to be. You don't need to like try and look hot. You don't need to gussy yourself up. Don't dress like you're going out with your husband for an anniversary or something. Just dress nice. Like you're going to church maybe. I think they picked the right.
Exactly like the defense was portraying her as being. Now, if this was an act, this woman needs to be in Hollywood because that was an Academy Award-winning performance. I don't believe it was an act.
She came across believable to me.
Me too.
Very believable. I didn't think that was manufactured.
49? Is she 49? I thought she said she was 59.
And now people are saying 69 because you're degenerates.
Look, they're only thinking about.
Should have seen that coming. Should have seen
Chat, you need to learn the judge's birthday because that's when Judge Regina Chu will turn 69 and you can all be degenerate together, you disgusting heaps of humans.
She's already got the hots for Earl Grey because that whole 14-point font was really for him.
Somebody
said, was there some interaction with her and the judge? Was he flirting with her at some point?
I wouldn't put past Earl.
Somebody-
Earl's kind
no, I
of a hound
wouldn't either,
dog.
but
He's on his day.
Somebody was telling me. I don't think. I heard
there's
that
a
somewhere.
tweet someone put up. It was like, find a woman who looks at you like Judge Chu looks at Earl Grey, and it's this cute little back and forth. Oh, okay. I think we have him now. Joe.
No.
Yo.
Hey.
Hey, welcome back, brother.
The ride, huh?
Gentlemen, how are you today?
Pretty good, man. How's Maxwell going?
It's over.
Oh, it's over.
We might have, they didn't close, the defense didn't close, but after hearing arguments that they had by the lunch break, at the start of the lunch break, it seems as if there may be one or two small witnesses that can only be available on Monday, and there's argument as to whether or not they're appropriate to bring, because one of them, they first told the government about today, and the government is freaking out that, it's too late of a disclosure to allow it. And then the other is a person who is under subpoena and they can't locate them. So if we don't get that, either way, even if we get those two witnesses in, closing arguments are locked in. That's happening Monday, and it's going to go to a jury that day. So yeah, this 4 to 6 week trial took under 3 weeks.
Well, there you go. What's your assessment? Who do you think the state made their case against Ghislaine?
If you don't like her, then yes.
I don't care about her. I'm just curious
Well,
if you think that.
No. Well, that's my point. My point is, if you're a defense counsel and you're looking at this from a purely legal perspective, it seems inconceivable that there's not reasonable doubt here. But did they make enough that, in a civil case that they can find liability on her? For sure.
Okay, so you think there is reasonable doubt for the jury in this case?
The lawyer in me says yes, there is reasonable doubt. The human in me says that she basically came across as Cruella de Vil, who Jeffrey Epstein would never have succeeded in getting these girls to go along with what they're doing without her considerable efforts. So, do I need to stop?
Well, maybe.
All right.
I'm behind plexiglass. Okay. All right. If you're
That's not a good laugh.
Okay, if you're speaking, you can take your mask off.
Earl wanted to take his mask off. He's tired of that shit.
He was wearing it on his chin the whole time.
Let's go through this page by page.
Okay, we're about to hit jury instruction.
You
arguments.
have our most recent draft, the one Zach sent.
By the way,
you.
guys, Joe's channel is linked in the
anything on
description. If you
page
want
1.
full Ghislaine coverage, you've got to check out Good Logic on YouTube. He's been in the
Page
courtroom
2.
every day. I mean, go listen. That's where you're going to get the best coverage. Where else are you going to find a lawyer covering this thing every day?
There's only one other guy, and he's not giving synopsis of anything.
Nope.
Page.
I do need to bust out though.
Okay.
So
all right, see you, Joe.
Catch you later, brother. We'll talk
Catch
soon.
you guys soon.
Peace.
Yeah.
Joe just flits in and out of our lives, doesn't he?
That's how
Okay,
it be.
Page 5.
He say it don't be like that, but it do.
But it do be that way.
All right.
That's what happens when
Okay,
you jizz.
now we're at page 6. Do we need a superseding cause instruction?
Yes.
It is in here.
Absolutely.
It's just wondering if
Absolutely.
it's at all applicable. Okay. You
The state disagrees.
Joe has got to be smoking
Argument's going to be
camels
is that by
because
fleeing, he's the
calling
cause.
Joe Camel, according
Can't,
to
as a matter of law, be superseding of the
Right.
events.
Why?
A superseding cause is not necessary. Part of the case, you can't mandate that it's not.
okay. I'm gonna keep it in. Okay.
They know how dangerous that superseding cause is.
Anything on 7 that you want to object to? This is okay. Now we're at 8, and I've changed down at the bottom. I've struck affirmative defense and just left it at defense. The jury's not going to understand what affirmative is or isn't.
I like that.
So it'll say defense hyphen.
I hate that phrase.
Authorized use of deadly
Yeah.
force by a police officer.
Good defense. No.
What did he say?
He said,
say affirmative, so you take.
could we have it say
We're
good
taking out
defense?
affirmative because nobody understands what that means.
Mommy likes it.
All right. And I think the state
Earl
wanted
breaks out the
to be
Barry White
heard
music.
on my change to the standard instruction on the kind and degree of force. The standard instruction did not have the hindsight language, which is in the standard instruction for non-deadly force.
Excellent.
Or has the state withdrawn its objection?
No, Your Honor, if I can just make a record about that.
Sure.
Can you hear me okay? So the state's position
Your Honor, is first of all that the use of non-deadly force instruction should not be given. I realize we're not at that point yet, but the hindsight language, we oppose the inclusion of that. And so if we're looking at page 9 of the proposed instructions, that last full paragraph, there is a sentence about halfway down that says the reasonableness of the particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the benefit of hindsight, taking into consideration split-second judgments, tense, uncertain, and rapidly evolving. I think we all are familiar now with that language. It's that language, Your Honor, that we feel the court should not include. Prior to that sentence, maybe I'm doing this backwards, is the sentence that says to determine whether or not the actions of the police officer are necessary, you must look at those facts known to the police officer at the precise moment she acted with force. We think that's appropriate, and that's an accurate statement of the law. All that follows is simply repeating that same concept, that, in other words, that we're limited to looking at what the officer knew at the time, and is unnecessary language. Because that's already included in the instruction. That language is, we heard testimony from Professor Stoughton, and I think might have been Mr. Imes or one of the trainers anyway, that explained that 2020 hindsight language is about that very concept. You can't look at facts that occur afterwards. My central issue continues to be with this additional language that comes out of appellate decisions in immunity cases where the appellate court is essentially telling the lower courts in granting or denying immunity, you can't be looking at these things that we know or learn later. And so their appellate language, I get it, they're an appellate opinion, and that's probably why they end up with the jig. But the reason I think they're inappropriate for a district court jury instruction is because they have the force of the court's authority behind them, and they're singling out specific facts for the jurors to consider. And that's why that additional language is improper in addition to being unnecessary. It's just a way of saying, also consider these things. So in other words, when we have a jury instruction on impeachment, the court gives, hey, you could consider some of these things, but we don't go forward and say people who use drugs are not as reliable. You know what I mean? We don't use it, we don't tell them how to think about certain things. And that's what I think this language does and is improper. My feeling that what probably happened is the writers of the jigs saw that language in the opinion and included it. Our position is it's unnecessary and actually improper to add it. That is our objection to that language.
Okay. Mr. Henry.
Are we persistent in its inclusion? We had a discussion about this in chambers. This is consistent with Graham versus Connard, and we would prefer and ask you to keep this language in as it is.
Okay. Two things. First of all, the U.S. Supreme Court has specifically stated that this is an appropriate a consideration in determining reasonableness. And number two, it is the standard jig for non-deadly force. And I'm just using the same standard in the deadly force instruction. So that hindsight language is already part of the standard jig for non-deadly force, but not for deadly force. There's no reason why it shouldn't be in the deadly force instruction.
Earl wins again.
Frank's like, but it makes it harder for us to win.
Right.
And then number 10, at the top, the title should be use of non-deadly force, and strike authorize and strike defined. Then I like the state's suggestion on explaining this TASER use. Did you get a copy of the state's? Okay.
We did get a copy of it.
All right. They're saying in this case, you have heard testimony about whether, first of all, is the state objecting to any instruction on non-deadly force?
We are, Your Honors, as we argued before, the only use of force at issue in the case is the firing of the gun, which clearly is deadly force. And so we continue to take the position that the jury should not receive an instruction on the use of non-deadly force.
Okay, and I've overruled that objection because the state's expert stated that the use of the taser was unreasonable and inappropriate. So the state's expert really made it an issue. So,
Good job.
Ab Stoughton.
Yes. Well, we read the state's proposal. We would object to the first sentence of the state's proposal and the last sentence, and then leave the balance of the
And then all
instruction.
those sentences in between.
Yeah,
those
I'm
two.
not going to argue that authorized use of non-deadly force is a defense at all. I might argue about it, talking about Professor Stoughton, Mr. Professor Stoughton, but I'm not going to claim that
Not
it's
doctor.
unnecessary. I mean, if I do, are you going to instruct before or after the arguments?
before.
Well, then I can do that.
Okay, and I like the state's language. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. I think that's accurate. And I would go down to the statutes of Minnesota provide that a police officer is authorized to use reasonable force in the line of duty, period.
Now, we would like you to say you're executing a valid arrest warrant.
Well, you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. That's so subparts 1 through 4 are just duplicative and confusing. So there be a period after line of duty, and we would strike 1, 2, 3, and 4 and go straight to you're instructed that executing a lawful arrest.
Key up all the duty
is a
comments in the
duty
chat.
imposed on officers by law.
And there it goes.
Standard instruction on
Dropping a binger.
force. And I also like the state's suggestion on the explanation. Whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
It's not an absolute defense, I think you should put, because the evidence is entered into this case, and this professor says that that was a violation too. So I just think that if you're going to comment on it, but is whether the defendant's apparent decision to use a taser was reasonable or appropriate is something you may not consider in order. Yeah, leave it alone, I'll argue. No problem.
Okay. Are you withdrawing your comments? Are we okay with the state's proposal then?
I'm in a state of confusion.
State of confusion.
The actual language, whether the defendant's apparent decision to use a taser was reasonable or appropriate, is not a defense to the charges in this case.
But I can't argue, Judge, that her decision was appropriate as far as she was concerned.
Yeah. Yeah. You can argue that she could use a taser under the circumstances.
I do have a question.
But you can't say that she's not guilty of either charge because the use of the taser was appropriate.
Yeah, but it shows circumstantial evidence that she was in good faith, that she wasn't intentionally doing anything devious.
Well, okay, you can't argue that it's a defense. You can't say she's. Yeah.
I am going to argue that Mr. Stoughton said that in his incredible opinion, he said that even what she did with the taser was unreasonable and appropriate. Read the instruction about Mr. Stoughton's opinion, and I'll point to it. That's all.
Okay.
So are you doing in toto the state's proposal here? Are you substituting it all in? Or you just help me with what you're doing exactly at the top? I may have missed it, and I'm sorry to indulge.
Okay, I am adopting the state's proposed language, the introductory language. So it'll say use of non-deadly force. That's the title. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. And then the last sentence would be whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
You're going to cross off the state's 1 through 4 sentences. I think you are.
Right, 1 through 4. 1 through 4 is effectuating a lawful arrest, executing legal process, enforcing an order of the court, or executing any other duty imposed upon the officer by law. I mean, right under that, it says you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. Do you want additional language in there?
Well, we would like executing legal process, enforcing order of the court. I mean, what we asked for was the statute, 609.06, and the language of the statute should be.
Okay, we can put okay, we'll put it, but all due respect. Okay, we'll put that back in.
They've got to get nitpicky here, guys, because this can matter.
Anything on 11?
Can I just make a record about this?
Yes.
Oh, God.
So
No.
I indicated before, I think, so it may not need repetition, but I will, just our continuing objection to have this instruction in at all.
Go fuck yourself.
And I want to point out that we also, of course, have the objection to the hindsight language in the definition paragraph here.
We object to the Supreme Court.
Consistent with the court's other.
Duly noted. Moving on.
Well, does he think he's appealing this?
And then, Your Honor, I should point out, that
Sounds like he's
paragraph.
trying to find as many things as he can argue on his next
So we're all
podcast
clear
when
about
he
this.
lost.
The first line, where in the deadly force instruction, it starts out saying,
Oh dear God, didn't we do this already?
as to each count and defense. Right? So do you see what I mean? In the deadly force instruction, that last paragraph starts out as to each count or defense. I did not include that in the non-deadly force definition so that there wouldn't be any confusion when we go on to tell them this isn't a defense, right? I just want that. So that, and then, Your Honor, if we're going to if we're going to reinsert paragraphs 1 through 4, I would ask the court to take out arrest in the next sentence. You are instructed that executing a lawful arrest warrant. All the testimony in this case has been that it was a bench warrant or a warrant. And so to call it an arrest warrant, I think it misstates it.
I just noticed, and I had a few of these. What we missed here, and I walked by, at the page 7 on column 1 and column 2 both, at the end of them, if you find that each of these elements been proven beyond reasonable doubt, the defendant is guilty. If you find any element that has not been proven beyond reasonable doubt, the defendant is not guilty. In addition, if you find that the state failed to prove that reasonable force, give me the language wrong.
Well, once self-defense is raised, they have to prove it beyond prove she didn't act in self-defense beyond reasonable.
Yes, so that should be in here, because otherwise they say, well, the judge says if they prove these elements, he's guilty. But you got to warn them. Look at the self-defense or reasonable use of force instruction. That if the jury finds that it was reasonable use of force, they're not guilty. So you got to put in there that
once you raise the defense, they have to disprove it beyond reasonable.
Right. It is on page 10 at the top of the page.
It's too late.
Is with the
Put it on
last
page
paragraph,
1.
Count 1 and count 2, where you tell them if the elements are proven beyond a reasonable doubt, the defendant is guilty. Unless the state whatever. You have to put that in there that the state has the burden of proof to prove that reasonable force. That's the language. Help me out, Paul.
Help me out, Paul.
I'm sorry if I may.
It's in here.
Yeah,
At
just
the
do
bottom of
this.
page
Do
8
this stuff, Paul.
is when the courts
Put the thing into place.
offenses, it plainly says Minnesota law provides that no crime is committed and the police officer's actions are justified. And then, of course, as the court pointed out, at the end of the instruction, it says they're not guilty of a crime.
So it's in there. You're covered. Okay. All right, and let's go back. Let's go back to page 9, the last full paragraph. I'm wondering if the language that says as to each count or defense is confusing.
You don't think so?
Okay, leave that the way it is. Is what the defense says, right?
We want it.
Okay. All right. I shouldn't have brought it up because everybody agrees, right? All right, where were we? Are we on page 11?
Well, I think we're all done with the non-deadly force changes. I did ask Your Honor to have the court remove arrest between lawful and warrant in the non-deadly force instruction.
You know what? I'm going to leave everything in there. You know, I just tried to
I'm tired
make
of your
this a little
shit.
bit easier for the jury, but if the defense wants it in there, I'm going to leave it in there. Okay, are we on
Earl has
11?
beautiful blue eyes.
Anything on 11?
No, you're.
Anything on 12? The implicit bias instruction is incorporated under duties of jurors. So 12 or 13?
Nothing from the state.
Okay. And did you have a chance to take a look at the verdict forms?
Really reject.
Oh, okay. No objection to the verdict forms either, right?
Really not a lot of argument over instructions.
Okay. Here's what
Other
I'd
than
like to
Frank's
do.
impotent rage.
First of all, yes. Oh, I like it when you raise your hand. Okay.
Simp.
Raise his hand first.
Transition out of
Head in the air.
the instructions. The defense did request an instruction on policy, and we would like a ruling one way or another. The instruction that I requested via email, which I'd like to read into the record and get a ruling from you. Brooklyn Center police policies are not criminal statutes, period. An alleged violation of a policy is not a crime, period. And we requested that on December 14th, and the court deferred ruling. We do persist in requesting that, and if we would like a ruling one way or another from you at your leisure,
frankly.
but I do want to persist in that.
Okay, I forgot about that. Does the state object?
Of course I do.
Hearsay.
I mean, it's true.
That's why they object.
It's true, but unnecessary.
Very
We're all
specifically
lawyers.
telling them, to find them guilty, you have to find these elements. And it's just not necessary, potentially confusing, to give them a specific instruction about policy.
Okay, I'm going to include it because it's
Yeah.
true. It's a statement.
So
Okay.
dishonest.
Might confuse them to hear the truth.
She ain't buying it though.
requested some language be added to the instruction because it's
prosecution wins no matter what.
I mean, it's not complete. And I'm trying to remember the exact.
Left out the part that says,
sorry, I don't have it in front of me, but
why don't you have it in front of you?
But it can be considered in determining, whether the defendant is guilty, because that's also true. Right? It is evidence in the case. So
I'm not going to talk about that. You can't consider that in determining whether she's guilty or not guilty. Plus, you don't know what we're arguing about. The Brooklyn Center policies are consistent with the law. So I'm not going to add that additional language, but where would you like that put in the jury? Where do you think it fits?
How about I put that up here?
Right at the top. We put that on the cover sheet.
Put in your pipe and smoke it, Franks.
Right after page 5, the demonstrative evidence. Charges are consistent. Fine.
You should have put that hand up now.
Page 5.
You should have raised a hand.
Can we put it on every page, Judge?
Right after
Right at the-
demonstrative evidence.
It's like a little footnote rider at the bottom.
Demonstrative evidence.
Yeah, the demonstrative evidence cannot be considered in a
What's the
in
title?
finding guilt.
Evaluation of policies.
Consideration of policies. Okay. Consideration of policies. Okay. I'll make the changes and recirculate another copy. We'll do it in 14 inch. Okay.
14 inch.
14
Whoa.
inch.
Whoa. Look at Earl.
If you notice anything
We're
at
going to
all,
notice 14 inches.
or anything, let me
Your Honor,
know
10
by
inches is just
later than
plenty.
4 o'clock. Okay. And let's see.
Judge, I'd just like you to notice that I took notice that the court has taken judicial notice
Would
of
the
14
defense
inches.
take the time, please, to
Let
look
them
at
make a record.
drive on the
For a
computer
bill.
that the state has? That because there's a computer, a laptop that's going to go
And
to
the standard of
jury room,
discourse on
right?
the show continues to
And then
elevate.
there's that thumb drive with all the exhibits on it.
You're not
So
getting
I
this
want
on Fox.
the defense to stay and look at all the exhibits so that
I
you
think we're
can
safe as long
confirm
as they don't put Beavis and
that
Butthead on
all
the
the
show.
exhibits that were entered are on the thumb drive.
12,000 of them.
Check out the computer, the laptop to make sure
Sure, there's no
that
handbrake
it's
on
clean
there.
of any other material. The laptop that goes back with the
I
jury.
want the jury enhancing these
will not
videos.
have internet
Pinch and zoom.
On their, zoom it on their iPads.
No internet on the
and
laptop there.
and then tomorrow morning, I just want to put on the record that you've had enough time to look at that, look at the thumb drive exhibits to make sure that's appropriate, and that you've also had a chance to take a look at the laptop and make sure that it's appropriate to go back to the jury room. So we'll make a record of that tomorrow. And oh, that's okay. Oh yeah, we'll do it Monday. Okay.
Did she drop an F-bomb?
Did she?
No.
Yeah.
Just a tip, though?
Judge, she was never said a curse word in her life.
About the 2 defense
Kind of what I
exhibits.
heard.
That's what I heard, too.
Electronic copies of those to put
Yeah,
on.
I saw you react. I was like,
I got that already?
We caught this.
I sent you our 2 electronic
Did you?
exhibits. Yep.
Okay. And then we try to keep track of all exhibits that were received. And I, of course, would like to think we are flawless at that, but I would rather seek some corroboration. So if the court has
Chat
an exhibit
agrees
list,
with you.
I'd like to kind of cross-reference ours with
well,
theirs,
the chat wants it to be so.
with yours, and then once we get that, we can dump all that
Thank you
onto
anyway.
the electronic stuff we need.
Okay. Yeah, Mr. Kramer's going to help you with that. Okay. What else?
Only
I
it
think
didn't say
that's it.
fudge.
All right, Counsel, I just want to tell you that I've really enjoyed having you. It was It was a really well-tried case on both sides.
I kept making
That is the
long-
least sincere compliment I
Unless
think
you-
I've seen.
unless she's looking at Earl.
You can't
Yeah,
help yourself.
Earl made her giggle again.
All
He
right.
just said, I kept making those long objections,
Okay.
Your Honor. I'm sorry.
Those 14-inch objections.
I can't do
14-inch
any
objections.
I can't do anything short, Your Honor. I can only do long. Sorry.
I don't do quickies. I only do longies.
And they're always speaking.
So I
I think
made
the
a,
judge. I think the judge dropped an F-bomb. I really do. That's what I.
I hope she
Thought
doesn't
I
watch
heard.
these streams.
I hope she does, of course.
Well, if she does, let's be sure none of us get within her jurisdiction. because that won't go well for us.
So no, I dropped a tweet about Aaron Eldridge bombing the cross exam, and some nerd from CNBC responded to it. he said join her in prison. You see, because the media narrative on it's important to remember the media narrative on this because we get lost in that by watching the actual facts. of the
No.
case.
I always go over and check CNN to see what the spin is. I'm like,
Yeah.
where is this? What's the ranking right now?
So
Like, how high is it?
what is the current spin? I mean, is she,
I think is it the same as always that she's a racist who shot him because he's black?
Yeah, it's still that right now Weeps on stand for fatally shooting Deontay Wright. It's still about the prosecutor's narrative, right? They still keep that front and center, like the prosecutor's position. They keep that front and center. It's still low ranked though because they don't have anything good. They've given them nothing good to chomp down on. It's not the Rittenhouse case where you could kind of pitch it. They've bombed it so hard they don't even have any narrative to write.
is this the
Yeah.
first team? I mean, is this the first string prosecution team, or are these a couple?
These are
spares that got-
these are the guys who did Chauvin, right?
Okay,
Or
nice.
some of them.
Some of them. Yeah.
Some of
Okay.
them who did Chauvin. Frank and Eldridge are assistant attorney generals, assistant attorneys general. So, but of course, I think it may be important to remember that I don't know that you want attorneys general assistants doing criminal cases because
Oh,
assistant district
I
attorneys
would
and
think you'd
district
want real
attorneys,
trial lawyers.
right? Attorneys
real
general
trial lawyers.
are often policy lawyers. They're state policy
Yeah.
lawyers.
Yep.
And they're not necessarily. They probably have a lot of trial experience under the belt, getting to where they are, but they're not typically doing that job as frequently
In
as.
that county,
Does Keith Ellison have a lot of trial experience?
I have no idea what Keith Ellison's.
My
trial
guess would be no.
experience is.
Can you imagine anybody saying that's the guy I want to defend me? I mean,
or
or
that's the guy I want to prosecute someone.
that's the guy I'd want to pay to render advice in any way. Yeah.
Yeah. By the way, we're the Minnesota Star Tribune has 6,200 people watching the trial, and that's about the most
cute.
on point coverage.
That's so that's adorable.
Yeah.
We've been over 16,000 for quite a while here, and
It's
I
like
think
16 inches in the court, right?
I just want to point out how encouraging it is because I think it's great that people are recognizing that they can get some actual commentary that is value added to just a broadcast of the trial and weird interjections by a journalist consulting with a lawyer in the middle of breaks because while they are bringing on lawyers who are skilled in practice in the area on breaks, the journalists may not be asking the right questions. Or even being in a position to challenge some of the conclusions that the lawyer may come to. And I think we bring a lot to the table there with this stuff and in explaining things out and then in asking appropriate questions. So I think you guys in the chat are really making a big difference in how consumption of legal matters is going to going forward. Like I said, I'm going to keep doing this as long as I can, depending on the specific trials. And I hope more people do it too, because I think it needs to happen. We need to change the scope of media, and we finally have the ability to easily and independently do it. So y'all in the chat are part of that. And I just want to give y'all a shout out.
Simpery and all.
And we here at LawTube will enable the grift by streaming before and after. You know, I know I'm going to stream, but I'm streaming before and after Nick, you know, and it's good to see everybody in the chat asking questions. I know, Andrew, you're doing stuff all over the place. I'm going to review your video with Megan Kelly today. That should be fun. You know, and Ty, you got to get a better grift going. But look, you've got your own thing.
Yeah, I've got a job. and I have tried desperately not to have a job, and it failed.
Ouch.
Well, speaking of grift,
yeah.
For those who are interested, there happens to be a Law of Self-Defense advanced class on self-defense law, January 8th, 2022. We only do this class once a year, once every year and a half. It's a law school seminar quality instruction on self-defense law, but taught in plain English, master self-defense law. The
Except it's
actual
not boring
law
like
of
a law school
self-defense
class
in a
would be.
single day. It's not boring. If you
Good.
like my appearances on the show, you'll enjoy the class. Trust me. But you can learn more about that at lawofselfdefense.com/advanced. And regardless of that, don't forget to get hard. Get the hardcover of the Law of Self-Defense Principles at lawofselfdefense.com/gethard.
Okay, so
that's at least 14 inches of book there, guys. At least
it would feel like it going in for sure.
So the real question I have for you, Andrew, is what tier of lawofselfdefense.com/advanced does one have to buy for the after stream, which is just you in a hot tub with cigars firing guns off into the night? Like
that's on my OnlyFans page.
It's Fansly.
If I get enough likes, I'll turn off the bubbles.
No.
Never turn off the bubbles.
Actually, threaten to turn the bubbles off if you don't get enough likes.
That's as one hot tube streamer to another, never turn on the bubble. That's one thing. Look, I'm a professional. You can find my hot tube streams on locals.recadalaw.com.
I like that.
Did I say hot
YouTube?
tube?
You said hot tube, but I like that. YouTube, hot tub, hot tube.
That's the Basil Hayden's toasted rye hitting right now, or toasted bourbon is it's good stuff. But no, so summary of today, gentlemen. Does anyone want to make a summary of impressions from today? I mean, I have one that I can do, but I wanted to offer any of you guys to give your opinions first.
I mean, I thought it was a good day for the defense. Their expert was good, came across well. I don't think they hurt him on cross in any meaningful way. And I thought Potter did. She didn't blow herself up. We knew there wasn't going to be any reputation damage that could really be done. I mean, she hasn't even had a complaint in 26 years as a cop, which I'm not sure I've ever heard of that happening before.
Yeah.
She cried at the appropriate time. She's clearly personally distraught about what happened in this event, this tragic event. I didn't see anything. Now all the testimony's over. I've yet to see anything that looks like intentional disregard of a known risk for death.
I agree.
Yeah. Didn't
Other
see it.
Andrew, did you have anything to add?
The ESQ. No, I mean,
What he said.
I'll go into it a little bit more on my stream, but I think that I've never seen a prosecutor and a prosecution team blow up their case like I've seen today, just absolutely implode it. I mean, they shot themselves in the foot here when they could have done it another way. They could have gone another way, or even done it in a neutral way, which didn't screw them up, but they were their own worst enemy, and I think we saw that today.
There was a much smarter way to play that Potter cross.
Yeah.
Did. And this was you couldn't do it dumber, really.
No, it's impossible. Yeah. They really fucked up.
I mean, they could have brought a hammer and literally hit her in the face with it on the stand or something like that. But I mean, they biffed the Potter cross examination. They did not get anything useful out of the expert. I mean, she attacked him with this claim of junk science, and as one of you guys brilliantly said, like an expert is going to claim that his field of science is junk science.
Yeah,
like
it's ridiculous. They're never going to admit that. Like, you're never going to get them. Like, admit what you do is junk science. Admit. I don't care if they're up there talking about Sasquatch. They believe that shit, and they know way more than you know about it. You are not going to win an argument with them.
Yeah, imagine you've got feminist basket weaving interpretive dance expert on the stand, and you're like, wouldn't you agree this is completely useless? No.
No, the only hope is for an expert like that is either you bring in your own expert who's going to say something different, which isn't going to happen here. These are very fundamental concepts. Or you can impeach him with his own writing. You know, in your book, you said this. In this blog post, you said that. And it's inconsistent with what he's saying on the stand. But if everything's internally consistent, it's very hard to even leave a mark on him. And she didn't leave a mark on him here.
Yeah, unfortunately for the state, what they had is what looks like just a standard issue action error or slip and capture, whatever you want to call it. And that's why they go to attacking the language of slip and capture itself. And that tells you all you need to know about what the state thinks about the argument. They know they cannot get to the heart of whether or not she made a mistake. They're not even disputing that she made a mistake. This guy's entire purpose is to come out and testify that people make mistakes, and these mistakes happen, and it looks like she made this kind of mistake. They haven't disputed that the entire trial. What they're trying to do is tell the jury that mistake doesn't matter.
Give us the win because.
Yeah. And I echo both of y'all's sentiments on the performance today. I think that accurately depicts it. So with that, the chat has been asking us to explain what a superseding cause is and why that jury instruction is important. And again, if either of you, any of you want to do that, you can go ahead and do that. Otherwise, I'll take a stab at it. But okay, I'll go. I'll go. So
why don't you tell us, Nick?
Typically what you have in negligence law is you have done something, you've breached your duty of trust or care, or you have violated a statute, and that creates some sort of risk. Like you negligently create the risk. We're not talking about recklessness necessarily at this point, but you've negligently created a risk by your actions, right? So a superseding cause comes in and says that even though you breached your duty, even though this risk occurred because of your actions, this other thing came in that would have caused the action even if you had not done anything, right? So you're no longer responsible. You've been absolved of your negligence because some other thing caused the harm. So if you think about it this way, that instance that we had of that I talked about earlier, where you're obeying all of the traffic laws and signals, but you slide into an intersection from some unforeseen thing. You're negligent in the operation of your vehicle because you're sliding into an intersection. However, if as the car is about to hit you or makes contact, some other car comes barreling in and head-on collisions or runs over and crushes the other car, that's a superseding cause that has caused the injury that you might have otherwise been responsible for. No longer are you responsible for that because some other thing happened that caused that. It's irrelevant to what you did. It's superseding. So in this case, they want a superseding instruction because they want the jury to be able to determine that if Officer Potter could have drawn the gun all day, the only reason she needed to fire it is because of the superseding cause of Dante Wright putting everybody in danger, trying to throw that car into gear, trying to harm these officers, trying to flee the scene. That all alleviates her of responsibility because had he just complied with the arrest, she never has to draw the taser or gun in the first place.
Now, it also goes to this whole flight issue, right? That she, in essence, they weren't supposed to tase him because he could put the car in gear and it becomes a missile, right? They'd want to argue that him doing that is a superseding cause for the harm that follows, the crash that follows, the injuries to so she's not responsible for that in a recklessness sense, that was a foreseeable risk.
Yeah. And so someone in the chat just said superseding like overdosing on fentanyl before fighting with the cops, which look,
which was an argument.
I get the meme and it is an argument, but you have a big difference here in that you have two factors potentially each contributing to George Floyd's death. And each of those factors could have independently caused those deaths. Therefore, this is the state's argument. Therefore, it's not superseding because the death occurs if Chauvin just keeps kneeling or whether the fentanyl kills him. That's how the state argues.
And it doesn't have to be the absolute cause. I mean, it just each of those might not have killed him. But if combined, each was a substantial contributor to death, that's enough under that.
Yeah, a superseding cause has to necessarily, by its own sort of facts, alleviate the guilt of the other party. And so the argument that the defense wants to make is that his flight, his resisting arrest and subsequent struggle and flight is the only reason that gun is fired, that otherwise it's not fired. and it's a compelling argument, and the jury's free to agree or disagree. If the jury thinks that that's not a superseding cause, that is not on its own sufficient to supersede the actions of Kim Potter, then they rule against it. And that's how that goes. And that's how these sort of negligence cases come up. You have contributory negligence where both parties are adding to the sort of fray. And then you have a superseding act, which negates whatever contribution may have been made. So there's the legal, the sort of plain language explanation between those. Hope that helps out to those people in the chat who are confused. Well, gentlemen, anything else to say on this case before I jump into the voluminous amount of super chats that I will read through? What's up, Ty?
Notice how this is 2 cases in a row now where the prosecutors look like absolutely awful human beings.
Yeah.
Is this a coincidence?
No. Prosecutors in general are like that. And I think I forget if it was Nick or somebody or Andrew who mentioned it, but I mean, they do get full of themselves because they have a huge win rate, right? They just take W's and W's and W's, and they get so used to these institutional advantages, the advantages that we're talking about that are baked into the system. That's why I'm asking questions with you guys. I'm trying to figure out how can we rebalance this system? How can we take some of that power away? They should not be used to just getting these easy W's all the time. Right. I mean, that's not how our system is set up. And that's not how the presumption of innocence works. Right. And we're lucky we've gotten relatively fair judges here, by the way, in both the Rittenhouse case and in this case. We could have had judges that are way more in the tank for the prosecution in both cases.
Judge Binger.
Yeah. Because there are Bingers on the bench.
I can think of a judge that I've been in front of right now that would have absolutely rolled over for the prosecution.
Yeah.
You know,
Well, Peter Cahill. I mean, again, and
I agree with that one.
I don't think people I don't know if they fully know my position of it, but it's not a secret. I believe that Chauvin was likely guilty of something. I don't know that I go into the murder statutes. I think the manslaughter was the more appropriate conviction, but I think there was sufficient evidence to convict. Whether or not the jury would was always a question. But that being said, with that, I don't know that Chauvin could have gotten a fair trial in Hennepin County, but more importantly, I don't think Peter Cahill's decisions were consistent with what we would consider a fair trial. I mean, some of the stuff that he let in with the cumulative evidence from multiple experts on the same subjects was a problem.
And that crowd. I mean, everyone standing on that sidewalk came in to testify. They were all standing a foot away from each other. They all saw exactly the same thing.
Yeah, and then when you have the juror that they refused to do the particular juror hearing for the fact that the juror basically lied on his form, that was a big problem. And you have some other issues going on where Peter Cahill admonishes the state and then ends up saying, if you do that again, I will do something. And then, of course, 1, not doing something when they do it again, but 2, not correcting the record, not actually striking things from the record that had occurred. It's like, I'm going to let it in, but don't do that next time. It's like, wait a minute. So I think there's some distinctions there, but overwhelmingly, we've got some serious balance issues in the criminal justice system. All of the presumptions are supposed to be in favor of the defendant. And the way we've built the system over the past century and a half to 2 centuries is where all the presumptions lie in favor of the state. And that's something that we all need to be considering as to what we want our justice system to look at. And frankly, a lot of people want that presumption in favor of the state. They want people in the jumpsuits. They want people in the handcuffs in the courtroom. They want people appearing by Zoom from the jail, and ignoring that prejudicial aspect of how that looks, the prejudicial aspect of access to counsel when your counsel has visiting hours. Things like that are big issues that need to be talked about. That's the type of justice reform that I'm interested in. I'm not interested in this notion of quote unquote defund the police. I think that's inarticulate. But there are issues with criminal justice in general that it sounds like Legal Mindset is on some of the same pages with me.
Yeah, we want articulate, and we also want like well thought out. We want to actually think these things out and think them through. And if we think them through, we have a discussion, we can come up with some really reasonable things that I think people on the left and the right will agree with. Right.
Right.
But we just need to think about it, right? Not go for the hashtag.
I think the things that that are being kicked around aren't going to materially alter the conviction rates, but what they will do is shore up these marginal cases, like this one and others. The other question I had, Nick, was this: I want to propose that we have a scale for prosecutor.
Well, Dante Wright had a scale, but it was disallowed.
Yeah. Well, prosecutor awfulness. I would like to measure it in micro Binghams. Micro Bingers, if we could. So,
whoa. Can we call those? Can we call the? Well, hold on. Can we call the smaller unit of a Binger a fluff?
A fluff? Yeah, there you go. Fluffs.
Yeah,
yes.
thank you.
Yes, a fluff is 1/100th of a Binger. Okay.
Yes.
So,
There
how
you
many
go.
fluffs and awful were these people? Were these prosecutors? Would y'all say? Binger is 100.
For the most part, I don't know that they played particularly unfair on a lot of this stuff. I mean, Binger was, Binger bringing up that Fifth Amendment,
Lying
Fifth
sack
and
of
Sixth Amendment.
shite comes to mind, but
Yeah.
that's me.
I mean, those were
me.
pretty bad. But
Binger was unethical, but he had a strategy.
Right.
They seem like they were ethical, but had no fucking strategy. Like, and when I say ethical, obviously the real ethical thing would be never to bring the charges, right? We're all agree about that. But
Yeah.
That aside, they've already brought the charges. Like Binger knowingly, and he went on his interview and he said this: in one ear, out the other. That's literally what he said about whatever Schroeder says to him. That is unethical.
I agree. Oh, there was actually someone just corrected me. There was actually an unethical moment that in particular in this case. And the question is, was it intentional? I think it probably was intentional, but they played video at half speed without disclosing to the jury or the defense that the video was played at half speed. And it was not the video discovery that was given to the jury was a full speed video, and it was slowed down, localized to the player at the time that they played it, which tells me it probably wasn't a mistake. That was slimy. And
Did that get picked up? I mean,
no,
oh
no, it did not. I emailed the defense team, but I'm probably one email in a sea of, however many. So and
there's really two different factors here, right? There's kind of technical legal skill, and then what they do with those skills, right? So you could have two guys that are both really good shooters with guns, but one of them just shoots targets and the other one guns down a school. Their technical skill is one thing; how they use that skill is another. Right. I think Binger, frankly, had pretty good technical skill in the courtroom. I didn't like what he did with it. I thought a lot of how he applied it was unjust, but he's not a bad lawyer. He certainly knew how to work that judge.
Mm-hmm.
Yeah.
Mm-hmm.
Yep. Yeah. Binger honestly is based on the Rittenhouse trial alone and the stuff that has subsequently come up about how he's conducting the Zeminski trial. And I think Zeminski belongs in prison for a long time, but how he's conducting the Zeminski trial is inappropriate. The fact that he asked Nathan DeBruin to answer or to identify Zeminski after identifying him for him is that is unethical. And if I were Zeminski's lawyer, I would actually have clipped my interview with DeBruin, and I would present that in or transcript it out and present that in motion to the judge. Also reference the court record where he talked about the changing testimony on the record under oath. And then say, we need to have a hearing on this immediately, Judge. And it might need to be an evidentiary hearing. Nathan DeBruin is already under subpoena for it. They could call him in to testify, but that's grounds for dismissal of the case against Zeminski. And that's the reason why unethical prosecution is such a risk when you have a guy who appears to be guilty of the arson he's charged with, not to mention the fact that he didn't charge him for the negligent or reckless discharge of a handgun, but just the arson alone, which is clearly on video. The fact that he may botch that prosecution by trying to manipulate evidence, that is the unethical danger that otherwise guilty people might walk free. You don't want that. You don't want that at all. So anyway, well, with that, I think I'm going to read through these super chats. If any of you need to go, you're welcome to. It is 3:24 p.m. Central Time, but you're also all welcome to stay. And if anything pops up, feel free to jump on. So
Yeah, I'm gonna jump over to my channel and run my stream real quick here, guys. I'll start probably in 15 minutes, and we'll probably go an hour or two before I get some sleep because it is 6:24 a.m. here. But I love you guys, and I do want to get this stuff out. But if you need to check me out, Legal Mindset, legalmindset.locals.com, Legal Mindset YouTube channel, and Legal Mindset Twitter. Check me out there. Some guys have sent me some really fun stuff. If you guys send me stuff on Twitter, I will check it. Someone literally just sent me a video, I swear to God, of Binger doing an interview in a Star Wars shirt that appears to have a rainbow on it, and the card collecting. I am totally going to watch all of that one day. I'm going to need to get a lot of soju or a whiskey or something, but I'm going to strap up and I'm going to do that one. I did Mark Richards. And shout out to the law. That sounds wrong.
Yeah, it does.
You did Mark Richards.
But the Law and Legitimacy podcast, they did a really good interview of Mark Richards. I got a lot better understanding. And by the way, you were talking about phone calls, Nick. I mean, he was talking about getting death threats and you know, his phone was just blowing up and people were saying, object, asshole, protect your client. You know,
sorry, Mark.
Yeah,
Sorry about that, Mark.
exactly. You know, he just had to shut his phone off. And I imagine, by the way, these guys, or I mean, poor Earl and Ing, they're probably getting death threats and they're probably getting all that sort of nasty stuff from the BLM folks. If they're here in our chat, they're getting it way worse.
Well, the vacuum tubes in Earl's phone probably don't heat up fast enough. So
just take the crank handle off the side. You'll be fine.
To be very clear to the chat and for the public record, I actually never endorse in general contacting attorneys on either side in active litigation. I mean, I did it to notify them of the slowed down video just because I happened to be watching all of the trial, noticed this and thought, you know, maybe I can just reach out. But it was seriously one email that I sent. And I do not recommend in general doing that. I think mobbing, one, it adds signal to noise. So if you're favorable to that person, you don't want to add signal to noise, or you don't want to add noise to the signal ratio. You don't want to do that. You want to make sure you're only sending signal stuff, and having 10,000 people all send a text to Mark Richards that says object, asshole, doesn't actually help him object. He's not going to listen to a text message. Right. So
Mark Richard reacting to that, Nick.
What was that?
Oh,
yeah.
Going off. Yeah.
This damn phone keeps buzzing or vibrating, I think they call it. It's a term not really. I don't know how phones work or what makes them jiggle like this. That's what I call it. My phone jiggles when someone calls. I might be out at the cheese shop getting some curds and my phone will jiggle in my pocket. So I'll pick it up. I'll answer it. I'll try and talk to someone. But my phone was jiggling off the hook. I think Will Smith did a song, Getting Jiggle with It or something like that. I remember. But it's not really helpful to my case. I can't take legal advice from people unsolicited over my cell phone. So all the jiggling that happened really just had to be turned off. My battery was running out in a matter of minutes every day. So there you go. Thank you.
That impression might actually be even, I might actually like find that even funnier than
well, literally, I had people when we were playing Mark Richards' voice, they're like, I'm sorry, after the trial, all I hear is Nick's voice. I'm like, he's done it. He's done it. He's supplanted the real thing.
Well, you remember back in the 80s when Dana Carvey did Ross Perot, right?
Yeah.
That's
yep.
Nick
Can I finish? Can I finish? Okay, I'm finished. Oh, it's great. Well, gentlemen, I'm going to start reading. Thank you all for joining. If you are leaving, if you're staying, that's fine too. But I know Legal Mindset, you're peacing out.
I will take off. I got a grip. The grift never sleeps, baby. I will see you all tomorrow. We'll be back on. And Nick, you're well, I guess, yeah, no.
Tomorrow's Saturday, so Saturday. I won't be
Saturday.
on.
Sorry. So nobody's on tomorrow. I'll see you guys next week.
Actually, isn't it Saturday where you are now?
Yeah, it's already Saturday, but I lose all track of time when I'm here. I'm just in this bubble. I'm like, look, I'm not sleeping. It is what it is. See you guys.
All right, brother. Okay, here we go. B.A. Krim says, are there lesser included charges in this case, or those not been decided? No, they're not. To my knowledge, it's just the original two charges. I mean, first and second degree manslaughter, I don't think there are lesser included charges. You might have the second degree as a lesser included of first if you didn't have it, but I don't know that there's a third degree manslaughter. I haven't looked. But I no, not in this case. Michael Shell says, thanks for this presentation. Hey, you're welcome. Thank you for watching it. That's why we do it. Blackguard Force says training on something and it happened in real life are two different things. When the stakes are real, the stress goes through the roof no matter how many times you train for it. Train to storm a beach and then do it when the bullets are real. B.A. Krim says sounds like bad training by the department trainers. And look, there's all sorts of juice for a civil lawsuit here. I mean, she said they don't train on slip and capture very well. I mean, they mention it, but they don't train on it. They don't train to mitigate it. I think that was powerful testimony actually from Kim Potter. They never trained me on they never put us in a dark room and told us to grab the right gun or the right thing. They didn't do that training.
They never trained to perfection. I mean, they couldn't afford it, and there's no time. I mean, the person would do nothing but be in training, and they still wouldn't be perfect.
Yeah. ACK says, this whole trial, the prosecution's been doing this. She had so much training. How could this happen thing? But it did happen, and they're not alleging she did it intentionally. The only alternative disconnect feels
Highly trained
weird.
pilots crash and die in aircraft every day, right? I mean,
well, hopefully not every day.
Not every day,
but
often. I mean, somewhere, just
it could happen on any day. I think that's true.
Yeah. Point being is that this was one of those 1 in a million situations, and maybe she just had a bad day. I mean, that does happen.
The one pilot who didn't crash and die, right? It was so odd that he didn't crash and die was Captain Sully or whatever.
Yeah.
I mean he became like a national hero. He became a national icon for a period of time because when things went bad, he didn't crash and die.
And he didn't ascribe that to his he didn't ascribe that to his skill. They were in exactly the right place when it happened.
Yeah.
Here's a really good reason why you don't fight the police when they stop you, because this can happen. If this guy had just simply acted right, this would not have happened. Okay. As you know, that's not very popular to say, but that's the reality. And I think, Nick, that's why the civil case may not be a slam dunk, because when his behavior and conduct is really put under the microscope, a civil jury may not be
right. Well, in the criminal trial, Dante Wright's not on trial, right? But in civil court, he is.
Yeah.
Yeah.
And so,
I think in civil court, the likely outcome would be a payout from the city.
Sure.
It's the difference between the family of Dante Wright getting $1 million versus the family of Dante Wright getting $15 million is the guilty verdict of Kim Potter. But the city paying out $1 million of taxpayer money.
Decision. Yeah, sure. Well, a virtue signal with other people's money. I mean, what's not to love about that?
Right. I wish I could do that.
Yeah.
200 Watt Studio says, Nick, why did they allow the close-up pic of the taser and the pic of the firearm not as close up? It makes it look like the taser is huge compared to the firearm. Why didn't they take both pics at equal distance?
Or side by side?
I don't know why they didn't, but it wasn't objected to, so that's why they allowed it. I mean, that's the short answer there. And unfortunately, we don't know. I mean, they did object. The state objected to Earl Grey showing pictures of the taser and the firearm to Kim Potter, or the two taser models. I don't know what the objection actually was because it was all in sidebar. So we don't know why they did that. But the defense chose not to object when the state showed the tasers, or the taser and the firearm afterwards. So don't know what the disconnect is fully. We can only guess. And I have no guess on that one. Cathurga says, is it true that Mr. Wright never threatened to detonate a dirty bomb in the middle of Minneapolis? No more questions, Your Honor. Billy Witch Doctor says, I can hear the smugness in this lady prosecutor's voice. Mike the Dad Crosby says, afternoon all. Didn't want to drop during testimony. My middle son had a nice write-up in the MSP Star and Sickle sports swimming section this AM. Hey, very cool, Mike. Glad to hear that.
And points for the name.
Norn Iron John says, and not a word about the Waukesha massacre, doesn't fit the agenda. JK the Slacker says, I think the Wright brothers joke was just a silly joke about the most famous Wrights in history. It's absurdist humor. State has no sense of humor. And to be fair, I'm not sure that Kim Potter has a great sense of humor. That's maybe why the joke bombed in front of her friendly audience. Mad.org says, happy birthday. Hey, thank you. Please cover the lawsuits by Lawyers Committee for 9/11 Inquiry, Explosive Evidence, and check the Unspeakable Doc on YouTube. Joe Rogan, number 1747. Thank you for speaking up. If I have time, I'll look into it, but we'll have to see. C. Goody says, Nate's gone. The cinnamon raisin oatmeal is now just cinnamon oatmeal. Very rude, C. Goody. Stephen Oglesby says, Aaron Eldridge is enough to make me quit chemo. No, don't do it. Garrett Holloman.
That's pretty good.
Garrett Holloman says, as a juror in a civil case, the plaintiff has numerous experts that they paid thousands. The defense, Hyundai, had an expert that didn't charge because of the merits of the defense. The defense expert was more reliable. Gino says, everybody in the courtroom is getting paid except the defendant. Correct. The defendant is actually losing the money at the time. Peter says, make the state track their work hours for the prosecution and provide equal compensation to the defendant in trust that can only be used for legal defense. I mean,
mechanically, you couldn't make that work because you don't know how much time they're going to spend until the trial's over.
Yeah, it'd be unwieldy in general. Let's see. I do think there should be, and in federal prosecutions, there is an action to recover the amount of money that you spend on legal defense. If you can get a showing that the prosecution was improper, that does exist in federal courts. The problem is how they actually function it out. If you're too poor, you get paid, or you get a public defender, and so you're not entitled to recovery. It caps at the cost of defense being like $2 million, I think. The people who can pay the amount of money often don't qualify for the amount that they would that they shell out. So oftentimes the people cannot afford it, or if they can afford it, they're over the cap involved there. So it's a weird issue. It needs to be better refined. I don't think there should be an income thing. Oh, well, this person is of means, therefore my unjust prosecution of them doesn't need to be compensated.
It should not be relevant.
Very right? Mad.org says people.
How is an improper prosecution not a taking in economic terms? I mean,
very good question, because
they're taking hundreds of thousands, if not millions of dollars away from you. Say nothing of your time.
And you could put that to more productive use. Like you could put that to alternative productive use, which has been found to be a taking under the Fifth Amendment. Mad.org says people raised over $200,000 for research by Alaska University, 3 years, proving fires didn't drop World Trade Center 7 on 9/11. Ongoing lawsuit by @LC4911. Evidence is all online. Evil Bunny says, I'll toss you 20. Only fair is I bought a few $100 of product / class from Andrew. Oh, and
thank you very much.
Guilty conscience.
Mrs. Branca appreciates it.
Thank you, Evil Bunny. Mr. Obi-Wan 2020 says, get the Ouija board. C. Goody says, 564 says, she's speaking in tongues. Send her to the stake. Lefties and disingenuous fucktards, probably. Billy Witch Doctor. How did they let you say fucktards on a Twitter super chat? That doesn't seem fair. Other people can't say fat. Billy Witch Doctor 99 says this
super
lady
chats intercept bad language.
Yes, they intercept offensive language, not necessarily bad language, but
offensive language. Yeah,
they clearly don't spell check.
Billy Witch Doctor 99 says this lady prosecutor is a see you next Tuesday. Okay. Tommy TK says, on the recross, should the defense have pushed more about why she quit and the attitudes about the police as the prosecution opened the door to it? Nah. I think on recross. I don't know.
What, stomp on a rake again?
Yeah, the issue that they had on recross is what was relevant to what was in scope was her statements about the police. What was not in scope was other officers' attitudes about her. And that's what they were trying to get to.
I don't even understand why they brought that up. Because now you're just making her look admirable, right? She's got she's loyal.
Well, they were very upset that all the BCPD officers who testified were clearly favorably disposed to Kim Potter. So they
were.
Yeah.
Oh, okay.
They're
So-
trying to show bias. That was the main thing.
Show
But if you
bias because people who work together liked each other.
if you
Right.
if you want to spend a lot of time saying that she felt an extreme duty to her fellow officers, 2 of which were in danger at the scene, I mean that just to me doesn't seem like the best strategy on recross.
It's prepping the battle space for the closing by the defense, because the defense is going to get up there and say, "Hey, Lucky said he would have tased her. Johnson said he felt his life was in danger. This other person said, I like and respect Kim Potter. Her former or the current chief, the acting chief, I think, said, I'd go on a call with her any day." The defense is going to say all that. So the prosecution wants to be prepared to, hey, they're only saying those because they like her as a person. They work with her, not because it's true.
But having her,
if I were on the jury, I would be insulted at such a juvenile argument myself.
Yeah, but having Kim Potter sit on the stand and just recount the profound sense of duty she has to her fellow officers in her community isn't going to help the prosecution. No. So that's why they're not going into it further. Eugene says, "Who's that doctor anyway? Do you know?" What doctor? The guy who testified, Lawrence Miller or something like that.
Lawrence Miller.
He's a pretty pretty famous from what I understand. Like he's not like some obscure unknown guy. Eddie Oliver says, "Hey Nick, Ty owes you. I retained him yesterday and I found him through you. Make him pay like the grift master that you are."
Sadly, I cannot split legal fees, Nick, or I would.
Yeah, it's that's against the rules in Texas, right?
Indeed, it is.
Yeah,
look at that smile.
Maybe I should review those rules myself.
So is there no payment for like referrals? Another lawyer refers a case to you? How do you guys work that out?
Minnesota allows it.
You have to. God, it's been so long since I don't get involved in the payment details.
This man is lying.
I only ask because I've had people ask me all the time if I would set up like a network of lawyers, that people can contact for self-defense cases. And I'm not averse to doing that, except that it takes time, and it's time that I'm not getting paid, so I can't
I
work
know the
for free.
personal injury guys. The personal injury guys.
I broke Ty.
He's going to start speaking backwards.
I
don't
know how all that works.
Oh boy!
I broke the internet. Sorry, Nick.
Ty, your if you can hear us, Ty, your internet just completely eldridged it up just now, and it's dead. Now you're frozen. Oh God, like Elsa. Razor 390 says on Pornhub, 2 old men plow 4 young prosecutors while 12 people and an Asian lady watch. Oh, come on. No.
Hey, Nick, this seems to be a Streamlabs issue. I just randomly clicked on a tab on my browser and all this stuff happened. I bet it's repeatable. Is that a known Streamlab issue?
I don't know. I can't trust you. I've seen your glasses. Seen your battery operated glasses before. Fisk the Lomback says, I think for future polls, it would be useful to distinguish between how you would decide the verdict and what you think the jury will decide. I'm sure there's a good bit of difference between the two. Well, thank you for the constructive feedback on polls. I will consider it. Braden Grimaldi says, Godfather was an officer who shot someone in the line of duty, but his partner thought he pulled the trigger, even though he never fired a round. That's how much adrenaline messes with people. Bill Potter says cross-examiner pulled her big guns, but intended to use a taser on Cross. Oops. Diego Machado says if Binger didn't play for the other team, he'd probably fall in love with this prosecutor after seeing her on Cross. Can you imagine an offspring from those two? No. We heard what it would sound like earlier, though. Polar Bear Jago says just came back from the stream. If y'all still haven't figured it out yet, Biden said that if you don't know whether to vote for me or Trump, then you ain't black. I believe that's what the other commenter wanted to say to Nate. Oh, okay. I see what you're saying. So you're saying that Nate is black, even though he may not have voted for Biden. Got it. C. Goody says, if 14-inch objections are sustained for more than 4 hours, consult your attorney. Abe Eckstein says, check out the graphic on the PBS stream. It makes Wright look more saintly than they portrayed Floyd. I don't want to see that. I don't need to pull up the PBS stream. I mean, they already have that picture with the blurred background of him holding his son with the sunlight coming behind and all this stuff. It's like, look at what a nice young man he is. It's like, someone mentioned, by the way, Andrew, we were talking about this earlier, that civil charge for shooting the 16-year-old in the head. He was actually he had his appearance for that case. The criminal case was in August of this year. So
That's just youthful exuberance. Nick.
Right. Just,
Yeah.
I don't know how many.
I guess he didn't appear for that court appearance either. Then
he didn't make it. He didn't make it. He was obstructed from appearing. Audi Joe says, "Are judges selected or assigned to hear cases? Please explain the process." There's a chief judge of different districts who tends to assign cases out in whatever process that particular judge decides to do it. I don't know. Some of them could do a lottery process. Others could be just assigned out, delegated, but it's going to vary, district to district, with the elected judge in charge being the one who determines that process. Brendan Conway says legal mindset knows how to get an attorney's attention. Ask him about the box of chocolates Richard's got. Okay. He's not here anymore. George Butch says, been listening almost daily for almost a month now. Appreciate all the time and insight from you and the panel. Happy belated birthday and Merry Christmas. Cheers. Hey, Merry Christmas to you, George. Thank you. And Helen D sent a donation. Very much appreciated. All right. And now back to the less than $20 ones. Seth Kaiser says, can you do my toast? Do a toast for my grandpa who's on life support until all the family can see him. I can do that. I won't speak for my co-host because it's the middle of the day, but I work from home and have no issue doing
We had our Christmas party today. If I didn't make that clear, I don't normally start drinking the bourbon at noon.
Seth, to your grandfather,
Yeah,
may whatever condition and ailment that befalls him currently be alleviated with a peaceful passing and fond memories surrounded by the love of his family. Jimmy J says, happy belated Nikolai. Does the Star settle civil suit today or Monday? Does the Star settle civil suit today or Monday?
Are they getting sued for something?
I have no idea who the Star even is.
Minneapolis Star, maybe the newspaper.
The Star Tribune? Maybe. I have no idea.
What do you got called the Star and the Sickle?
Gonfall says, I will steal all of your strawberry Pop-Tarts from your whole state. Rude.
All your Pop-Tarts belong to us.
Blue-eyed Roof Cree in the base says, Andrew Nick, your take on the governor's / AG's push for lawsuits against firearm manufacturers like Texas abortion law. How can Mexico use Massachusetts court to sue gun manufacturers? Well, the first thing is I find a distinct difference in the Texas abortion law and the lawsuits against purported gun owners, because in the Texas abortion law, you're not suing the person who's doing the act. You're suing a person who is assisting in the act against the statute. That's the issue. I think there's a difference there. They're specifically excluded from suing the woman for exercising her quote unquote right to an abortion. If you're going to sue a gun owner for exercising their right to keep and bear arms, you're already at a distinct difference. So I think there's room for Supreme Court to interpret SB 8 in Texas and the California proposal by Gavin Newsom differently. But the other thing is, I'm not entirely convinced that the Supreme Court of the United States is going to uphold SB 8 unless they overturn Roe versus Wade separately under the Missouri thing. And then there's going to be a whole litany of paring down and stuff that needs to be done. But again, I think the real issue lies in the fact that you'd be suing the party, the gun owner. And then the other issue lies in this idea of who has an actual standing in this case, who has standing to bring suit. And I think that's a state that's a job for the state appellate judges to pare down the lawsuit to its functional reasonableness on SB8 included. And that's been my opinion from the start. Again, I think deputizing anybody as the statute kind of purports on its face to do won't stand. I don't think a court's going to uphold that. I don't think they could.
Taking a bad idea from California doesn't make it a good idea. I don't know anything about abortion law at all. And in terms of gun law, I don't claim any particular expertise. I know the gun laws that apply to my particular circumstances, so I'm sure I'm not violating any of them. And I'm a Second Amendment absolutist. But other than that, I'm no gun law expert.
Yeah. I think there are distinctions, and I think they're going to run into problems on both laws ultimately, unless Roe versus Wade is undone, and then there is no fundamental right to an abortion. Yeah, and so then they can easily say this interferes with your Second Amendment rights without saying that it has anything to do with abortion law. So we'll see what happens. Also on the how can Mexico use Massachusetts courts to sue gun manufacturers? If a foreign state is suing a private citizen or a private business, then and they're doing it in state court, it is grounds for removal to federal court for diversity jurisdiction and, in fact, original jurisdiction over that. So if they're doing it in Massachusetts state courts, it'll be removed to federal court with and then if they're doing it in federal court, that's where you do it. You just pick your federal court.
If you're a gun manufacturer and you're in a blue state, you're a moron.
Yeah.
I mean, really,
Have they all left now? I mean, I know Smith & Wesson finally left Massachusetts. Most of the ones in Colorado, Connecticut, I think, are gone. New York State still had Remington, I think, at least the shotgun division. I think that's gone. If it even exists anymore.
Texas, Oklahoma, Idaho, Utah, if you're Florida, if you're not manufacturing in a state like that, I don't know what you're doing. I mean, you're setting yourself up for being shut down.
They're going to put you out of business if you stay. I mean, that's
Matt Hagen says this doctor looks like he helped develop the atom bomb. He's got some Oppenheimer with hair vibes or whatever. Johnny Stovall says this doctor looks like he babysat for Sigmund Freud. Rafi says, why is Barnes and Viva and Legal Bites on the stream lately? Thanks for the uplifting. Or why are they not on the stream lately? I don't know. I assume they're doing their own things. They're busy. Viva's popped on a couple times. Look, the way we all operate independently, and we love to jump in and collaborate with others when we can, but we all do have to do our own shows. That's kind of the nature of YouTube. Otherwise, we have to come up with these like weird revenue sharing agreements. And based on how YouTube pays out, like it's not entirely clear how much a video will ultimately make at the end of the day because it goes on forever. So the easier thing, I think personally, is that we all do our own things and we all try and lift up each other. And so that's kind of how it's organized right now. And by that, it means it's not really organized. People are invited to come on the show if they have time and ability and desire. And if they have those three things, they pop on. And I'm very happy for any guest who comes on. But I know Legal Bites is also visiting family right now. So she's not doing a ton of streaming because she's spending time with family that she doesn't often get to see. Alex A says, and please tell the jury if there's a code they can use to check out and get discount on these books for the expert. Daniel Gray says, Psychology Chat is going to explain why Potter said she was going to prison immediately following the shooting. He actually didn't get into that. I think that's one of the more damaging statements that she's made. And I think it's best to avoid it on the defense side. Because there isn't, I mean, you can say, she was just worried about political prosecutions and the environment she was in or whatever, but that's all going to sound weird. Just let it go. And the state didn't push on it very well. And they should have. J.K. Wynn says, Harry sent Dumbledore to do magic for his sister. Eric Marchester says, I feel sorry for that poor court reporter. Look at her hands flying in the plexiglass reflection. Mandalore says, I'm definitely engaged here. And from this guy's comment, sounds like the jury is too. President-elect Four Doors More Horse says, this is literally a 500 IQ move. Prosecution has hung their hat on she has this taser training. How could she do this? But Dr. Grandpa says otherwise. Gonfall says, but couldn't in a stressful situation you react in a different way, like being nervous? Yes. John Smith says, poopsicle. Ma N says, could this testimony actually support automatic / subconscious mens rea? There is no automatic or subconscious mens rea. mens rea is a conscious intent. It is a manifestation of the criminal mindset. The other option is not a subconscious mens rea, but a strict liability under statute, where mens rea is specifically excluded for a limited purpose. And that is probably subject to a constitutional challenge. And the state has to provide that they have sufficient interest and that it's sufficiently limited. I don't know what standard they would use, but for example, possession of illicit images of children is to a strict scrutiny standard because it implicates free speech. And so since they do that, they have to prove that it's a compelling government interest to restrict these images and that it's sufficiently narrow to only collect unlawful activity and not sweep up other activity in the process. So same thing that you'd have here. If you're trying to add mens rea as a strict liability to something like this, it would go through severe constitutional challenges. Mega Man Chronicles says, this action error stuff is just making me think autopilot engage, and you just do things automatically without knowing. Yes, that's entirely it. And people do this all the time, all over the place. It's why you forget something in the microwave, right? Like you put your coffee cup in the microwave to warm up your coffee that you forgot earlier because you got distracted. And then you put it in the microwave and you walk away. And then you're not used to putting your coffee in the microwave. So you forget that it's there because the phone rings or text comes in or whatever. This stuff happens every day. It just usually doesn't end up with death.
I mean, we all type on keyboards, right? You're typing on a keyboard. It's an automatic activity, unless you need to come up with some obscure symbol or something, and then you don't remember what the key combination was, so you have to stop and consciously think about it. But when you're typing, with any degree of proficiency at least, you're not thinking about each letter you're hitting on the keyboard.
Viva answered in chat. He says, also right now, I am on the treadmill. So yeah, thanks Viva for that. Tiki
Thanks for
71
exercising for us, Viva.
Yeah, no. Have you ever seen him flex his arms? Gosh, it makes me feel bad about my entire life and all my choices.
Not bad enough to actually work out though.
Look, there's only so much shame that I can possess. As a narcissist, I only have a little bit of shame to go around.
Yeah.
Tiki 71 says, expert looks like Nick in 20 years and many a fifths. Drew says, action error, automatic actions. Wasn't TASER always on same side of body, even with model changes, etc.? Doesn't this line of questioning hurt Potter? No, she started with it on her same side. Then she moved to a left side cross draw. Then she moved to left side support draw. And the significance of that is she was always actually following training as best practices improved to minimize the effort. It just never, it just at the critical time she failed. And that's how failure works, right? It doesn't matter if you fail on practice exams. You can take another practice exam. You can succeed on 100 practice exams, and then you go in to take your bar exam or whatever, and you fail. And people, that's how it goes, by the way. Those people who fail at bar exams often are taking practice exams. They're working their butts off, and then they fail when it comes down to game time. And that's all that matters. All that matters is game time. You make 100,000 passes as a quarterback in practice, but you miss the touchdown pass and you lose. Kieran says, sorry, Judge, I was simply overly aroused. Eric Neverick says, Nervik says, sorry, Your Honor, being in your courtroom is a new experience and I'm hyper arousal. Action errors may occur. This is satire. EFC says, to people who say that Potter could not have mistaken her gun for a taser, send them the video of an invisible gorilla walking through a stage. That's what I talked about earlier. There was a study, or there's a video where people are asked to count the number of times a basketball is passed on the video. Now that I'm saying it, it's going to ruin it for you, but most people will watch the video. They'll be sitting there counting up all the times this group of people pass a basketball. And in the middle of all that, a gorilla walks across the video, a guy in a gorilla suit, does like a moonwalk, turns around or whatever, and then goes off the screen. And almost no one notices it. We have conflicting Ty Beards here. His internet, Ty, your internet is not happy with this.
The clone copies keep replacing each other.
Yeah, it must be on your upstream right now. It could be time of day in the building. Who knows?
No shit. No shit. Yeah, we're still
not applicable. Says the technical.
Well, yeah, and we haven't got the wires dropped yet.
Yeah. You're really choppy right now. So I'm going to keep reading super chats. If you clear up, we'll talk more.
There it goes again.
Not applicable says the technical term for this is pocket rocket. He also says
Yeah,
this
talk to you
woman is
later,
a
man.
robot. Okay, see you, Ty. He says this woman is a robot. That's just her circuit board. Bogey 34 says if you stare long enough at the prosecutor's flat chest, you'll see Jeffrey Epstein didn't kill himself. Crusader says Kroger brand Marsha Clark. Lukey Dookie says in dash cam video, Kim told Johnson she knew the Wright brothers, right? When this planned to her knowledge at the time, bring in criminal history. I think she was talking about the Wright brothers who invented air travel or airplane flight. I think that's who she was talking about. God's Monkey says Florida professor is based. Ian Smith says having the prosecution repeat the question about impatience twice shows that he's inside her head. This guy's owning the cross. Danny says she's like a deer telling a lion how to hunt. Toasted Foolery 71 says Merry Christmas, Nick. Panel and chat. Favorite Christmas movie and why is it Bad Santa? Bad Santa's a good one, but I'm going to be basic and say Die Hard. Do you have a favorite Christmas movie, Andrew?
Die Hard's right up there.
Wazapalooza the Drunk says these defense witnesses are making the prosecution look like amateur night at the Apollo. DCV Titan says, I'm starting to hear the doom music with the prosecution at the podium, the mental image of them putting the super shotgun under their chin. No. Jamie Deselm says, I am just guessing, but the prosecution's continued impatience and crosses demonstrating their lack of training in managing and controlling stress. And that seems to be a common theme for prosecutors to me, that they seem to be prone to explosive sort of, well, not explosive, but just emotive reactions. Have you noticed that?
There's a certain degree of lack of emotional control. I mean, they're making emotionally driven decisions as opposed to, what's the mission here? What's the goal? What's the end point we want to get to? And what's the best way to get there? It's not being emotive. It's not, especially none of that stuff Larson did all trial.
Right. And same thing with Krause, right? He's displaying his reactions and his disdain for what's going on in the court constantly. Juries see that, and I don't think it looks favorably.
No, keep that on the inside.
General Sorty says this prosecutor loves asking the same question worded a million different ways. James Ligon says, me, sad face, because so many people in chat and my comments are overlooked. Sorry, buddy. There's 10 to 15,000 people. I try to catch a lot of comments, but I'm also trying to watch the stream. So Whale Ears says, is it not true, Galileo, that your research is new and called junk by the church? This prosecutor, probably. Evan Bouchong says, I'd characterize this entire prosecution as weaponized incompetence. General Sorty says, the prosecutor's case dying before the jury's eyes, not that they had much of one. Stephanie King says, hey, from the UK, love your coverage and comments. Say thank you. Learning so much about U.S. law. Have my favorites on the panel. Not saying who, by the way, Earl Grey rocks. Love him. Well, Stephanie, I will take that as a personal slight, but thank you. I appreciate the comment there. Warren Lee says, Attorney Eldridge, an example of an action error is your voice breaking and starting to cry, which is a throwback to your childhood stress response. Streaky says, you can't checklist pulling a taser in a scenario like this. American Virus is Freedom says, I have been surprised that no one has brought up the amount of reps the police do with guns versus taser in training. Yeah, someone mentioned it's something like 400 or 800 to 1 gun versus taser.
It came up on direct or redirect today with Potter. It was like 80% to 20% gun to taser.
Yeah.
I think that's wrong. I think it's more gun.
I think so. Yeah, I think it's significantly more. I think you're pushing north of 95%. Because gun training is so, it should be, right? Gun training is deadly force. It should be more critical to use it appropriately, and it poses a greater risk to the people in the area. Boomer Wow says Lucky's yellow taser was in Potter's peripheral vision right next to her gun. With or without tunnel vision, this could happen. Pancake Third says prosecutor Karen shouldn't quit her day job of being early 90s one-hit wonder folk singer Lisa Loeb. Expert witness Donald Sutherland handed her a massive L. Steve says spark tests aren't done like you're drawing your taser. You can do a spark test after picking it up from your locker shelf prior to donning it. I agree. And ideally, I think that's what they're wanting. You grab the taser, you spark test it, you holster it, and then you go on with your day. I mean, that's the idea, I think. I don't think it's already in your duty belt, that you draw it out like this, You say taser, 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 spark test, and then do it. And no, it has nothing to do with how you draw a taser. Kieran says, subscribe to Nate the Hoof Guy. Great videos on animal foot trimmings. JC says, thank you for these 3 a.m. law lessons and fun commentary, y'all, in Australia. You've made waking to tend my 3-month-old a lot more entertaining. Hey, thank you. Radio Ruin says, a hoof guy is called a farrier. Deleo Turk says, forget the lawsuit. The Nates need to do a team up. MB says, if Dante Wright's family sues Potter in civil court, would any proceeds then be subject to further lawsuits from Wright's victims? If Dante's family sues, his estate is not suing. So no. However, if they sue Potter in civil court, they'll likely be including the whatchamacallit, the prosecution or the state itself, the police department, the city of Brooklyn Center, and maybe even the state of Minnesota. But because that's who's going to have the money.
I think they're asking the people who were suing Dante Wright for the injuries he caused to them.
Yeah.
But those people are not suing Dante Wright's family. They were suing him, and he's gone. So
yeah, they're suing him. I think some of the suits are persisting against his estate. But if his family recovers from Kim Potter or from the city, that money is not going to the estate. It's going to the family, and you would have to have a pretty significant happening to somehow get access to it, or they'd have to make a grave mistake and have the estate sue. But the estate doesn't have an interest in what happens afterwards typically. J.L. Haynes says, say it like she's surprised. This is MAGA country. Wilder's Honey says, my father-in-law had his femoral cut by a doctor high on coke and drunk. It happens more than people know. He died 3 times. Damn. Roy Merlunos says, tasers have been around for 40 to 60 years. One notable incident of taser blammo, and the prosecution is questioning Miller how many planes have fallen out of the air. James G says, JFK was more of an inexperience issue. Flew into what was likely instrument conditions without having proper training. This likely resulted in vertigo and a death spiral into the ocean. Yeah. From what I saw, or what I read about, his vision would have been all gray. And so what happens sometimes is if you get into a death spiral, the inertia of the turn outweighs the gravity distortion of being pulled to the left because you're pulled down into the seat. So you think you're flying level, but you're actually flying not level, and your plane is banking in a spiral as you descend into the ground. So that's what I
overspeed the airframe. You rip the wings right off it.
Yeah. So that's what I've read about. But yeah. Baxter says, I'm worried that the jury will totally write off the defense use of force expert because he will testify for the Chauvin cops. Jurors are stupid. I don't know that the jury has any idea that he's going to be testifying for the Chauvin cops. I mean, I don't even know that that's true. Someone mentioned it in chat, but that's all I know about it. So they would have to specifically look for that. And maybe they will see it. Who knows? Air Chunk says, if you would stop overruling the objections, that would be great, mommy. I mean, Your Honor. Locknav Livok says, my mom would describe my existence as action error. Still Sharfrichter says, did they say Kim never used her firearm or taser in duty before?
Yep. Never fired them. Yeah,
that's been brought up prior to her testimony and then again on testimony. But funny thing, she lied on the stand. She did fire her firearm on duty into Dante Wright.
Right.
Loretta Silver member says, Kim is going to be so hot on the stand. I love women on trial. Stop it. Q Revere says, if doctor-patient confidentiality is easily overcome in court, why aren't we seeing the therapist notes in these school shooter cases? It depends, but it can be overcome. It can be overcome if they need to. And look at this. I mean, they even said that he had a diagnosis for Kim Potter that they weren't allowed to discuss, but they got to the notes of what Kim Potter said. They were able to read the report, and the report is, going to encompass the contemporaneous notes that the doctor decides to put in the report. So
that's because that was the foundation for his expert opinion offered in court.
Right.
I guess, but it wasn't. He didn't really, though, did he? Because he didn't say He didn't say she experienced action error. Yeah.
No. I'm just telling you guys, don't rely on doctor-patient privilege. Don't rely on clergy privilege. I mean, you might get them, but a lot of times, attorneys can subpoena those notes and may be able to get them in.
Definitely don't rely on spousal privilege.
Definitely, exactly. The most solid privilege is attorney-client privilege. It really is. It's the most solid privilege. Your lawyer can be your confidant if you pay them for that, and that's the scope of it. That's the most. But even that's not sacrosanct. It's not unimpeachable. It's just the strongest privilege that exists. Corey Boatwright says, think of training as a vaccine to mistakes. Only has to be effective 20-40% of the time, right? Michael Milano says she unclicked her holster and the expert testified about things mitigating slip and cause errors. Does her unclipping her holster become reckless? That's not actually a fact that she did unclip her holster. It's now a fact in dispute. They're going to argue that she did. I don't know that she did. All I saw was her hand go to her belt on a blurry ass video. Chris K says Cross and Potter will last till Christmas Eve or until she says I shot him because he looked like that N-word from Empire. And this is MAGA country. Rano says they forgot to add in trotting the globe saves orphans for free in spare time. HG Gundam Play says Nate the Hoof Guy is a bovine hoof doctor treating and trimming hooves on cows, on beef, and dairy farms. Jam Corp says I emailed you a meme about the expert from yesterday. I think chat will appreciate if you can get to it. Not applicable says lady cop. Are you a lady? Then why are you a cop? Baffled Buffoon says thanks for the clarification of my channel, Nick. Hey, you're welcome. Fran Moore says, do any of you think there are times when a defendant on a murder trial should testify? I mean, it's tough. It's tough. The rule is no, but you always have specific cases. I mean, in this case, Kim Potter did very well. She did very well. She probably didn't hurt her case. She probably helped her case a little bit. There you go. Mark Richards suggested that for Kyle Rittenhouse, you're going to have a self-defense person testify to their defense in Wisconsin. I don't know if that's true, but that's his impression of the jury. And again, he won. So Chris Friday says the judge just slipped and captured called for the prosecutor, not the defense witness. Yeah. Not applicable. Message retracted. Go Burns says, forgot to wish you happy birthday yesterday. Today is mine. Happy birthday, brother. Been enjoying your streams and content for over a year now. Happy holidays, everyone. Gunner says, gotcha. Here's a criminal complaint against Dante Wright that you received in 2019. You lied in your direct. The state rests. Photo Hive MD says Phantom Hive D Hived says the female prosecutor made an objection. I think she will be on cross. What do you think? I didn't think she would do both of them, but she did. So you nailed it. Blurry Light says, since the female attorney is making the objections here, does that mean she will be doing the cross-examination? Pride or Honesty says, Potter, I don't think that necessarily means it, but that ended up being the case. Pride or Honesty says, Potter's demeanor explains it all for me. Her being out on patrol is like blood in the water for violent criminals to escalate when there's contact. Gonfall says she's definitely innocent. There's no way this is intentional. I feel like this is just the left going after guns again and after police. Marine Incident says, will your sons be home for Christmas? That right there probably won the case for the defense, in my honest opinion. Assuming something terrible doesn't happen on cross, I'm a little behind. Yeah, that was a good question.
Smart move.
Kids are coming home for Christmas.
Humanizes her.
Jonas Wheel the Fourth says, we're going to need that box. What box? The box we're going to stand on so they can kiss our ass. Kyle Bogue says, putting an officer with a squeaky clean record into prison for 10 to 20 years for an accident is absolutely the most absurd thing I've ever heard. Screwtape Game says, she said the line. Gonfall says, trolls in chat saying she's guilty. Lol, ignore them. They read BuzzFeed. Z. Michael Gelke says, I think we need to hold the black supremacists who terrorize this woman for an innocent mistake accountable for their acts of hate. Enough black privilege ruining lives. Kingslayer Damocles says, I feel bad for this lady. Bad cops and bad internal affairs investigators caused the climate where good cops get charged. Pancake Turd says, I'd rather rip off my Sergeant Johnson and throw it in the river than listen to another minute of Prosecutor Girl Boss. Lamer says, Potter's face is the one I have when I answer the 1,000 questions of my 3-year-old cousins. Oh, God. Pissed Off Patriot 83 says, don't tase me, bro. Henrik Syvertson says, this is not an evil killer. She has a good art and had good enough suffering from this. I don't get why they have to add to it. Z. Michael Gelke says, are prosecutors the kind of people who read PowerPoints? This clears up so much. Blue-Eyed Roof Korean says, Cruella, the witch prosecutor, has a 5-head. Robin Camp says, the cross of Kim Potter has convinced me that this was an accident. You can be told anything repeatedly, yet still make a mistake. Nudge says, Mr. Branca, can you cry havoc and let slip the tie of constraint?
Soon.
Lil Binger says, goes to show annual training without casual use and practice is more of a cover your ass thing for the department than it is to make you competent.
Exactly.
Kyle Bogue says, it's not Rugrats, it's Stewie from the movie when he's all grown up. That's what the weasel looks like. Uriah Wright says, object, Your Honor. We need to repeal the 19th Amendment so we have 0 empowered whammons. Tube Amps Rule 1 says 2021, the year sport commentary was replaced by the case commentary by Team Law. I love it. You know who's the best at that? Legal Mindset. He's like, so in this instance, here's what should have happened. Like he feels like a modern day John Madden or whatever. It's like the prosecution's going around the outside, but the defense comes in and blocks magnificently. They came out of nowhere. Wonder Bucket says, is a long range taser heavier than a normal taser?
No, and they probably both have the same range actually, but it's the angle at which the darts come out relative to each other, either close together. So when they go out a certain distance, they have the right spread, or they spread at a faster rate to be used closer in.
Get out your protractors, guys. It's 3.5 degrees versus 12 degrees. You can look at it the exact spread. And anybody who thinks that, like, if you get tased at a 3.5 degree arc at a foot or 2 feet away, that isn't effective, like, try it. I would say try it sometime. You might not get the same level of neuromuscular incapacitation, but you do. It's not like it doesn't work. It's not like the taser doesn't function, and you may still get the neuromuscular incapacitation. What they want is above the belt line, below the belt line, so it hits the entire body by having electricity travel through 2 major nerve clusters that control the top and the bottom halves of the body. That's why they're talking about it. But neuromuscular incapacitation on the top half of the body can be extremely effective. Effective in incapacitating a subject. Same on the lower half, depending on the circumstance. I mean, again, if tasers hit both hitting your leg and it locks up your lower body, you can't run or move or walk forward. So they're splitting hairs on the effectiveness of tasers here. Adam Trapp says a 223 round is just a long range 22 round. So there you go. Oh, but one thing I wanted to say about that with the tasers and the weights, no one picking up tasers and guns is sitting there, unless they're specifically trying to pick up the weight, is considering the weight of this thing. You pick it up, especially if you've done this like 50 times, like if you've drawn your taser 50 times, your gun 50 times, you're not sitting there going, oh, I've got my taser in my hand. I don't think, maybe I'm wrong, but I fired multiple guns of different calibers and different sizes. You might notice the weight at first. After about 1/8 of a second in non-stressful situations, the weight becomes irrelevant because none of these things are all that heavy.
And it's not a 25 pound and a 50 pound difference.
Right.
I mean, it's 1 pound and 2 pounds. And once you get into small weight measures like that, it's very difficult to detect any difference.
Yeah. I mean, the reality is you're holding out the gun or taser and your arm's not tired because it's not that heavy. And that's about all the processing your brain needs. Adding more to try and determine the weight takes extra effort. And unless you're focusing on it, that's effort your brain doesn't need. Murderbit says, always a state of high arousal watching Rekieta Law. Oh, thank you. CS says, when your case hinges on multiple conflations. Paper City Gamer Jeff says, I think being on a jury must be hard. This is so slow getting to any points. Blue-Eyed Roof Korean says, how risky is redirecting defendant? One and done. They did a pretty short redirect. It was just like 5 questions, I think, something like that. Not very many. But yeah, it's going to depend on what they did on cross to answer your question in real time. But I think their redirect was appropriate. They got some more good stuff. And again, they got to sympathize, or they got to give the jury the opportunity to empathize with Kim Potter. Good person, loves her fellow officers, saw them in danger, tried to act, made a mistake that anybody could make, and she deeply regrets. I mean, if they're going to put her in jail for that, they're going to put her in jail no matter what. Ray Halleck says, I'm never hanging out with anyone named Lucky. It never goes well. Not applicable says, let me post this Google skateboard point eyes. And says her style sounds like she's aggravated that they make her stand up there and ask people pointless questions. This lawyer hates her life right now. My left little toe. Welcome to Paralegal Status. Robin Camp says the condescending manner of the female prosecutor is very off-putting. Really now says that was just to torture Kim. What a jerk move. Lochnav Livok says they're drinking Dasani to prison with them. Amelia LT says with the paper they've shown where the confusion came from, the question should be, do you have paper object in your hand during training? I guess not. Lochnav Livok says, in Romania, even if you drive legally and somebody suddenly jumps in front of you and dies, you have a high chance to go to prison. Kyle Guerrero says, most law enforcement in my area uses the term less lethal over less than lethal because there's still risk of death by taser, as if the electricity affects the heart, it could cause cardiac arrest. Again, I know a lot of people get, oh, you need to do this now. Give me, Andrew, you want to plug your book for just a second?
Sure.
Sorry. Be right back.
So, ladies and gentlemen, you may have heard about the upcoming Law of Self-Defense advanced class. This is the equivalent of a law school seminar, semester-long seminar on self-defense law, taught in plain English, the same course that many lawyers, prosecutors, judges, police officers take for continuing legal or other professional education, but again, taught in plain English and suitable for anybody. If you've liked my appearances here on Nick Rakaita, you'll get the same kind of delivery for our full-day law self-defense advanced class. It's taught live by me in person over Zoom, streamed right to your computer, so you don't have to go anywhere. Enjoy it from the safety and security of your own home and convenience. It's Saturday, January 8th, 2022. There are only limited seats available, and they are going fast. We only teach this class every year or year and a half. So if you miss this January 8th class, it'll be into 2023 probably before we do the next one. So if you're at all interested, I would encourage you to take a look sooner rather than later, because once the class fills up, it is filled up. You can learn more about that at lawofselfdefense.com/advanced. And you might also consider picking up a hardcover autographed copy of our best-selling book, The Law of Self-Defense Principles. The hardcover version, they come autographed. You can get that at lawofselfdefense.com/advanced. We do also have the soft cover of our book that you can get for free. We just ask you to cover the cost of shipping the book to you, shipping and handling. You can get that at lawofselfdefense.com/free book. By the way, here's Nick. All right.
All right. Thanks.
I was grifting hard, man.
I appreciate it.
Lawofselfdefense.com, grift hard.
Yeah, sorry, I had to take care of something. We have someone who needed something at the house and they're about to leave. Free Golem says that pre-litigation thing sounds like extortion. Blurry Light says, what effect would requiring no, pre-litigation just is pre-trial litigation, and it's how 98% of cases are dealt with in the United States. So
they don't go to trial.
It costs a lot of money because the amount of hours that you still have to put in pre-trial is still huge. Right. By the time you get to trial, in a case like Kim Potter's, if you're not six figures deep, you very well are close. It's just how it goes. There's a ton of interviewing and document review that has to be done. There were 1,000 exhibits in the court record. That means there's 5,000-10,000 things. Some of those things are manuals of tasers going back 26 years that are, dozens to hundreds of pages long that they have to go through. 700-page police policy thing. The lawyers read it. They read all of it, or at least skim it for relevant sections. Yeah. All of that stuff just takes time and money. Blurry Light says, what effect would requiring officers pay their own insurance against civil lawsuits have? I don't think it would have much effect, because the underlying legal principle is that most of the time an officer is not liable for stuff that they do in the line of duty.
Right. So then normally they have qualified immunity, at least from suits, and there's no insurance against criminal liability.
Right.
We don't do that. So
Yeah, if you have an intentional act that's overtly intentional that violates the scope of the employment, you're outside of the shield of the law enforcement agency, and you're similarly not going to be covered by insurance. Like if I walk up and murder someone, they're not gonna do that. So, and that's another distinction why the mens rea aspect of criminal law is so important, because it does distinguish from civil law in that way. This is no longer a negligent act. It is now something that involves an overt or intentional act of disregard, and therefore insurance is going to be out the window.
yeah, it's why most of these self-defense quote unquote insurance programs out there like CCW Safe and others, they're not actually insurance. They're not selling you an insurance policy. The good ones are themselves insured for payments they make out, but they're not selling you insurance, because it's kind of it can be a gray area whether self-defense can, as a matter of public policy, be covered by insurance, because in one sense you shot that person intentionally, and normally intentional acts are not covered by insurance as a matter of public policy. On the other hand, the argument can be made, often successfully, that you were compelled to act, so it wasn't really a voluntary act in that sense, and then maybe you do have insurance coverage, but it's sufficiently a gray area that most of these companies that offer these plans, they specifically don't sell them as insurance.
Irie WOW says, I think the joke about Wright brothers, but not the ones that flies, about the inventors of the airplane. No, don't think someone did a racism. I don't think it had anything to do with racism. Aldrich, and again, if there was any hint that Kim Potter was even remotely close to racist, it would have come out of trial, especially when she's taking the stand. There's no doubt, if they had any evidence that she ever did anything close to it, that would have been brought up. Aldrasai says, a legal mindset. I've tried the regular soju and it's awesome. What flavor should I try next? He's not here, and I don't know about soju. Angry Baneling says, training mindset, legal mindset's new channel. The Roach Den says, that lady prosecutor has her girlfriend tied up in the basement, I bet. Rob Dorr says, the in-service training is a joke. When I worked at Hennepin County Sheriff's, most deputies crammed the online training at the end of the year. Just click through. Harmon Arman, welcome to Paralegal Status. Yeah, I would believe that fully, Rob, because look, these guys are out doing police work. I mean, that's what they do, and their police work doesn't really change day to day. So to have some outside of specific trainings, to have some paper pusher come in and teach you about your taser that you use or whatever, do you care? Like, you know how your taser operates. For the most part, you know how your gun operates. You go do your range time, and that's fine. But all of what is a PowerPoint going to help you with your gun that you may draw on any given day? Not really. Justin Filson says, has anyone in the case testified if she was a house mouse or a patrol officer? 10 years behind a desk, training can't make up for lack of experience. The original reporting on it was that she had spent the majority of her career behind a desk, but it seems to be contradicted by today's testimony. It seems like she was a patrol officer for her entirety of 26 years. Now, how much she does patrol on that, I don't know, but she seems to have been in the field. Black Tiger 001 says, Nate, did Binger help train with the ass baton? Matt Hutchinson says, I've been watching the whole trial on your channel, but I'm still confused. What exactly is the charge, and what does the prosecution need to prove to win a guilty verdict? 2 charges, manslaughter 1 and manslaughter 2. Manslaughter 1, they have to show that she intended to assault Dante Wright. In the case of police use of force, it means that they would use excessive force or unjustified force. Police officers are presumed to be using reasonable force when they're effecting arrest, unless it becomes excessive. At least it goes beyond the quantum of force that they would need to respond to an incident, because they get to use force to effect arrest. So then if the suspect uses some level of force higher than nothing, then they have to escalate appropriately in response. So they would have to prove that she exceeded the amount of force that was necessary and therefore intended to cause an assault, and that led to a death. That's manslaughter 1. Manslaughter 2 is that she was culpably negligent, which is gross negligence, which means it's higher than an ordinary level of negligence and has a side of recklessness attached to it, where she consciously disregarded the risk created by her actions. The way that Andrew and I seem to think of this means that she has to know that she's got a gun in her hand, because she has to disregard the risk created by the gun, because she didn't seem to disregard any risk created by a taser. And if that's what she thought was in her hand, she can't consciously disregard the risk unless we see that she consciously disregards the risk of a taser. I don't see that they get it. So hope that answers your question. Not applicable says chat. Get Nate to do Rafiki. That would be glorious. 310 SoCal says, what about the 26-year-old Hispanic in Denver, Colorado? His truck brakes failed on I-70, killed 4, and he got 101 years. It was not intentional and was an accident. Look,
no, but it appears to be reckless. So first of all, he's a professional driver in the mountains on Colorado. There's lots of truck runoffs that people can take specifically there because trucks do overheat. There's signs all over I-70 cautioning about brakes overheating, testing your brakes here, being aware that there's a steep grade coming up. And he chose none of those turnoffs and just ran until his brakes were cooked, and then he killed people. So
yeah. And did they have any evidence that he tried engine braking or anything?
No,
like
I haven't read the case, but listen, you got 80,000 pounds going down a steep grade. You're not engine braking anything.
Right. But it might go to mitigating his culpability is the only thing I was thinking. But yeah, I mean, I've driven on, I don't know if it's I-70, but I've driven in the mountains in Colorado. There are those truck turnoffs are everywhere.
Everywhere. Yeah. It's the major highway going east and west through Colorado, through the mountains.
Oh, okay. Yeah. Then I probably have driven on it. John Coyle says, but yeah, the other thing is, did he consciously disregard his duty to check his brakes would be another question in the case. So, and again, he is driving a vehicle, a truck. He's driving an 80,000 pound, as just described, truck. He is aware of a risk. He is aware of a risk at that point, and then to consciously disregard the risks associated with that.
And it's not an instant disregard, like the case with Kim Potter, where things suddenly go chaotic and she's got 6 seconds to make a decision.
Right.
Over a long period of time driving down I-70 that this is an issue that you need to be paying attention to.
I had it happen on my when I had a minivan. We were driving through Montana, and I wasn't thinking anything of it. I was just braking, going down some not super steep grades, but long, consistent grades, and cooked the brakes on the van. Had to get them, no, I didn't have to get them fixed, but they were smoking.
Yeah.
And we had to let them cool off.
Right.
And so the solution for that with a van, not a truck, obviously, was just to engine brake going downhill, which there are giant signs that says use the lower gear, on the downgrades. But I had never run into that before, despite driving in the mountains several times. Just in this case, we'd had a long day. It was warm out, and that happened.
Yeah, if you go up to Pikes Peak here, which is not far from my house, when you come back down, there's like a little wooden guard shed in the road, and they stop all the cars, and they have a little, infrared temperature pistol thing they put on your brake rotors, and they're almost always too hot, and then they make you pull over for 15 minutes to let the brakes cool down.
That Pikes Peak drive is pretty steep.
Yeah, I like to go during the week. The weekends get a little crazy with the traffic, but it's a fun motorcycle road.
I bet it is. John Coyle says JFK Jr. is a bad example. He didn't have an instrument rating, and he was flying in IMC, not action error, lack of necessary training.
Probably.
Lori Tony, thank you for joining at paralegal status. HMFIC, thank you for the donation. Mo Jorison says Bronca keeping that noose on until the cops get there. Dursek says, Ty, thank you for your help, counselor. You're a great Texan and a good example of what many want to see in a lawyer. Joy May says, wish I had Andrew's class in book 19 years ago when I wrote a paper on self-defense for my master's degree program in forensic science. Blue-eyed Roof Korean says, use the new charge, the family Michigan doctrine, declare the prosecutor's family members as having a corruption of blood as sins of the father's doctrine. Dalton Bebout says, I've been listening almost daily since Rittenhouse. I'm now getting geared up to take my super liberal law student cousin, or to take on my super liberal law student cousin. I can't wait to go home and binger myself afterwards. Alpha Ibra says, what's the panel's thoughts on Gavin Newsom planning these Texas abortion style laws and related to the Second Amendment? We talked about that earlier. Kendall Seeger says, first time super chatter here. Hey, thank you. Just want to say happy belated and thanks to you and the panel for these streams. I love spending my work days with y'all. Also, thoughts on 110 years for Colorado truck driver. We just talked about that too. UNSC forward unto Dawn says, someone get a priest. To be clear, though, I'm not familiar with the truck driver's like facts, but I also did say a jury can still find you criminally negligent. It may not be proper. It may not be the legal standard, but juries find things that aren't fully the legal standard all the time. And sometimes they get appealed and overturned, but it's that's a jury. Mandalore Wise says Bronca probably knows this, but my understanding of post self-defense communication with officers is I'm in shock and I need a lawyer.
Well, if you take our class, Law Self-Defense Advanced class, we spend about 45, 50 minutes talking about nothing but interacting with the police in the aftermath of a use of force event. That's Saturday, January 8th, 2022. Learn more at lawofselfdefense.com/advanced. And thanks.
Rhino says Alex Jones was right. These people are demons. Jared Vautrat says prosecutors like Krause getting back at a middle school bully. Peyton Kern says that was almost harder to watch than Binger. Danielle Savoy says, love when you predict the testimony so acutely. Also, why am I just noticing today that legal mindset is hot? Oh, you need to stop. No simping in the chat. Very, very, very embarrassing. Demise Glitter Sword says, in other words, if Dante Wright hadn't had that paper in his hand, he might be alive today. Literally, yes. Very possible, because that paper transferred to Kim's hands, occupied her left hand. She drew with her right. Stephen Oglesby says, for Andrew, 300 blackout subsonic is great for home defense.
Probably. I don't own one myself, but I hear good things about them.
Fisk the Lomback says, if I was in that jury, that prosecutor would be getting a burning stare from me. Mad.org says, right. Jace Nemhard says, the prosecution is going to look real dumb. Is the prosecution projecting? Lady Ziplock says, she was consistent. Even when the Miller report would benefit her, she did not remember. Very credible. TLJ Screwjob says, worse, Eldridge with cats or Krause with lunch. Adolf E. Newman says, at Ty Beard for low-key bragging about his elite penthouse lawyer office. Nah, just joking. You deserve it, sir. That's really cool. Blue-Eyed Roof Korean the base says, poll doesn't reflect reality of communist jury. I don't know that we have a communist jury, honestly, but we'll see. Fran Moore says, why do prosecutors ask after the fact, why didn't you take some reasonable sounding action when no one ever does in that situation? Binger tried to do that too, didn't he? Because they want the soundbite for closing argument.
Right. Binger said, why didn't, after you shot Rosenbaum, why didn't you just stay there? Stay there. You know, explain to people what happened.
just set your gun down on the ground, bro, and back away from it slowly and sit down in a cross-legged position, pour gasoline on yourself and light yourself on fire. Why didn't you do that? Why didn't you self-immolate? What's wrong with you? Allison C says, no faith in a not guilty verdict from a Hennepin County jury. Evan Bouchong says, Bronca, I've been following you since your first appearance on Timcast. Had no idea you were this funny. Wishing the best for you and your wife, and a Merry Christmas to the whole panel.
I appreciate that, and Merry Christmas. Right back.
Brad Hobbs says, theory, Aaron deliberately did it to trash the case to help Potter. No. This theory kept coming up during Rittenhouse too. Prosecutors don't operate that way. If they wanted to drop the case, they just drop the case.
Right.
Nayland says, I wish we could see the jury reaction of the prosecutor's cross on Kim Potter. I only hope the defense let her do that because it made them look bad. Jager Thompson says, law of self-defense. What do you think about that LaRue Bratcher case coming up? Black guy shoots intruder breaking into his business. I don't know much. Hey, I think I just sent you that last night.
Yeah, I looked at it last night. It looks like a bad shoot to me. His business was a illegal marijuana grow hut. He shot a guy in the head who was still outside of the building. Doesn't appear to have had any weapons. For all we know, the guy was banging on the door hard and got shot in the face for his trouble. So it doesn't look good to me.
Yeah, it's you don't want to be, by the way, guys, if you're ever in a self-defense situation, you don't automatically fully lose your right to self-defense under illegal circumstances that are aside from the self-defense, but you can. And so don't be engaged in illegal activity if you're going to engage in self-defense. And if you are engaged in overtly illegal activity, like unlicensed growing of marijuana, do not engage in a quote unquote self-defense action. Try and escape, try and retreat, make it, you have to make it so that it's the last possible option because your presumptions are all gone.
Yeah. So this guy, normally someone breaking into his business, he would have had a legal presumption that he had a reasonable fear of deadly force harm from this guy. he loses that legal presumption because he was using the property for unlawful purposes. He doesn't lose self-defense, but he loses that legal presumption. And without it, it's a straight up self-defense analysis. And you shot an unarmed guy in the head. It doesn't look good.
That you couldn't see because he was outside the door or whatever. Or if you could see him, if he was outside a glass door and you aimed at the head and shot him, as he's, it just,
Why?
it does. Yeah, it doesn't look good. And it's important to note that all those things are presumptions. And even if you have those presumptions, they can still be overcome if the action is clearly unreasonable.
Right.
Fatal System Error says Aaron made an OBFU on this cross of Potter. Kenneth Slayer says, did these people learn nothing from Timothy Leary? You cannot outshrink the shrink. President-elect Four Doors More Horse says, Earl keeps Dante's mom from breaking down by keeping her to fact questions. Ms. Gremlin Harpy should take notes if she isn't fired after imploding. Yeah, that was a big difference. Earl had fact questions. He didn't make her revisit the death of her son. He didn't do any of that. Let the state do that. Let the state make her cry. And here it was the same thing with Potter. Samantha Heber says, how much education do lawyers get in law school on how to read people and their mannerisms? What, like this much?
Yeah.
Approximately. It's like police in situation training. You do your mock deposition and the person has a 2-page summary of who they are and all the facts that they're going to testify to. And you have you have a summary of the case, and then you try and elicit those facts out of the deposition. You get, I mean, it's all fake. You're not getting anything real out of anybody, and they're acting, and it's only the quality of the actors involved, which if you're not already an actor, law school isn't going to teach you to do that. So Samantha Heber says, wait, I read that one. Texas Sooner says, so are y'all as concerned about a hung jury in this trial as you were in the Rittenhouse trial? I feel like worst case scenario, the defense gets a hung jury. Best case is a not guilty vote. I mean, I think it's possible. I think it's going to be not guilty personally. I just don't see where the state gets there, but you never know with a jury. So Claire Fry says this prosecutor is Marsha Clark, the sequel. Drew says 2-hour max deliberations for not guilty on all counts. Brutus 53 says that's not acting. I have seen LeBron get hurt. Phoenix Lord Azerman says, teach me your Chad ways, O Sensei Earl Grey. New dislike button says, you can tell the judge wants Earl Grey to lay down his gavel on her sound block. Let's hook them up. Nick can stream the date in person. Stop it. Stop it. Jonas Wheel the Fourth says, cribbage gives me gas. Politics ruins all says, Kim Potter is just another incompetent quota hire. 26 years and no complaints means she never got into the mix much. That is a determination people might take from that.
I mean, how much into the mix is she going to get? 5'3" and a woman. I mean,
yeah,
you know, community relations work would seem much better suited to someone of that physique.
And it seems like, based on her testimony, that was her goals, right? That's her aspirational goals of police work: community outreach, peacefulness, negotiating crisis situations, which they didn't get into. They kept saying hostage. Even Earl Grey was saying hostage. What she's really doing is keeping people from killing themselves a lot of times, or de-escalating a domestic abuser, or maybe someone who's overly intoxicated. She's not normally going to be involved in situations that involve her being at personal risk. And if you noticed her response when she's like, so you're dealing with these high stress situations all the time, she's like, no, that's not her typical encounter in that type of environment. Other people's stress, yes. Her own stress, no. Her personal safety was likely not most of the time in question in those encounters. In traffic stops, yes, but not in those types of things. Chopper says, in addition to the jury instructions, are the jurors also allowed a copy of the statute that describes the charges levied? Usually, I think, yeah, they would be allowed access to the law itself. As a CPA, not knowing what the actual rules are would drive me insane. I mean, not that the statute's going to help you. There's so much interpretation in a manslaughter or murder statute through case law. But yeah, I think they are going to get that statutory language if they want it. Walter Dedman says,
I wouldn't want it. It's the law is not the statutes, folks. The law is the blending of the statutes and the case law. And that's what the jury instructions are intended to achieve, that blending, because the statute doesn't mean what it appears to mean. The statute means what the courts who interpret and apply that statute say it means. So a statutory language can actually be very misleading. It can It can just be wrong, a plain English reading of a statute, wrong legally speaking, because the courts have said it means something else. So I think the jury instructions are the way to go. There's the people who draft the jury instructions are trying to address that specific issue.
Yeah. Let's see. Walter Deadman says, has anyone made any dirty TNG references for Earl Grey and Judge ASMR yet? No, stop it. It's not Next Generation. Oh yeah. It is. Yeah. He drinks, Picard drinks Earl Grey. Also, Lord of the Porcelain Throne has now become king of the thermostat. JD Ski 892 says 14 inches. Dang, that's 7 Asian men. Oh, come on. JK the Slagger says jury gets handbrake on the laptop. Judge asks if they have returned a verdict. No, Your Honor, but check out these sweet memes we made. Not applicable says 14 inches, but non-functioning, to be precise. Andrew Rohn says Snapple fact of the day. Gray Bay on Lake Minnetonka is named for Earl Grey. Oh, hey, cool. Charles Argo says, Judge to Earl, love you long time watching all of you covering from South Africa. Hey, thanks. Shout out to South Africa. Hope everything's well for you. Music and Fiction says, I'm Earl Grey. Taste my tea, 14 inches. Jeremy Smith says, Your Honor, you know what they say about a man who makes large objections. Victor's Garage says, no nuh-uh, no uh-huh, and no for-us, please. Let's see. Z Michael Gelke says we need to make teabag the legal term. We have the power chat. Zeganfuss says, how long before Fox or other alphabet asks for a ride along on your channel for a high profile case? Yeah, who knows? Justin R says Drunk Bronca has changed the way I consume my legal information while falling asleep at night. Outlaw 2 says jury deliberation starts on the 20th. How the holidays impact their decision in favor of defense or prosecution, in your opinion? In favor of whoever has the most votes to start. I think that's the answer. Neil Pert says, if Potter equals guilty, no chance an officer is going to taser first for fear of this debacle going on. TLJ Screwjob says, speaking of cops, what about when Dr. Loomis and the sheriff killed Ben Tramer? Would they have been negligent since they did not know it wasn't Michael Myers? Dude, that's a bad police collision right there. Ben Tramer got done dirty. Mandrake says superseding cause like your ex poking a hole in the protective covering. Michael Fleming says Mystery Lawyer Theater 3000 the only way I can watch trials from now on. Bloody Blast says, what are your thoughts on the trucker getting sentenced to 110 years in prison for getting into a wreck that killed 4 people after his brakes failed? We talked about that earlier. Wilder's Honey says, I heart this entire panel, but I've been here for days neglecting my housewife duties. I'm a wrecked crackhead now, so I'll be later. Have fun, Wilder's Honey. You have the whole weekend. You can squeeze all of your housewife duties into a weekend. No problem. Poppycock says, if you want to test muscle memory, remove the toilet paper. Brendan Conway says, someone sent Richards a $27 chocolate meat hammer. What? Free Flyer. Oh, wait. By meat hammer, do you mean a chocolate penis? That'd be funny. Free Flyer says, I lived in Brooklyn Center when I was recruiting for the Navy, and I'm actually shocked she has not made more arrests involving using force higher than restraints or only pointing her taser. April Wine says, it's like working doing CPR on a mannequin, but when doing it in a real life situation, the scenarios are much different. Cruel Storm says, ask a special forces operator how much training they get before a deployment. It's a lot of time. Now send out police with little to no training. VSync says, action errors. Sadly, many resist applying technical and human factors, lessons from other industries, despite common factors. Researching how to solve this for critical safety critical applications and and engagement teams. Outnumbered Mom says, my thoughts and prayers will be with Miss Bronca on Monday. Please thank her for sharing her husband with us over the last weeks with trial coverage.
It's very kind.
Instructor Mike says USCCA or CCW safe. I think you typically would say the second one.
Between those two, lawofselfdefense.com/CCW safe.
Yeah,
get a discount.
I don't have any opinion on either because I haven't looked into it. Travis G says definitely judge F-bomb. So apparently the judge did drop the F-bomb, so that's good. Free Flyer says the black prospective juror. We're getting close to done here. The black prospective juror who had the wife going through chemo and was dismissed lucked out. This feels like a not guilty verdict in incoming riots. Clumsy Clairvoyant says, on day 9 of your stream video, go to time 4 hours, 48 minutes, 29 seconds. This is about an hour or two after you mentioned the email to Gray about the slowed down vid. Okay. I'm not going to do it live. I don't know what you're trying to get out of there, but I'll check it out later. A lemon sticker came from Cindy Sturgill. Thank you. Taylor Stagg says, Bronca, seems like you could set up a group of South Dakota lawyers you get a finder's fee for. No.
Oh, if I could get a finder's fee, I might make the effort to do it. But like Ty was saying, in Texas, they're not allowed to split fees. And I'm not putting major effort into a project that I'm not getting paid for. So,
yeah. Black Magic says Ty Beard is Alex Jones's second cousin. And before anybody harps on what Andrew just said, it's simply because of the amount of work that people like him have lined up. You can't spend your time on non-paying work because you have paying work that's there
right.
To do. It makes it very, very difficult. Daniel Harp says, Fluffer, Binger, shooting and missing in the court. Lunchbox is glistening. A beautiful sight. Kyle is free tonight. Walking in a free pew pew land. There you go. Eugene says, about Richards' box of chocolates he received, 14-inch objection made out of chocolate. Apparently it cost $27 with the message, suck on that. Oh, see, that's funny. Satoshi was a reptiloid, says, been fun seeing the development from Nick fanboying over the seemingly dry academic at lawofselfdefense.com to Bronca taking over the stream and talking guns with chat while Nick goes to the bathroom. Sound of one hand clapping says, Ty/Bronca favorite defensive ammo. Well, you're
I'm currently using Gold Dot 9mm for the carry gun. I can't remember if it's in the 124 grain or 140 grain range anymore. I haven't looked in a while.
I'm Stormin Mormon says Richards received a chocolate mail part and was told to eat through a straw on this. Why the censors YouTube? Music and Fiction says less mens rea, more Chris Rea. Hashtag work on it. Oh, okay. Kimberly Campbell says, couldn't they just say that she was having a blonde moment? Tony Yu says $5 for Die Hard. Warrior Biatch says people pushing for defunding should instead push for more money and more training is the biggest issue in law enforcement. Wolfgang Deo says, gotta love how the state expert CV was hearsay. Baron Sky says, it's funny to see how blue-pilled this trial has made Andrew. Andrew, is hair up or down more effective, little blue pill? Wait, what? Oh, little blue pill.
Judge Chu. She had her hair up the other day.
Yeah, that was hilarious. Crusader says, Allah guide the hand of the surgeon for your wife.
Thank you.
Satoshi with a reptiloid says, does a super chat afford ACP, attorney-client privilege? No. Wolfgang Deo says, defense expert is awesome. You are now manually breathing. EFC says, Dante Wright, just tase me, bro. Real quick, the reason the exchange of money doesn't establish an attorney-client relationship. Attorney-client relationships are established by both parties manifesting an intent to establish an attorney-client relationship and an expectation of the privileges that come with that. The end is near. Beware says, saw your crackers, Reese's treats the other night. Many things to try. So candy's nuts go into your mouth. Yes. Delicious. Shin Kakashi says, happy birthday, Nick and Andrew. Thank you.
Thank you.
Glenn Davis says, it's a difference between a cup of coffee and a half cup of coffee. Adventurers Guild says, did you see the mass orchestrated school shooting threats across the nation today through TikTok? Seems designed to instill fear of semi-autos. I did see that. I think it was yesterday. Angry Baneling says, American Andrew and Korean Andrew are fantastic guests, immensely enjoyable. Also, Andrew and Andrew stream when and on whose channel. That's up to them. JT, welcome to Super Lawyer Status. Avahine says, you should do a reenactment of the dating game killer trial. He defended and interrogated himself on the stand for 5 hours in court, different voices and all. Diego Machado says, could this accident have been avoided if our officers were issued guns with a manual safety instead of Glocks?
I doubt it. I mean, you just would have had an action error with the safety. So
yeah. Yep. Warrior B.
If you really shoot a gun with the safety, folks, the safety becomes completely intuitive. Precisely the kind of system one action that the expert witness was talking about.
Warrior Biatch says, when I was an LEO trainer, it was over 2,000 hours of training on your own before you become proficient in any new tactics. Few do this. Lord Vader says, the weapon chooses the cop. Potter. Blue-eyed Roof Korean says, check out the Bruce Gernon story. Flew full IMC under duress due to a weird green fog surrounding his plane from Bahamas to Florida. Aliens, probably. John Popham says, do lawyers get jury duty? And if yes, how often are they selected? Yes, and rarely. The Sultan of Zanzibar says, Melissa Eldridge, explain speaking in tongues. Also, Aaron Eldridge. Also, Epstein was not good at singing. He was always stuck in A minor. And finally, Bogey34 says, Nick, we listening to Richard's interview tonight with Bronca after dark? I don't know if you're up for anything like that. We can talk about it off stream, but we'll see. It's Friday, so I will be streaming tonight. And I'm not sure what the stream will be yet.
We can talk about it offline. It may be possible. I have to do my end of day right up here. That takes me an hour or so. And then I have, I think, a Christmas party to go to a couple houses down the street, but maybe I'll be lit as soon as I show up. You know, who knows?
It'd be 10 PM your time. But like I said, we'll talk about it off stream. I don't want to put you on the spot on anything like that. And that put me on the spot because I hadn't decided to do that either. So very, very racist of the chat from that. But we'll see what's going on tonight, guys. And thank you all for watching. Andrew, as always, thank you for joining me. If I don't see you before, best wishes for your wife on Monday. And you'll be welcome back whenever you have time. But please always attend to personal issues first. And with that, chat, we'll catch you later. Have a good night.
Take care.
Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of love broke. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have